2024. It's a Friday, and we are going to have a good day in the Judiciary Public Safety Committee today. We are a little bit short of a quorum, but we're going to start with our presentation. So we're going to start with Senate File 4782. This is a cannabis provisions modifications. We're going to hear from Senator Port, and then we will have council identify for us the provisions that are specifically within this committee's jurisdiction. Senator Port, nice to have you with us remotely this morning.
Good morning, Mr. Chair and members. Thank you for allowing me to present to your committee virtually. I'm happy to be here today to present Senate File 4782, the very first ever Office of Cannabis Management Agency bill. If you'll recall, last year we did historic work to start correcting the harms and failures of prohibition. Throughout the 2023 session, the bill was heard in 14 committees, took 65 amendments, and became one of the strongest cannabis laws in the nation. As I said then, and I continue to say, it will not be the last time the legislature hears a cannabis bill. Prohibition of alcohol ended nearly 100 years ago, and we still hear liquor bills every session. This newly legalized and regulated industry is in its infancy, and we're here to continue the work that we started last year. In partnership with the brand new Office of Cannabis Management, this bill improves and streamlines the licensing process and supply chain. It strengthens our social equity goals, accelerates the transition of enforcement infrastructure and resources, and it expands protections for medical patients. I will hold off on reading the portions of this committee's jurisdiction and let council take that, but happy to plug in with that afterwards. I do have the A15 amendment, Mr. Chair. The A15 amendment addresses the technical data issues around the transfer of medical cannabis from MDH to OCM, and it makes further technical changes recommended by the revisor's office.
All right, members, we are going to be handing packets out today as each bill is called so that there's room on our desks. You have the Senate File 4782 third engrossment at your desk. You also have the A15 amendment at your desk. Are there any questions about the content of the A15 amendment before we take action on that?
We do have a quorum, yes.
Okay.
So we can say
And we do have a quorum present for the record, so we can act as a committee now. Senator Limmer.
Thank you, Mr. Chair. Just as review, could we have council tell us what areas are in our jurisdiction on this bill?
Before we do that, Senator Limmer, I'd like to address the A15 amendment, and then we will go ahead and do that. Any questions about the A15 amendment or commentary on that? Not seeing any. Senator Westlin moves adoption of the A15 amendment. All those in favor say aye.
Aye.
Aye. Opposed? Motion prevails. The amendment is adopted. Ms. Primo, could you please identify for us what provisions within Senate File 4782 are within the jurisdiction of the Judiciary Committee?
Mr. Chair and members, the bill makes several technical or clarifying changes within statutes that are within our jurisdiction. I am going to point out the ones that make substantive changes. However, if there are questions about any of the technical clarifying pieces, I can stand for those questions. Section 21 on page 22. Section 57 on page 57. Section 60 on page 58. Section 130 on page 108, as well as the amendment that was just adopted by the committee.
All right, Senator Port, do you have anything further you'd like to say, or do you have any testifiers that you'd like us to hear from?
Yeah, thank you, Mr. Chair. I would like to pass it now to OCM Interim Director Charlene Briner, who will have some deeper insight into the agency recommendations, and then she and her staff are here to answer questions as well.
All right, thank you, Senator Port. We're going to try to keep our testimony focused only on the provisions before this committee's jurisdiction. So, Director Briner, welcome to the Judiciary Committee. If you go ahead and identify your name and your affiliation for the record, and tell us what you'd like us to hear about those provisions.
Thank you, Mr. Chair, and thank you, Senator Port. It is a pleasure to be here this morning. For the record, my name is Charlene Briner, and I'm currently serving as the Interim Director of Minnesota's Office of Cannabis Management. We appreciate the opportunity to be in front of the committee this morning to speak specifically to the provisions that fall under your jurisdiction, and I will do my best to be as brief and succinct as possible while offering you the context you need to consider our bill. We have used two primary lenses as we have started the process of turning the words on the page into practice and policy. We use two primary lenses to develop our recommendations this year. What do we need to launch well and in a timely manner, and what do we need to do to regulate effectively over time, all in service of creating a safe, accessible, equitable, and well-regulated cannabis market? I'll be focusing my presentation this morning on OCM's recommendations that do fall under the purview of this committee, which you can see in front of you. Our proposals relating to this committee are summarized in three major buckets, and I will spend a little bit of time on each one: the technical changes to the office, changes to the office structure, and expansion of protections for medical patients and medical program modifications. The first bucket of proposals is intended to support our goal of implementing well, meaning how do we operationalize Chapter 342, build effective processes, and hold license holders to high standards of compliance. That's why we propose these modifications in the background check process outlined in Chapter 342. Currently, OCM would be responsible for managing all of the background check processes for every prospective cannabis worker in every business across the state, which could equate to thousands of background checks for the office to complete. We propose instead maintaining the requirement for prospective workers to undergo background checks, but we separate that process, the review of those checks, into two categories. The office would be responsible for all licensees and leadership positions for those license applicants conducting those background checks, while the BCA would work with license holders to conduct those background checks on cannabis workers. Additionally, we propose modifying the language to outline high-level offenses that show a history of the exploitation of people or financial systems as disqualifiers for application licenses. This clarification allows for the appropriate authority for these decisions and will help ensure that operators are held to high standards of regulatory and operating compliance. Finally, in addition to utilizing the information that is part of the criminal background checks, we recommend changes to allow OCM to utilize applicants' civil regulatory history to inform our licensing decisions. The second group of changes apply to our office structure. Current law plans for the transfer of the Office of Medical Cannabis from the Department of Health to occur on March 1st of 2025. OCM is recommending accelerating this transition, including the transfer of the temporary hemp-derived enforcement that currently sits with MDH to OCM on July 1st, 2024, along with transition of the medical program. These changes will result in earlier integration of staff and program activities, help with consistency enforcement, and help OCM continue to build out its operational and foundational capacity. This transition requires a transfer of employees and relevant data between MDH and OCM and is reflected in the language you see. Finally, expansion of protections and medical program modifications are the third category of changes. As we've developed these proposals, one of our guiding lenses has been to maintain and enhance the medical program to support patients' access to high-quality, affordable products to treat and alleviate symptoms. That's why the bill includes provisions to enhance the program. Each of these provisions are informed by feedback from the medical medical cannabis registry community of patients and caregivers. And the proposals include expanding current protections for patients to all persons enrolled in the medical registry program, including caregivers, parents, and other people in the registry, and also modifying patient supply limits to ensure patients who have differing medical needs have access to the medicines they depend on. That concludes the high-level summary of those proposals, and I will turn it back to you, Mr. Chair and Senator Port, and am available to take questions.
Thank you, Director Briner. Any questions from members of the committee for the director? Anyone else in the room wish to testify in connection with these provisions? Not seeing any. Any discussion from members of the committee? Senator Limmer.
Thank you, Mr. Chair. I'd like to introduce the A20 amendment.
Okay, members, that amendment will be distributed by staff. While that's happening, Senator Limmer, why don't you describe what your amendment is
Yes,
intended
thank
to
you,
accomplish?
Mr. Chair. My apologies, Senator Port. I did not have an opportunity to speak with her about the amendment, but it was posted yesterday. This is in reference to the age of a minor using marijuana, and this is modeled after the alcohol prohibitions of minors using alcohol. It's modeled after that. It addresses the use of cannabis by a person under 21 years of age. That it would be a misdemeanor for a person to unlawfully use cannabis flower products, etc. It may be prosecuted either in the jurisdiction where the use occurs or where the evidence of the use is observed. It also addresses the possession of cannabis by a person under 21 years, claiming it's a misdemeanor for a person to unlawfully possess any amount up to 4 ounces, any amount up to 2 pounds of cannabis flower in the person's residence, any amount up to 16 grams of cannabis concentrate or edible cannabis products, in any amount up to 1,600 milligrams. The effective date is August 1st. And there is a reference, or a definition reference, juvenile controlled substance offense is slightly changed to adjust to this if it becomes a statute. I'll stand for questions, Mr. Chair.
Thank you, Senator Limmer. Senator Port, would you like to respond?
Yes, thank you, Madam Chair. Senator Limmer, thank you. For 2 reasons, members, I'm going to ask for a no vote today on this amendment. The first is that while this is certainly a cannabis bill that touches a lot of different pieces, this is the agency's first bill. And as I have asked members throughout the year, this is really a bill focused on the regulation, the regulatory system, and the agency's sort of technical necessities. I think all other bills about cannabis really deserve to be heard fully in committees, in all the committees that they touch, and deserve that full conversation. I don't believe that this bill is a place, and we've tried very hard to keep it not the place, where changes to the sort of meaning and structure of the law that we passed last year would live. Secondly, the prohibition of cannabis has historically been incredibly disproportionately enforced. And we know that from years and years of history and data that primarily communities of color, especially young Black men, are prosecuted much more significantly for possession and use of cannabis than white counterparts. We were very clear in the bill that we passed last year that the strongest penalties that we put in the bill were for the sale to minors. We continue to believe that that is the best way to address that, and by having a strong regulated market that is able to remove as much of the illicit market as possible. I continue to be against criminalizing for kids, for young people, something that will perpetuate the school to prison pipeline and that we know will be disproportionately enforced based on all the history and data that we have.
Thank you, Senator Port. Is there any other discussion on the amendment? Senator Limmer.
Thank you, Madam Chair. I'm somewhat surprised this bill being described as the first agency bill, and yet we do not establish certain parameters of the use of marijuana, especially with juveniles. Many have said that although we have decriminalized the use of recreational marijuana in this state, just like alcohol, it can be misused, it can be dangerous by those who would use it to an extreme measure, or certainly the references of it being a gateway drug for some individuals. That experimentation would happen during a childhood if they're involved in this type of activity. And quite honestly, I think we should have some kind of sanction where the court may enforce the law if there's sizable abuse. Many times we put criminal sanctions in to limit or define or deter behavior, and this would be one of those tools to be used. Otherwise, I think we're going to find, especially minors, abusing the use of marijuana that are under the age of 21. I would hope that the committee would recognize the need for a rather minor application of criminal law to this misuse of the product.
Senator Westlin.
Just very briefly, the parameters around use and so forth were actually part of the bill that was passed last year. Again, this is an agency bill, and any discussion about criminal sanctions or anything would not properly be in this bill. I also just want to say also that what we do know for a fact is that criminalizing addictive behavior doesn't work, and that is not what we should be about.
Senator Kroon.
Thank you, Mr. Chair. This is a question for the author, or maybe council. I'm just trying to understand the amendment better. In the current bill, are the penalties that are at issue in this amendment, are they petty misdemeanors, or are there no penalties at all currently?
Mr. Backus.
Mr. Chair and Senator Kroon, my understanding is under current law, a person under 21 years of age may not either use, possess, or transport cannabis. That's under 342.09. But there's no penalty specifically applicable to that. So I think because it's phrased as a prohibition, I believe that the petty misdemeanor catch-all under Chapter 645 would likely apply. So I think that there is a petty misdemeanor. I don't know if that was specifically discussed last year, but I think that's the result of prohibiting something without specifying a penalty, which last year's bill did not.
Senator Kroon.
Thank you, Mr. Chair, and thank you, Mr. Backus, for that answer. So as I'm understanding this from council, there's no specific penalty in the cannabis bill itself. The catch-all could make underage possession a petty misdemeanor, and all this amendment would do that we're presenting, that Senator Limmer presented, is put a specific penalty in the cannabis bill and make it a misdemeanor rather than relying on the catch-all petty misdemeanor, which in my view is abundantly reasonable. I believe these are the same penalties that we have for underage minors with alcohol. I have no idea why we would treat marijuana differently than alcohol for underage possession. And I understand this is an agency bill, but there's absolutely no reason we can't put it in here and rectify this situation today, right now. So I certainly support the amendment.
Any further discussion on the 820 amendment?
Roll call, Mr. Chair.
There'll be a roll call. Senator Limmer moves the adoption of the 820 amendment. Clerk will take the roll.
Chair Latz,
No.
Senator Verbaeten,
No.
Senator Limmer,
Yes?
Senator Carlson,
No.
Senator Eichhorn, Senator Howe,
Aye.
Senator Kroon,
Yes.
Senator Pappas, Senator Seeberger,
No.
Senator Westlin,
No.
Senator Eichhorn, Senator Pappas,
There being 3 in favor, 5 opposed, the amendment is not adopted. Any further discussion on the Senate File 4782? Senator Kroon.
Thank you, Mr. Chair. My question is relating to page 58, lines 58.13 to 58.15. It looks like to me the current law disqualifies any applicant for a cannabis license based on a felony conviction, but now it looks like we're adding to that with including but not limited to language in line 58.13. And I guess my question is the intent of this this additional language, is the implication that not all felony convictions are now going to be disqualifying?
Mr. Backus.
Mr. Chair, members, I think the office can speak to it more explicitly perhaps, but I guess the way I read current law is that the office may, by rule, determine whether any felony conviction shall disqualify a person, and that this language basically says the office may, by rule, determine whether any felony convictions, including but not limited to these. So I guess the way I looked at this wasn't necessarily a substantive change. I think it's just, for whatever reason, it's choosing to highlight some of the convictions that could disqualify a person, but that it would be up to the office to do this via rule either way.
Senator Kroon.
Thank you, Mr. Chair and Council. Yeah, I see the word may in line 58.12 now, so I think your explanation makes sense. However, when you add the including but not limited to, which that language is always problematic in my view from a legal standpoint, or usually problematic, I think what you're doing, and you can correct me if I'm wrong, and I don't want to put words in your mouth, but you're setting up a situation here where these are the specific felonies that you're going to be looking for, and you kind of are creating a statutory basis for if it's a felony that's not in this list, that it likely won't be disqualifying, but maybe you can elaborate on that.
Any further discussion on Senate File 4782? I'm not seeing any. The appropriate motion here would be to refer this bill to the Commerce Committee. Senator Westlin moves that Senate File 4782 as amended be recommended to pass and be re-referred to the Senate Committee on Commerce. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, members. Thank you, Director Briner.
Thank you, Mr. Chair.
All right, members, the next Senate file is 1745. Senator Murphy, who is on her way. Ah, here she is. Perfect. The bill and the staff summary is being distributed to the members. Senator Murphy, welcome to the Judiciary and Public Safety Committee.
Good morning, Mr. Chair and members. Thank you so much for making time for me this morning on 1745.
Why don't you go ahead and tell us about your bill, especially if there's any provisions that are specifically within this committee's jurisdiction, or Ms. Primo, is the whole bill in our jurisdiction? Why don't we hear a basic presentation from Senator Murphy about what the bill intends to do, and then we'll focus in on our provisions. Senator Murphy.
Thank you, Mr. Chair and members. Senate File 1745 is legislation creating a healthcare commission that will help Minnesotans, with the help of Minnesotans, understand and make more transparent to policymakers what we're experiencing in the healthcare system today as it is consolidating and leaving parts of Minnesota without access to care. This is legislation that I've actually been working on for a number of years, and I am really grateful that the legislature is moving it this year. On page 9 of the legislation before you, subdivision 13 deals with data classification, and that is what brings us to the hearing today.
Ms. Primo, anything else to add regarding committee jurisdiction? Not seeing anything. Okay. Senator Murphy, do you have any testifiers that you wish to present in connection with this question?
Mr. Chair and members, I do not have testifiers. I think you would see, if you look at the language, that we are just conforming with current law, making sure that the data is private and non-public according to statute, as this commission would be dealing with information coming from different facets of the healthcare system.
Anyone else in the room wish to testify in connection with this bill and the data provision? Any discussion from members of the committee? Where does this bill go from here? Rules. Going to your committee, Senator Murphy. Senator Carlson. Oh, wait. I don't know. Okay, just to be clear, the Rules Committee needs to hear the bill on the merits. It's not going there because it's late or anything like that, is what I'm informed. So the appropriate motion then from Senator Carlson is that Senate File 1745 be recommended to pass and be re-referred to the Senate Committee on Rules. All those in favor say aye.
So moved.
Aye.
Aye.
Opposed? Motion prevails. Thank you, Senator Murphy.
Thank you so much for making time, Mr. Chair and members. Have a great hearing.
You're welcome to join us back here around 4 o'clock if you wish.
I may stop in. I'm a big fan of hardworking groups. Thank you.
Members, next item on the agenda, Senator Mohamed, Senate File 2026. And we are going to have Senator Mohamed joining us virtually. Members, the packet is being distributed. Senator Mohamed is not able to join us at the moment, so we're going to change our next item on the agenda. We're going to see which senator is available. One moment, please. Members, next item on the agenda is Senate File 3900, Senator Seeberger. Staff will pass out the packet. Members, this is the first committee hearing this bill. There is an A2 amendment. That would be an author's amendment. Senator Seeberger moves adoption of the A2 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Seeberger, tell us about your bill.
Thank you, Mr. Chair. It is my honor to be here before the Judiciary Committee on Senate File number 3900, which provides a mechanism for the mapping of schools in the case of an emergency. When first responders show up on the scene of particularly a school, knowing where to go, what the hallways are called, where they need to go makes all the difference in time responding to an emergency. If we think of not just medical emergencies, but in the event of an active shooter, when time is a factor and law enforcement or rescue personnel need to get to the exact location as soon as possible, knowing beforehand where to go would make all the difference. This bill appropriates $7 million from the revenue fund, special revenue fund for 911 emergency telecommunications, provides for an RFP process to go out to have vendors come in and map these schools, and then integrates the mapping with the software used by different agencies so that our rescue personnel know exactly where to go when they need to be there. To be clear, this allocation does not come from the general fund, it comes from 911 special revenue fund, and it is considered a permissible use of such resources. The amendment that you see before you is the product of ongoing discussion that has been occurring on this bill. And discussion continues to occur in order to get this bill in a shape that the best shape it can possibly be. So I'm optimistic we're going to get there. Let's see. I have two testifiers, I believe, who are ready to testify, and I will let them explain it a little more, if that's okay with you, Mr. Chair.
All right, Senator Seeberger, I have Dan, is it Craigie? I don't see Dan Craigie coming forward. Jeff Potts from the Chiefs of Police Association. Chief, welcome to the Judiciary Committee. Go ahead and identify yourself for the record, please.
Thank you, Mr. Chair. Jay Henthorn, Chief of Police, City of Richfield.
Go ahead and present us with your testimony.
I am here today on behalf of the Minnesota Chiefs of Police Association, who represent more than 300 police chiefs across the state and over 150 command staff members. We would like to thank Senator Seeberger for bringing this bill forward, as we feel there's a need for this type of legislation. Sadly, there were nearly 350 school shootings in the U.S. in 2023. Whenever these incidents happen, law enforcement responds to the scene. These are very chaotic and dangerous situations where every second can be the difference between life and death for students, staff, and first responders. These maps can help save precious seconds as officers respond in an attempt to stop the armed intruders. Officers are not always familiar with the floor plans of schools. When speed is of the essence to stop the intruder, we must be able to know the layout quickly, as it is sometimes difficult to locate the intruders. Having responded to a school shooting in my own community in February of 2022, I know how important it is to responding officers, medical personnel, and additional resources to know the school layout during one of the most unimaginable critical incidents to happen to a community. When life safety is key, this legislation will give first responders the advantage to resolve the incident quickly. For these reasons, the Minnesota Chiefs of Police Association supports Senate File 3900. Thank you for your time today and allowing me to testify.
Thank you, Chief. We'll let you sit there for a second so Chief Potts can get a cameo. All right.
Thank you. Thank you very much.
We have Ben Galnick, I believe, is online also. Mr. Galnick, welcome to the committee. Go ahead and identify yourself and present your testimony. You are, there we go. Now we can hear you.
Are we good now? Sorry, guys.
Go ahead.
Thank you. Thank you, Chair Latz. Thank you, members of the Judiciary Committee. My name is Ben Golnick. I'm speaking on behalf of Critical Response Group, CRG. For purposes of introduction, CRG is composed of relevant practitioners and has mapped over 14,000 schools nationwide. We've worked closely with legislative bodies to ensure public safety professionals have access to accurate school mapping information during an emergency. We're opposed to Senate File 3900, but applaud your efforts to introduce school mapping legislation. CRG provided feedback on the original bill and are pleased a few recommendations are incorporated into the author's amendment. However, we believe this bill is intended to benefit a specific vendor, and this is a cause for concern. Based on our extensive experience, there are still several serious issues. First, while it is important to include the regional communication boards, they should not be driving the process as the bill suggests. No other state that has passed mapping legislation has empowered 911 boards in this manner. We believe funds should go to schools to work with local law enforcement to obtain maps that work for that specific public safety community. To date, school groups in Minnesota have not been consulted, and we believe this is a critical error. Second, line 1.30 provides broad authority to the statewide communications board to, quote, implement further requirements at their discretion, quote. The board should not have such autonomy. No other state has given the 911 board the ability to make additional requirements. We suggest requiring that school districts must collaborate with local public safety agencies to ensure school mapping meets all requirements. Lastly, we believe it should be required and mandatory to do walkthroughs of schools, even schools that have not changed physically. As you know, rooms at schools are often relocated, and more often than not, existing maps of schools are not accurate, with new entry points, renamed rooms, etc. Every state has incorporated this requirement. We thank Senator Seeberger for her willingness to engage in meaningful discussions with people most conversant with the problem the bill is intended to address. It is our hope that in the coming days, lawmakers, first responders, DPS, school groups, and all interested vendors will meet to make improvements to the bill. Thank you.
Thank you, Mr. Golnick. Appreciate your testimony today. Just members, so you know, this is a 911 fund fiscal impact, which that's within this committee's jurisdiction. So the intent will be to lay this bill over for possible inclusion in our budget bill, which we'll be putting together next week. So there will be time, and I know Senator Seeberger is always interested in trying to work with stakeholders and see what can be accomplished. I also suspect that if this were to, if there were another source of funds that were hoped for here, it might not go anywhere this year because funds are pretty limited. So there might be a practical aspect to this side of it as well. We'll let Senator Seeberger sort that out. We'll ask again if Dan Craigie is present to testify. Mr. Craigie, come on forward and present your testimony as well.
Good morning, Mr. Chair and members. My name is Dan Craigie, and I just ran over here, so apologize. I'm breathing a little roughly here. I serve as the director for GeoCom. We are a St. Cloud-based safety and security GIS company. Previously, I had served actually as the deputy director at the Emergency Communication Networks Division here in Minnesota. I was managing our statewide 911 network, statewide radio system, as well as directing efforts for our emergency alerts and public safety broadband network. In addition, I spent 5 years working in public schools in a variety of roles. Here to provide testimony in support of Senate File 3900, as well as answer any questions that the committee may bring. As referenced, schools are very complex structures. First responders don't always know the exact location of emergency or even what door to enter in. We do know that 911 caller location accuracy from schools now provides room-level accuracy. However, the vast majority of 911 centers in the state, and really public safety at large, do not have the ability to combine that accurate 911 caller location information with an indoor map of the school. In some cases, paper maps do exist, or the school has shared maybe a PDF or a floor plan with public safety, but getting to that information is difficult. By building an interoperable digital indoor map, public safety can easily see the location of emergency within a school, so much so that a 911 telecommunicator could share the room, floor, or even door to enter in for the first responder. Along with that, important details such as locations of AEDs or hazardous materials could be shared. An indoor map for schools reduces the response time for first responders and increases the chances of a positive outcome during times of an emergency. While the primary purpose is very much related to public safety and integration into 911, the data can be used for several other school-related functions, such as facility management, space planning, visitor management, et cetera. As it's been referenced, the funds being used are from the 911 Special Revenue Fund, which are statutorily required to be used for purposes related to 911 operations, either at the state, regional, or local level. In the building of the indoor maps in a GIS format is an authorized use of the funds. And with that, I conclude my testimony.
Thank you, Mr. Craigie. Any questions from members of the committee? Mr. Craigie. I know you just ran over here, but for having run from St. Cloud, you're looking pretty settled down here. Senator Cron.
Thank you, Mr. Chair. What's the, and this could be for, I don't know if Ben Golnick is still on, for either one of you, I'm trying to figure out the benefits or to appropriating the money to the regional communications board versus directly to the school, and why one is preferable to the other. And if either one of you can comment and help me understand that better, I'd appreciate it.
Chair Latz.
Seeberger or Mr. Craigie?
Representative Kuhn.
Mr. Craigie.
There's a few reasons. One, existing Minnesota statutes 403 reference that any funds collected, so everyone here pays a fee on their wireline wireless device, that gets into a 911 special revenue fund. The statute says that any of those funds being used shall be used for 911 operations. So just within the statute, there's not a pathway to share it with schools. So that's just a very practical sense. In addition, the FCC monitors how that 911 fee is spent. And if they see those funds going to any jurisdiction, organization other than a 911 fund, the state of Minnesota may be ineligible for future federal grants as it relates to 911. So those two reasons in particular, it makes sense for this funding to go to the regional emergency communications boards who have that authority.
Senator Cron.
Thank you, Mr. Chair. I don't know if Ben Golnick is still on the line. I think, looks like he's got his hand raised. If I could hear his response, that'd be helpful, I think.
Mr. Golnick.
Yes, hi, thank you, Senator Kroon, thank you, Chair Latz. My understanding from a conversation with the Department of Public Safety is it would be workable with these funds to award grants to schools and have those schools saved by the Department of Public Safety or the School Safety Center. And that's what we've pushed for, is because we believe people closest to the maps, the schools, who unfortunately have not been consulted, that they should be involved in this process as they have been in every other state. And again, if we think we have talks with the group, as Senator Seeberger mentioned, we think we may be able to get to some resolution on that. But we absolutely think, like every state in the country's done it, we should have this money go to the schools and the school districts.
Senator Kroon.
Thank you, Mr. Chair. You mentioned the school safety centers. It seems like this would be squarely within the purview of that office as well. And I don't know the legalities of it, maybe if I'm understanding this, because the money in this bill is coming from the 911 fund, there may be some limitations on how the money is distributed. I'm not quite sure on the legalities of that, but it does seem like the safety office should be part of this, it seems like. And I guess maybe this is a question for the chief author, but have the schools been consulted on this? The School Board Association or any of those various groups, have they had a chance to weigh in and what their thoughts are?
Thank you,
Senator
Mr. Chair. Thank you, Senator Kroon. It's my understanding that, yes, they have been a part of this discussion. Some stakeholders have had greater involvement in the discussion than others, but this bill has been out there and pending for at least the last 6 weeks. It hasn't just come about within the last week or so. So those folks have had an opportunity to weigh in and express their concerns. And I will note that I have had conversations with our witness here appearing remotely. I have had conversations with many of the stakeholders involved. And, as you know, sometimes not everybody's happy with the way a bill is drafted. And we work on amendments that try to get at various issues and make the bill better and not favor one vendor over another vendor. And really get at what the heart of the bill is here. So yes, stakeholders have been consulted. Is everybody happy with the end result? No. Is that unusual? No. Will I continue to work with the stakeholders and try to make this bill better? Absolutely.
Thank you, Mr. Chair. And maybe the bill's been out there for a while. I'd feel a little bit better if there was affirmative dialogue with the School Board Association and some other education groups. Just so I know if one of these models is better than another, and what the schools think. Obviously, they're not here. I don't think this bill, maybe it should, but I'm sure it's not going to be traveling through any of the education committees. But if we're dealing directly with school safety, it seems to me I would love to have some representative from the schools giving us some insight on what they think about it, whether or not they had an opportunity to know about it or when they got involved. My next question is, there is a compatibility piece in here, and that I'm not a technologically savvy person, so this is something I'm relying on other people to explain to me, but obviously compatibility is very important, and there is a compatibility piece here. But I know when I was on the school board, should be careful here what I say, but we used a certain vendor for our school security systems. I don't want to say it by name because I'm not sure I'm supposed to, but what assurance does this bill provide that a school district who's already using certain security software, that at the end of the result, that whatever data that comes from this is compatible with that? And then the follow-up question is there going to be any expenses to the school district relating to that in terms of leasing or licensing or any other expenses that the schools would have to bear?
Senator Seeberger.
Thank you, Mr. Chair. Senator Kroon, as to the second part of your question, the intent here is not to impose any kind of unfunded mandates on the school. The intent is to use the 911 funds to fund this process entirely. As to the first part of your question with regard to compatibility, the bill doesn't speak either way, whether or call out any particular system. To me, any vendor who came in and wanted to provide this service would have to ensure that whatever the product is would have to work for the particular school system. So that would be an issue specific to the process that I think is inappropriate to contain within the bill itself.
Senator Kroon.
Thank you, Mr. Chair. And I do see the compatibility language. I'm just concerned that, compatibility, is it possible to be compatible? Is it compatible from a technical sense? I'm looking for a more expansive definition of compatible, meaning that free to the schools. And I appreciate your comment about no more unfunded mandates, and that's exactly where I'm going on this. even if it's technically compatible, if the schools have to pay any money to have access to that compatible data, I think that would be very problematic from my standpoint. And so as you're talking to the groups, that's something I would be very keyed in on, to make sure that that data that is not only compatible but free to the schools. That's part of that. And then my next question is, I heard some testimony about walkthroughs on the schools. What's the important, and this could be for any of the competing vendors, how important is a walkthrough of a school, and what in this bill is going to assure that walkthroughs, if you think they are important, that they actually happen through this bill?
Senator Seaberger.
Thank you, Chair Latz. Senator Kroon. Yes, I've had many discussions with CRG about the importance of walkthroughs. And it is important, obviously, if you map a building, that you map it accurately. And therefore, at the time of mapping, you should know what you're mapping and not rely on outdated blueprints or other drawings that may or may not be accurate with respect to the school. I've also had conversations about sometimes hallways are called different things, different terminology by those that work in the school. For example, I think the example was the kindergarten hallway that was used. And in a time of stress, the staff is going to say there was an incident or a shooting in the kindergarten hallway. And if that's labeled as such on the map, that's a useful tool so that first responders respond to the kindergarten hallway as identified and not just the east wing or whatever. So yes, I understand that, and that's all important, and that is information that would be useful and probably should be contained on a map. And it sounds to me like CRG does that. I have not had an in-depth conversation with GeoCom whether they do that, but certainly that's important. I will note that Senator Howe, who has his hand up, and I have been discussing another amendment that I think addresses some of those concerns and which I'm inclined to accept. So maybe we get to those concerns a little bit later on when Senator Howe has an opportunity to weigh in with his thoughts.
Senator Kroon.
Thank you, Mr. Chair. I do have one more question that I can think of, but if I would yield to Senator Howe, or looks like we have two hands up, so I'll wait until after the amendment process to ask my final, well, what could be my final question. Thanks.
Senator Howe. By the way, Senator Kroon, I noticed that last qualification there. But it went in one ear and out the other, so you're Senator Howe, go ahead.
Thank you, Mr. Chair, and thank you, Senator Seaberger. I do agree that this is an important piece that we need to be looking at as I've dealt with this in numerous capacities in my past. But before I go down that road, could Mr. Turner maybe answer a couple questions for me, whether he believes this use is whether this use and or maybe the purchase or grants of radios are an approved use of this fund, if Mr. Turner can comment on that.
Yeah, Senator Howe, whether it's a good use is a policy decision that, whether it's a lawful use, perhaps.
Yes.
Or an approved use might be within fiscal staff's purview. Mr. Turner,
yes, Mr. Chair. My bad on proper language. Thank you. Approved use.
I'm protecting Mr. Turner here.
Mr. Chairman and members, I spoke with the Department of Public Safety. They said that this mapping project is an eligible use of the 911E funds. The second question that Senator Howe asked was whether or not local end-use local public radios was an eligible use. And I think that there's an ambiguity on whether or not those are. In the past, we've only funded them with general fund monies. I have heard, but it hasn't been confirmed, that the feds have declared local radio purchases as eligible. but I haven't confirmed that. And those were the two uses that you asked, right, Senator Howe?
Senator Howe,
Yes.
follow up.
Yes. So, thank you, Mr. Turner, and thank you, Mr. Chair. You know, and this is, I guess my point is this is great stuff to do, to map, but with all the mapping, it's great stuff, but when the incident occurs, the piece that we all have had the problems in the past is if you don't have radios to talk to one another at the scene, at the local level, none of this great information, even the backbone of the armor, doesn't make any difference if you don't have the technology in the end user's hand to be able to communicate with one another. So, Mr. Chair, on another bill, we talked about trying to find a fund to actually make this available. That's how I got to here. But, you know, in the past, in my past life, I was required to do pre-fire plans, which identified the fire department connection location, the fire alarm panel, the annunciator panels, the AEDs, the corrosive cabinets, the flammable liquids cabinets, fire access doors, emergency doors, and all of that good stuff. And I had a rudimentary program to do that with. And the problems with it that we found is what I was using, we're just kind of discussing this compatibility issue, is the program I was using was not compatible really with the programs and the program that they had on the scene. It was great in the dispatch office, did not work so great at the scene, nor was it compatible with the police department nor the school. So that compatibility process is huge. But with that, Mr. Chair, and as I've talked with Senator Seeberger, I'll offer the A6 amendment.
Senator Howe offers the A6 amendment. Staff will distribute it. Senator Howe, why don't you tell us what your amendment proposes to do?
Thank you, Mr. Chair. And it basically requires an request for proposal process. It basically says the data is owned by the school district and available to law enforcement, and requires a walkthrough, and basically talks about where the money goes. So and the process. So it just kind of identifies, clarifies a little bit about where the money would go, how the process of the RFP goes, and it's basically clarifying language. And I believe the discussions with Senator Seeberger that we may be able to alleviate some of the discussion between the two vendors and maybe make this a more open process and get the bill moved forward.
Senator Seeberger, your position on the A6 amendment.
Thank you, Mr. Chair, and thank you, Senator Howe, for having these discussions with me. I appreciate your input. And having had the opportunity to take a look at this and to clarify some of the issues that actually Senator Howe brought to my attention, irrespective of the particular vendors at issue here, I'm inclined to accept the A6 as a friendly amendment.
Is there any further discussion on the A6 amendment? Senator Howe moves the adoption of the A6 amendment. All those in favor say aye.
Aye.
Opposed?
Aye.
Motion prevails. Amendment's adopted. Any further discussion on the Senate file as amended? Senator Limmer.
Thank you, Mr. Chair. As I was looking at the bill's language, I wanted to bring our attention to line 28, page 1, line 28. There you find the words perpetually available. I don't usually see that in statute. And could someone tell me what that means?
Forever. council want to weigh in further on that? Senator Seeberger.
Thank you, Mr. Chair. Thank you, Senator Limmer. I think the notion here is that the data is always available to the schools. Can't be withheld. They get to use it.
So, Mr. Chair,
Senator Limmer.
Senator Seeberger, so it does not mean that we will perpetually fund the mapping of school buildings into the future. Is that what you're saying?
Senator Seeberger.
That is correct. Senator Limmer, if I could invite your attention to line 1.8. This speaks to a one-time appropriation only available to June 30th of 2026.
So, Mr. Chair.
Senator Limmer.
It's perpetually available until the money runs out. Is that what we're saying?
Senator Limmer, line 1.18 refers to the data created is perpetually available.
Okay. Thank you. I did have another question or a comment.
Senator Limmer.
I know that 911 funds that we were established, I believe the bonding is completely finished now. This is asking for $7 million to be a pinch of that taken out of that fund. And yet I know that that fund is, it's got a lot of competition for projects in it. And one of the more, the louder voices for the use of that fund is our armor radio modifications and improvements. Very costly program, but one that's absolutely necessary to make sure that law enforcement and other public safety entities can talk to one another, especially during a time of extreme emergency. I'm just wondering, is this going to be, well, maybe Mr. Turner could tell me more on the financial end of it. Is this going to curtail any commitment that we've made toward the armor radio program?
Mr. Turner.
Mr. Chairman and members, right now we've got an available balance in the 911E fund of approximately $42 million a year. The fund is comprised of the revenue from the telephone service fee that we all pay on land and cell lines. It's currently 80 cents per line per month. It's statutorily capped at 95 cents per line. 2 years ago, the governor, after the state paid off the bonds that built out the armor system, the revenue bonds, the governor, and we no longer had that as an expense, the governor lowered the fee from 95 cents to 80 cents. Senator Limmer's correct in that there's a lot of competing claims for these funds. One of them, which has come up over and over again, is the local radios, the end-use radios. It hasn't been determined, at least I haven't been able to get to the bottom of whether or not that's an eligible use for the fund. I have a feeling that it may be after the revenue bonds were paid off. But that aside, and that is an accumulated need of people have been banding around $250 million, which is an amazing amount of money, seeing as how the service fee only brings in $69 million a year. I think on the horizon, we have next generation 911 is going to be developed and deployed. We have maintenance on the armor infrastructure, as Senator Limmer pointed out. We've got a need for increased funding of the 103 PSAPs across the state. There's a lot of claims on this money. But that said, we do have $40 million that we're carrying as an available balance. This bill is $7 million. And it's up to the committee to decide how they want to spend it.
Senator Limmer.
Mr. Chair, we do not have the public safety judiciary, the Judiciary Public Safety budget bill before us at this time.
Next week, Senator.
Do we have, in the preliminary plan, are we directing any money to address the armor radio program seems to be in dire need right now? I know that there's senators that have talked to me about in rural Minnesota where a Senate district that represents 3 or 4 or more counties cannot talk to one another from one county to another, and that's today. And so I was just wondering, as we try and balance this $7 million here with the available funds, are we moving in the direction of modernizing and updating the armor system, especially in those areas that can't communicate with one another?
Mr. Turner, do you have any knowledge to answer that question? I mean, all I can say is we'll consider all of our budget matters next week. This bill will be laid over for possible inclusion and further discussion on that question. And it may be appropriate for us to include some proposed study language in that bill, asking some agency or somebody to take a broader look at the questions Mr. Turner just described in terms of long-term costs for armor and local radios and other potential demands on this 911 fund, and see if the revenue streams under the current structure will be enough to meet. I doubt we'll be making those final decisions next week, however. Mr. Turner, anything further to add?
Just this, Mr. Chairman and members. I think that next year, as being a funding year, and the rapidity with which this technology is moving, I foresee a fairly large push for next generation funding using the 911 fee. And I also foresee a recodification of Chapter 403, which is the Public Safety Communications chapter. It came through last year, but the various parties who are very passionate could not agree, and we dropped it. I see next year a lot of movement in this area from both the governor and from the legislature and from the players involved.
So, Senator Limmer, if you're interested, I'd encourage you to work with council and Mr. Turner to draft an amendment for the budget bill next week that maybe would light a fire under this analysis so that when we come back next January, we're in a more educated position to make some long-term decisions about that. We'll have some individual requests to deal with next week, a couple of individual appropriations requests, and whether or not we want to honor those or leave them for a longer-term process, so we'll have to figure that out. Any further discussion on Senate File 3900 as amended at this time? Senator Kroon.
Thank you, Mr. Chair. Senator Howe's amendment took care of my final remaining question, so I don't have any more questions. Thanks.
Great to hear, Senator Kroon. Any further discussion? I don't see any. Senate File 3900 will be laid over for possible inclusion in this committee's budget bill next week. Members, Senator Gustafson is present now. We're going to go to Senate File 44. Oh, where'd she go? Do we have Senator Mohamed available yet? Yes, do we have Senator Mohamed available yet? Okay, we're going to take a brief pause to wait for Senator Gustafson. Senator Gustafson. All right, members, we're going to take up Senate File 4413. The bill and staff memo has been distributed to members. There's also some correspondence in your packet from Violence Free Minnesota. This bill comes to us as the first committee. There is an A1 amendment, which would be in the nature of an author's amendment. Although I'm told maybe that's not requested now by the author. Is that correct, Senator Gustafson?
That's correct. Thank you, Mr. Chair.
All right, members, recycle your A1 amendment. Senator Gustafson, tell us about your bill.
Thank you, Chair Latz and committee members. SF 4413 is not just a modification of existing statutes, but a significant step towards ensuring safety for victims of abuse and harassment. Under current law, when someone who causes harm is released from confinement and placed on probation or parole, the victim survivor who needs the OFP for their safety and security must locate the abusive party's address in order to have service completed. This puts the victim survivor, whose goal in part in obtaining the order of protection is to avoid contact with that abusive party, and now they're in the position of having to hunt down an address for this individual. This imposes both the tangible burden of investigating the abuser and emotional burden of having to potentially interact with them or their family and friends. Additionally, even when the victim or survivor has best known address for the abusive party can still make attempts to avoid service. In this scenario, the victim survivor needs to file additional paperwork and attend additional hearings to complete service by alternative means. And the multi-layered process, of course, imposes extra burdens upon those who are victims and survivors. So simply, it simplifies the current legal framework by consolidating service requirements into clear, unified sections, and will make it easier for law enforcement to do their job. Allows for electronic or mail service of orders in cases where respondents participate in hearings remotely, ensuring that they are informed of the orders against them in a timely manner. It encourages cooperation between various law enforcement and corrections agencies to facilitate the efficient location and service of respondents. Establishes a task force to review and improve legal framework around surrender of firearms in domestic violence cases. And this bill is needed to address inadequacies of the current system, which leaves victims vulnerable due to delays and inefficiencies in serving protective orders. So thank you for your time and consideration. Again, you will see that letter of support that the chair pointed out to you from Violence Free Minnesota. And I believe we have some testifiers in the order that you see fit.
Senator Gustafson, we've had two testifiers sign up, Megan Walsh and David Lamb. If both of you would come forward, please, and have a seat at the table. Members, the plan is to lay this bill over for possible inclusion. Ms. Walsh, I have you listed as first. Please go ahead, identify yourself for the record, and present your testimony.
Thank you, Mr. Chair, Senator Gustafson, and members of the committee. My name is Megan Walsh. I am a visiting assistant clinical professor of law at the Minnesota Law School. I serve as a director of the Gun Violence Prevention Law Clinic, and my academic research and courses are focused on the Second Amendment, with a special focus on the intersection of firearms and domestic violence. I'm joined here today by my student, third-year student, David Lamb, who will be joining me in testifying today.
Welcome. Please go ahead and present your testimony.
Thank you. In 2014, through bipartisan work and a bipartisan vote, Minnesota amended certain domestic violence statutes to require domestic abusers to surrender their firearms. These include individuals who are subject to domestic violence orders for protection, have been convicted of domestic assault, stalking, or harassment, and are already prohibited by state and federal law from possessing firearms. These amendments requiring surrender and, in cases of imminent risk, seizure by law enforcement are intended to help implement those laws that are already in place. I'm here to support the task force that is being recommended by Senator Gustafson, and I'm joined by my student, David Lamb, who will be testifying about the work that our clinic has done to support this bill.
Mr. Lamb, welcome to the Judiciary Committee. Go ahead and state your name and your affiliation and present your testimony as well.
Thank you, Mr. Chair. My name is David Lamb, and I am a student at the University of Minnesota Law School. For more than a year, under the direction of Megan Walsh, I've researched how we can stop domestic abusers from hurting and killing people. The violence that Minnesotans witnessed in Burnsville in February was heartbreaking. And as outrageous as it was, this triple homicide was hardly anomalous. 2/3 of mass shootings are linked to domestic violence, and women are 5 times more likely to be killed by their abusers when those abusers have access to guns. In light of these grave realities, Minnesota's bipartisan laws require domestic abusers to surrender their firearms. But failures in implementing these laws have far too often left guns in the hands of domestic violence offenders. The team of law students that I have helped lead researched the barriers to enforcing Minnesota's gun surrender laws, and we analyzed how we can address these barriers in order to save lives. We interviewed dozens of experts and public servants involved in the gun surrender process, everyone from domestic violence researchers to law enforcement personnel, advocates for survivors, family court judges and staff attorneys, and others. We analyzed Minnesota's framework for disarming abusers, as well as the processes in other jurisdictions that have improved their gun surrender rates. Our team identified a range of solutions. They include a process that clarifies each law enforcement agency's role in implementing gun surrender orders, judicial forms that ensure that courts don't overlook guns that are in the hands of abusers, and education programs aimed at those who prosecute, defend against, and adjudicate domestic violence crimes. We also identified key stakeholders who have the insight and the authority to address the barriers that we found. This bill would create a task force that brings together each of these stakeholders. 3 decades ago, Minnesota legislators passed the first laws in the state requiring abusers to give up their guns. It was a promise that Minnesota would use its power to protect domestic violence survivors. The time has come to fulfill that promise and to pass this bill.
Okay, so members, I appreciate the testimony from the professor and from Mr. Lamb. Sounds like there's a great need for some follow-up, but I also get the impression that a task force would create a fiscal note and would take this to another committee and might create an insurmountable barrier to moving the bill forward on the merits this year. So, Senator Gustafson, to that question?
Yeah, thank you, Mr. Chair, for giving me a moment to clarify that. It is something that came to us as a late amendment from the House, so we did not have time to consider it or ask for the fiscal note. So at this time, we're leaving the task force piece off of it. That does not mean that it is wrong to bring it up today, because it is something that has ongoing conversations. But as a late amendment, it was something we were able to put together over here in time, so for later consideration.
So, Senator Gustafson, you wish to hold off on considering that as a part of today's hearing, is that right?
Yes, thank you, Mr. Chair.
But, okay, well, we may at some point see it again.
Yes.
Possibly. Well, without that amendment, is there a fiscal impact or fiscal note relating to this bill? Mr. Turner?
Mr. Chairman, no. We were only concerned about the amendment, the task force.
All right, so then we could take action on the bill independently, or we could consider whether to add the bill to this committee's omnibus policy bill. So let's see if there's anyone else that wishes to testify in connection with the bill. And please, if it's connected to the task force, we do not have time for that testimony, only on the underlying merits of the bill that came to this committee. All right, if you go ahead and identify yourself for the record and present your testimony, please.
Thank you. My name is Elsa Swenson. I'm the community-based advocate serving domestic violence victims. I'm here to speak about the service portion of the bill, not the task force. So I testify in support of Senate File 4413 because I have seen and believe in the power of protection orders to interrupt violence in our community. However, protection order without enforcement is simply a piece of paper, and people who use violence know this and are emboldened when violations go unenforced. Lack of proper service is one of the biggest reasons violations are not or cannot be enforced. Senate File 4413 makes two important changes to how service of protection orders is effectuated. The first change comes from lessons we learned during the COVID-19 pandemic. When hearings went remote at the height of the 2020 lockdown, the usual practice of personally serving a respondent with continuance orders or orders following a hearing prior to them leaving the courthouse, of course, became impossible, and orders were sent to sheriff's departments for personal service. If violations occurred after the remote hearing, but before the respondent was personally served, law enforcement data showed the order as unserved and therefore would not enforce the order. A case I personally worked on took 3 months to serve the respondent following the remote evidentiary hearing, and despite the respondent being present when the judge determined domestic abuse had occurred and an order for protection would issue, my client's reports of violations went unanswered, and the power of the court was undermined, all because the respondent successfully avoided service of an order that he knew existed. Understandably, my client was frustrated and questioned the point of seeking an order for protection at all. Senate File 4413 allows for service electronically or by first-class mail in situations where the respondent is present and aware that an order for protection is going to be issued, allowing the protection order to be fully enforceable immediately upon the issuance following a remote hearing. Petitioners and respondents both overwhelmingly report preferring remote hearings. The proposed change does not decrease access to justice for the respondent or change their right to contest a protection order. It simply prevents them from having to be personally served by law enforcement more than once and closes a gap in the service process. The second change, as outlined in Violence Free Minnesota's letter of support, clarifies the service process for respondents who are on supervision while simultaneously easing the burden of survivors through increased communication among system players, which survivors expect system players to communicate, and this change simply makes clear the duties of the system to work together. I appreciate the opportunity to speak to these important issues. Thank you.
Thank you for your testimony. Is there any discussion from members of the committee? Senator Westlin.
Thank you so much for bringing this bill, Senator Gustafson. This often is a problem where individuals show up at hearings that are now often by Zoom. When these hearings appeared in person, people were told to wait and receive the order before they left the premises. And surprisingly enough, or not surprisingly enough, there are people out there who make efforts to avoid service in many types of cases. So I think that this makes sense to allow for alternate service without having to make an additional motion, and takes the burden off of the survivor of the domestic violence to try to make sure the service is effectuated. And I won't say much more about the task force other than to say I'm really sorry it's not happening. There is a problem this is a problem. I know for a fact that there is no verification mechanism to ensure that people who are supposed to turn over their firearms have actually done so. So anything I can do to help with that in the future, I'd be happy to.
Mr. Chair, I would, if it's okay.
Senator Gustafson, yes.
I would just say that as far as the task force goes, I do think that it is something that will likely happen, or at least for sure will be brought up again. I think we're just waiting to make sure that it's either happens in a budget year or, that we have the funds to support it. So thank you.
And I would echo Senator Westland's support and Senator Gustafson's support for addressing the concerns that the task force would be designed to address. However, is the most effective way to get there. Any further discussion, members of the committee? Senator Kroon.
Thank you, Mr. Chair. Thank you, Senator Gustafson, for bringing this bill. On the task force piece, certainly supportive of that when the funds are available for it. But I would like to bring you back to last year with Senate File 2496, which I'm carrying and you're a co-author on, that does address specifically some of these things. One of them in particular, which is a compliance hearing with the court after one of these orders to remove firearms have been issued, just to make sure that it's actually happening and giving the courts the requirement to do that, and also then could hold somebody in contempt of court if they haven't complied. And I guess my question then is, why do you think we need a task force to at least implement that part of, I guess, that safety component and that compliance piece? Why do we need a task force to do that?
Well, members, we're having a lot of talk about a task force that's not a part of this bill, and we have a lot of bills on the
Mr.
agenda
Chair?
today, so maybe we can take 30 seconds and then move on.
Mr. Chair,
Senator Crum.
it's the question, if the task force isn't needed, then that's a different discussion than what's included in the task force, I guess would be my clarifying point.
Senator Gustafson.
Mr. Chair, Senator Cruen, and thank you for including me on 2496. I will review it and look at it again. I would just say that the firearm surrender laws, and to be able to appropriately review those firearm surrender laws, it's needed to address the gaps and inconsistencies, especially when we come to domestic violence and sexual assault. A task force is needed. I think it's a great idea. I hope it goes forward. We're just, we're in a policy year, and so we're just being very mindful with those dollars. But it is something that needs to be addressed. The firearms and domestic violence, unfortunately, far too much go along with each other, and often the crimes are connected. So, thank you.
We have had compliance hearing proposals in the past, and I shudder to recall the fiscal note from the courts that would be required to come back and have a hearing on every domestic violence sentencing that they impose a week later. The courts are clogged up enough right now. There's got to be a better way to enforce compliance than requiring a hearing on every sentencing that happens in the court. Senator Cruen.
Thank you, Mr. Chair. And yeah, there may be a fiscal note associated with that. I think it's worthwhile nevertheless. And also, the question was whether a task force is needed, not necessarily the fiscal note implications for including that. But one final comment, and then I'll end. Also, to let Senator Gustafson know, I do have Senate File 5017, which actually expands this to all crimes of violence, all felony crimes of violence, that would, if the person is not immediately turned over to the Department of Corrections, it would require them to transfer their firearms within 3 days and then also have a compliance hearing within 7. So that's another thing out there. I don't like to wait for the task force, but I appreciate you bringing this bill forward. Thanks.
Any further discussion on Senate File 4413? Senator Gustafson, we're going to lay it over, and when we turn back to our omnibus policy bill, if you'd like, we consider including it by amending that into the policy.
I would appreciate that. Thank you, Mr. Chair.
All right. Senate File 4413 is laid over. Senator Gustafson, which of your other bills would you prefer that we take up next?
Senator Latz, or Chair Latz, I'm sorry. We have another one about SA, so we could continue on that, or we could, I've got a pile.
Can you give us a Senate file number? Is that 4952?
Yes, Senate File 4952, Mr. Chair.
All right. Staff are distributing it. Members, this is the first stop for this bill. There is an A1 amendment. Senator Gustafson, do you wish us to adopt the A1 author's amendment?
Yes, Mr. Chair, thank you.
All right. Senator Carlson moves adoption of the A1 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Gustafson, tell us about your bill.
Thank you, Mr. Chair and committee members. SF 4952 establishes multiple permissible venues for prosecuting criminal sexual conduct cases. It represents a change in our legal system, especially in how we support and protect survivors of sexual crimes. The bill is more than a procedural amendment. It is a commitment to the rights of individuals who are mentally incapacitated or physically helpless due to being asleep or unconscious at the time of the offense. By allowing these cases to be prosecuted in the county where the crime occurred, we are prioritizing the victim's needs and reducing their trauma, ensuring that justice is both accessible and sensitive to their circumstances. The bill introduces flexibility in choosing the prosecution venue for cases of criminal sexual conduct. It caters specifically to victims who are mentally incapacitated or physically helpless, providing them with a more considerate legal process. It's designed to streamline the judicial process, making it more efficient and centered around the survivor. And by permitting legal action in the victims or incidents county, the bill reduces logistical barriers and potential re-traumatization of the survivor. Thank you for your consideration. We do have a testifier when you're ready, Mr. Chair.
Thank you. Members, ma'am, if you would go ahead and identify yourself for the record and present us with your testimony.
Good morning, Mr. Chair, members of the committee. My name is Karen Kugler. I'm a prosecutor with the Ramsey County Attorney's Office. I've practiced law for over 30 years, focusing much of my career on sexual assault cases, and I'm here in support of Senate File 4952. I currently hold a specialty position within my office working with a multidisciplinary team on sexual assault cases. Almost every case involving an adult perpetrator who's suspected of sexual assault goes by my desk for charging considerations, so I've seen a lot. In the work that I do, I've seen serious sexual assault cases that we have not been able to charge because the victim is mentally incapacitated or physically helpless and unable to state where the crime occurred. Thus, we cannot establish venue, which is a critical element of the crime. In some cases, I've been able to proceed with charges on circumstantial evidence. On many cases, we can't do that because we don't even have enough with respect to circumstantial evidence. Recently, I've had cases involving victims who have been drugged, rendered unconscious, and have woken up to find themselves hospitalized and that they have been sexually assaulted. One victim found herself intubated recently. Doctors discovered that she had a lethal amount of GHB, a known date rape drug, in her system. The last message that she sent to her sister before going unconscious was, "I think he's trying to get vagina, but that is not happening." Sadly, she was wrong. The sister of another victim flagged down an ambulance as she was rushing the victim to the hospital after finding her out of it, drooling with crazy-looking pupils and bruising on her neck, legs, back, and chest. She had been in Minneapolis and in St. Paul the night before. The GPS on her phone gets her to the area of 280, but we cannot identify where the sexual assault in her case occurred. We don't know if it's Hennepin County or if it's Ramsey County. She lives in Ramsey. She was in Hennepin. We don't know where the date rape drug in her case was given to her, so we cannot charge the case because we can't establish venue. DNA was discovered from vaginal swabs in both cases. We know who the perpetrator was. In the first case, the intubated case, I went forward with charging on circumstantial evidence for venue, but the open question lingers. In the second case, we can't charge it. Frighteningly, the same perpetrator gave both victims the GHB in those cases. Senate File 4952 corrects the void left by the current statutory language. It provides for physically helpless and mentally incapacitated victims who are blameless victims of sexual predators. They deserve justice, and this allows it. I ask that you pass the bill as written. Thank you.
Thank you, Ms. Kugler, for your testimony. Maybe you can answer a clarifying question for me. Does the bill make any substantive changes to the definition of physically helpless?
It does not.
Thank you. Any questions, Senator Pappas?
Mr. Chairman, did we adopt the A1 amendment?
Yes, we
We
did.
did. Sorry. When you're ready, I can move the bill when you're ready.
Thank you, Ms. Kugler. Anyone else in the room wish to testify in connection with this bill? Any further discussion from members of the committee? Senator Pappas, there is no cost to this, so this is a bill which might be considered for adding to our omnibus policy bill later today. So it was my anticipation to lay it over for possible inclusion.
Okay.
All right, seeing no further discussion, Senate File 4952 as amended is laid over for possible inclusion. Thank you.
Thank you so much.
Okay, are we gonna? Mr. Turner, you had asked for an opportunity to give us some additional information on Senator Seeberger's Senate File 3900 that we were discussing earlier. Mr. Turner.
Yes, Mr. Chairman and members.
Senator Seeberger. Mr. Turner has something to add relating to an earlier bill of yours.
The question came up when we were discussing your bill, whether or not grants for radios are purchased by local law enforcement are 911E eligible. And the Department of Public Safety must be watching because they answered the question in an email. Are grants for radios purchased by local law enforcement 911 eligible? No, they are not. In order for this to be an eligible expense from the state government special revenue fund for 911 emergency telecommunications services, only PSAP radio consoles connected to and compatible with the Armor system are eligible. 911 dollars cannot be used for subscriber equipment. In simple terms, if the radios would be in the PSAP, they would be eligible. If they are for outside the 911 center, they are not eligible. And I will take this as policy set in stone because this is question has been asked numerous times in the last 3 years, and I appreciate the DPS getting back to us.
All right, Mr. Turner, did DPS indicate whether that is a function of state statute or federal law or both?
Mr. Chairman, it's part of the federal guidelines.
So we couldn't change that if we wanted to, is that what?
I believe that's
guidance is?
correct.
All right. Senator Limmer.
Thank you, Mr. Chair. Mr. Turner, when it talks about the end unit or the end user, can the infrastructure be eligible for the funding? Usually there's quite a bit of computer work and other things. Is that, or is it just the radio you hold in your hand as the end unit?
Mr. Turner.
And Mr. Chair, I don't want to delay the committee either. We can take this discussion offline as well.
Let's do that.
Yes, Mr. Chairman. I believe a good portion of the infrastructure is eligible. It would be not a good use of our time to go into that right now.
Okay. Thank you.
Wise advice, Mr. Turner. Senator Limmer, I encourage you to follow up offline. All right, Senator Gustafson. What bill would you like to hear next?
Mr. Chair, 4057.
All right, Senate File 4057 is before the committee and will be distributed to the members. Members, there is an A1 amendment. This is the first committee on this bill. The author's amendment, Senator Gustafson, do you wish to have it adopted?
Yes, Mr. Chair, thank you.
Senator Pappas moves adoption of the A1 author's amendment. All those in favor say aye.
Aye.
Aye. Opposed? Motion prevails. The amendment is adopted. Senator Gustafson, tell us about your bill.
Thank you, Chair Latz and committee members. 4057 is talks about fire dampers. Fire dampers are critically important to prevent fire, heat, and smoke from spreading to different areas of a building through the HVAC system. It's important not only for the health and safety of individuals who work, live, or occupy a building in fire distress, but also to preserve and maintain valuable infrastructure. Without a properly installed and regularly inspected fire and smoke damper, a building's HVAC ductwork can quickly circulate harmful smoke and toxins, putting building inhabitants at risk. According to the National Fire Protection Association, most fire deaths are the result of smoke inhalation rather than burns, with death certificates for fire-related incidents demonstrating 2-to-1 ratio of smoke inhalation burns. 53% of fire dampers in existing buildings need repairs. This bill would essentially make sure that all fire dampers are up to code. I do have a testifier who is able to talk a little bit about the amendment, the definitions that were necessary in that amendment to make the bill whole, and we are ready whenever you are, Mr. Chair.
Thank you, Senator Gustafson, and I'm going to make kind of a general statement here as well. We have a long agenda, and I'm happy to spend what time is necessary on details that need to be vetted before the committee. But for those that don't, especially if there isn't any dispute over things, if our testifiers could be very succinct and not go into enormous detail about language amendments. If the committee has any questions, they've got the materials in front of us. We can take a look at it and follow up with questions. That said, if you go ahead and identify yourself for the record, sir, and tell us what your testimony is.
Chair Latz and committee members, my name is Colin Beery. I handle government affairs for the Sheet Metal Workers Local 10. We cover all of Minnesota, North Dakota, and South Dakota, representing about 5,000 members, predominantly in the HVAC industry. We are here to speak in support of Senate File 4057. And to most, when we start with fire damper, they say, what is that? Fire dampers have been around for decades now. They are required by existing code to be installed into HVAC ventilation systems as a fire life safety device. To be clear, there's a good chance many of these are being installed at this moment throughout the state of Minnesota. As an individual myself that has installed countless fire dampers in the field, these are dynamic devices that not only need to be installed properly, but must be tested and maintained over time. They're mechanical. If you don't put oil into a car, it breaks down. Same premise around these devices. Senate File 4057 will strengthen the already existing standards and codes with a program that makes sure these life-saving devices are taken care of by qualified individuals, clear documentation of work performed, and provide the local AHJs the authority to make sure the buildings in their communities are safe as possible. Local 10 would respectfully ask for the committee's support on Senate File 4057, and we would graciously like to thank Senator Gustafson for leading in the space of fire life safety. I will stand for questioning.
Thank you, Mr. Beery. We also have signed up John Kornstrom.
If I may,
Mr. Beery.
Chair, John Kornstrom did sign up. He is the CEO of our Contractors Association. He is currently in negotiations, bargaining a unit with us. We saw the calendar and assumed that we could make it happen today, and we got moved up, so apologies for any inconvenience that may have.
No problem. I appreciate that, Mr. Beery, and I would assume his testimony would be supportive of what you've already presented to the committee.
Yes.
Is that fair to say?
Yes.
All right. Thank you. Anyone else in the room want to be heard in connection with this bill? We'll open it up for committee discussion. Any members of the committee? Senator Limmer.
Mr. Chairman, what is the jurisdiction portions in this bill? It seems like a lot of labor, technical information in this bill. I was just wondering what is our focus?
Mr. Backus.
Sorry about that. Mr. Chair, members, I think the entire bill is within our jurisdiction. Chapter 299F is one of quote-unquote our chapters. Whether or not any other committees have jurisdiction, I couldn't say at this point.
Any further discussion on Senate File 4057?
Mr. Chair.
Senator Howe.
Thank you, Mr. Chair. Senator Gustafson, has the Department of Labor and Industry been contacted and have they weighed in on this bill?
Senator Gustafson.
Mr. Chair, Senator Howe, not to my knowledge.
It's the fire code. It's the fire chief.
Senator Howe.
Mr. Chair? Thank you, Mr. Chair. And keep in mind, usually what we do is we enforce the building code and the mechanical code, and usually when there's, and especially in the fire code, if there's something that needs to be tested, it usually goes through that code development process where you have public input and you go through that rulemaking process. To me, it's great that we're looking at inspecting these things and testing them, but usually the authority having jurisdiction already has that authority to require that. I don't see where we have to write legislation to make this happen. The other piece is more importantly than this is keep in mind, we do not currently have statewide licensing for HVAC contractors. And I remember being on the governor's technical advisory group on this very topic of licensing HVAC contractors statewide. I wrote the decision for the governor, and 20 years later, we still do not have statewide licensing for HVAC contractors. You've got Billy Bob's pretty good HVAC contractor putting in gas lines and everything else out here. So certain cities have requirements and licensing, but we don't have that statewide. I would think that would be much more important to get right before we go down the road of this, because I absolutely believe, because I enforce this through the fire code currently. When we come across the fire damper, and keep in mind, some of these fire dampers, once you cut the link and drop it, you've got to replace the link. It's not, you've got these smoke fire dampers that are tied to a smoke detector that can be reset with the resetting of the fire alarm system. But Mr. Chair and Senator Gustafson, I believe that the code development process is the right place to take this. I do not believe the legislature is the right place to bring these types of requirements. And I think we should give this to the Department of Labor and Industry, their Construction Codes and Standard Division, and let them, if this is an important piece, let them go through the code development process and put that with the code officials that have the expertise, knowledge to make this happen and do it appropriately. Thank you, Mr. Chair.
Senator Gustafson, any response?
Yeah, Mr. Chair, thank you, Senator Howe. I'm actually going to defer to my testifier who can answer all those questions.
Mr. Beery.
Could you clarify the question?
Senator Howe.
Thank you, Mr. Chair. Why isn't this in the code development process instead of here at the legislature? Isn't this usually done and with the code development process in the construction codes and standards division?
Mr. Beery.
Chair, Senator, first off, we fully believe in the code system here in the Minnesota and participate in it. To the bill and the program that we are trying to establish, this does not change any code, adopt new code. This only utilizes the language within NFPA around testing and maintenance of fire dampers. There is no new upgrades of code inside of this program.
All right, members, we have received advice that this may need to go to State Government Committee as well because there's rulemaking that's authorized in here, just FYI. And also a fiscal note has been requested. Senator Limmer.
Thank you, Mr. Chair. I think Senator Howe is making a good observation. I remember back in 2020 the energy code was modified by the legislature alone. And many of them, with good intention, thought that if a little insulation is good in a residential wall, a lot more will be even better. And then sealing up the wall with vinyl and making sure that it was airtight. That was legislators coming to the idea that they could modify building code. And we all remember the consequence of that. Walls were molding out and quite a considerable expense on homeowners. Litigation was created against builders, and the builders were simply saying, we're following the law. We had government-approved inspectors check off and approve that construction. And it really stemmed back to the legislature thinking that they knew more about building codes than the experts. And so Senator Howe is making a pretty good point that there are experts in the labor and trade organizations in the Department of, I think it's Dolly, and they review all of these things anyway. So I would advise caution and let the experts that are assigned to this type of work to give recommendation.
Senator Gustafson.
Mr. Chair, Senator Limmer, thank you, and thank you for bringing your concerns. I would say that we do have an expert with us here who is talking about how this is needed. I'll remind you that with more and more people living in multifamily housing and schools and hospitals, 53% of fire dampers existing need repairs. We're going to need to do something more than just recommend, that this happens just on the labor side. We need to enforce it. This isn't about the initial installation piece of it. This is making sure that they are continue to stay up to code and that they are checked for needed repairs. So two different things, but if you need more clarification, happy to defer to my testifier. Thank you, Mr. Chair.
Any further discussion on Senate File 4057? So the appropriate motion here would be to move that Senate File 4057 as amended be recommended to pass and be re-referred to the State Government Committee. Senator Pappas makes that motion. All those in favor say aye.
Aye.
Opposed? Motion prevails. All right. Senator Gustafson, Senate File 3920. Members, the material will be distributed to you.
Thank you, Mr. Chair. Would you like me to wait until everything is handed out?
No, you can go ahead and describe your bill. Just to note, there is an amendment in the packet, but this is not an author's amendment. This comes to us from the Commerce Committee. Senator Gustafson.
Thank you, Mr. Chair, members of the committee. If you've ever joined a gym, a month-to-month cell phone plan, or a dating app, you've probably experienced the pit of despair that comes from trying to cancel your membership. The difficulty of quitting a membership or subscription service is a high-end problem designed to be a high-end problem. Companies want your money, they want to keep your money, and they know all too well that you are busy and often unable to jump through hoops to save $20 a month. Companies have discovered that the subscription industry is extremely lucrative, about $1.5 trillion. And it's not a bad thing, but leaving a subscription service is cumbersome and confusing, and that's on purpose. Consumers are likely to spend hundreds of dollars a year in subscriptions they no longer want but don't have the time to cancel, and that's the point. So, for example, a gym membership are notoriously hard to quit. The contracts are drafted in such a way as to not allow a person to quit without suffering a penalty, or the process requires written communication, sometimes even requiring a notarized letter to cancel the membership, all while the process to join the service in the first place takes only seconds. Another popular version of the subscription industry is allowing customers to sign up for a service with a few clicks of a button, but then forcing them to call a 1-800 number with long wait times to cancel or even mail cancellation requests to a physical address. Sometimes those physical addresses change often, and the letters are then returned to sender, leaving you still subscribed to a service you no longer want. What this bill does is provide more transparency, fairness, and flexibility when canceling a service or membership. This bill seeks to empower consumers with greater control over their memberships and subscriptions. We have met with several stakeholders. We have made changes necessary to protect businesses. This bill still is working, and that's why you see the updated amendment. But it is a good bill. It is a consumer protection bill. It is needed and popular. Thank you, Mr. Chair.
All right, members, this bill comes to us from Commerce. Council advises that the entire bill is within our jurisdiction as it's a contract-related issue. The anticipation here is that the bill will be laid over, that the Commerce Committee intends to include it in its omnibus bill. But any amendments that we make would be incorporated into the Commerce Committee's bill. So let's take some testimony. We have 2 people have signed up, and then we'll consider the A12 amendment. I have Eric Linseth and Susan Sheely have both signed up to testify. If you're present, both of you, come on forward, please. I have Mr. Linseth first on my list, but I don't care who goes first, so that's between the 2 of you.
Eric, do you want to go first?
All right.
Sure, I can
Mr.
go
Linseth,
first.
go ahead and identify yourself and your affiliation. And
Thank you,
provide your
Chairman
testimony.
Latz. My name is Eric Linseth. I'm the General Counsel at Lifetime. I was a former civil enforcement lawyer with Mike Hatch at the Attorney General's office, and that's the last time I testified before the Judiciary Committee, so it's good to be back. Lifetime operates health clubs throughout the United States. We have 171 clubs. In the United States, we have 25 here in Minnesota. We started in 1992. We've always been a homegrown company, and we've never used long-term contracts at all. We always use month-to-month agreements. And so I guess I would take issue with Senator Gustafson's representation that it's the pit of despair to be able to cancel a lifetime contract. It's a rolling 30-day cancellation. You don't need to send any notarized statement to us. All you need to do is just send us something in writing.
I think she's talking about a lowercase L.
Perhaps. Perhaps.
Mr. Linseth.
We're grateful that Senator Gustafson has met with us and made a few changes to the bill. There's still some things that are concerning to us. Among the things that Senator Gustafson has changed is she has built in a window to process terminations, which we're grateful for, an ability to confirm the identity of consumers who are canceling, because obviously you need to be able to make sure you're talking to the right person, allowing us to offer some ways to be able to maintain a membership with a person who would like to cancel. Often when someone leaves Lifetime, they would want to put their membership on hold and still continue to have fitness content that we can deliver to them. And we'd like to be able to do that, in part because 50% of our members at Lifetime are actually returning members, and I think the proof is in the pudding there. You can see that we're not mistreating any consumers when so many of them come back to Lifetime. And the last thing that this senator agreed to is to remove a private right of action from this bill. There's still a little bit of work, I guess, in our mind. There was originally a good faith compliance defense that was included in it. And we think that that makes sense because there are a number of judgment calls that need to be made in the current bill as it exists. The main testimony that I wanted to offer today relates to revisions that were introduced to the Health Club Contracts Act. Originally, when Senator Gustafson introduced this bill, it was really focused on automatic renewal and continuous service agreements. I'm actually not aware of any Minnesota companies that don't utilize those kinds of agreements, right? That just utilize standard term contracts that don't renew or aren't paid for on a continuous basis. And so I was surprised to see that there are changes now proposed to the Health Club Contracts Act that do not square with the auto renewal and continuous service provisions. So I think, number one, those would be unnecessary because annual health club contracts that do not automatically renew do not carry the same concerns that Senator Gustafson raised. Number two, some of the standards are conflicting. I'll just give an example, and my colleague Susan will give another example. The amendments to the Health Club Contracts Act require that a health club has to build an online message portal to be able to take online messages, whereas the current language in the continuous service and auto renewal bill only require online cancellation if the club actually or the seller actually sells memberships online, which makes sense. There's a marriage between sales of contracts online and cancellation of contracts online. That doesn't exist in the amendments to the Health Club Contracts Act. And then the other thing I wanted to point out is the Health Club Contracts Act was adopted in 1974, and it includes a provision in it that is essentially a statutorily prescribed notice to consumers to allow them to cancel their membership after 3 days. It's basically a 3-day free look. And that made some sense in 1974 when every contract was in paper and it was duplicate. Remember the duplicate forms, the multicolored forms? Well, we've moved way beyond that, and I think that the legislature should not be in the business of prescribing language in a statute that needs to be included in a contract. And that's what the Health Club Contracts changes do. They add 2 more paragraphs to that statutorily prescribed notice that has to be included now in contracts in 14-point bold text. And some of the language that is included isn't even particularly consumer friendly. And it also requires disclosure in the contract in verbatim language of various ways to cancel, like a toll-free number, an email address, a website. Those things change over time. And so we would submit that it makes more sense, and we would really like to continue working with the author to be able to create a principle like the one that is found in the continuous service and automatic renewal provisions that simply says a seller has to disclose the cancellation options in a clear and conspicuous way. Create a principle as opposed to particular language that is, required to be disclosed in a verbatim way, 14-point bold font. So we would hope that the author, Senator Gustafson, would continue to be able to work with our industry in particular and all of the others who are concerned about this particular bill. Thank you.
Thank you, Mr. Linseth. Ms. Shealy.
Thank you. Good morning, Chairman Latz and members of the Judiciary Committee. My name is Susan Shealy. I am Deputy General Counsel for Self-Esteem Brands. Self-Esteem Brands is the parent company for 3 fitness brands. We franchise a number of brands, but 3 of them are fitness related. Our biggest is Anytime Fitness, homegrown here in Minnesota. We also have the Bar Method and Base Camp Fitness. Self-Esteem Brands is headquartered here in Woodbury, Minnesota, and I'm here advocating on behalf of the 140 franchised Anytime Fitness clubs that are each individually owned and operated by your friends and neighbors and your constituents here in the state of Minnesota. Senate File 3920, this bill seeks to amend both contract amendment renewal provisions generally, and as a result of the amendment that Eric just referenced in the last committee, it also seeks to amend 325G.24, the Minnesota Health Club Contracts Act specifically. We have, like Eric mentioned, we have appreciated the opportunity to work and engage with Senator Gustafson on the general automatic renewal provisions of the bill. But with the recent Minnesota Health Club Contract Act additions, we remain concerned with overlapping principles that impose inconsistent obligations and increase the potential risk of litigation to our franchisees. Our preference would be to keep the changes in the general automatic renewal and remove the inconsistent and sometimes duplicative areas of change to the Minnesota Health Club Contract Act. Some of our areas of concern, the rights of cancellation and termination should be consistent across memberships, whether they're automatic renewal or continuous service. There's different standards between the general statute and the Minnesota Health Club Contract Statute. For example, the Minnesota Health Club Contract Statute, as the amendments proposed, add a requirement to clubs to add acceptance of a verbal notice of cancellation. But it's not clear in the amendment how to actually accomplish that. Who's that notice supposed to be provided to? Our clubs are they operate 24/7. We do have minimum staffed hours policies, so people can find an employee in the gym to talk with about canceling their membership if they want to. We're long past the days where this is a 24/7 gym where anyone can just walk in the door, but you can't ever find anybody after you've become a member. So who do you provide that notice to? There's no means of a record. How do you keep a record of a verbal conversation, a verbal cancellation? What if someone leaves a voicemail message and that voicemail message isn't received for a few days? There's a lot of ambiguity here that we'd like to continue to work with the senator and see if we can tighten that up with respect to the Minnesota Health Club Contract Statute. Also, the language that relates to automatic renewal contemplates a 31-day period for cancellation to accommodate month-to-month contract terms. That's something that we worked on together, and we're grateful for that change. That accommodates, like I said, the month-to-month contract terms. It also provides adequate processing time for cancellation. The immediate cancellation language that's included in the proposed amendment that applies to the Health Club Contracts Act actually requires immediate cancellation upon placing written notice in a mailbox. And that's inconsistent. And so when you have the inconsistency between those two parts of the statute, that creates ambiguity in its interpretation as well as its application. If a membership cancellation is effective immediately when written notice is dropped in a mailbox, but the club doesn't receive that notice for days, it creates a gap, that lag. In our system, people receive a key fob that gives them 24/7 access to the gym. So during that time, the lag between the time they put their notice of cancellation in the mailbox and the time that the club actually processes the cancellation and puts the key fob and cuts off the key fob, the member can still access the gym even though their membership agreement has been effectively canceled pursuant to the terms of the statute. So what happens if they slip and fall during that time? They don't have an active membership agreement. It's going to create, again, ongoing ambiguity and increased risk of litigation for our franchise owners.
So, Ms. Shealy, I don't want to cut you off,
Yep.
but we're not going to have the ability today to rewrite the entire bill to remove or consider inconsistent provisions that are in it. This bill came out of Commerce March 20th. So there's been at least several weeks now for all of these issues to have been communicated and potentially worked out with the author before it was brought up before this committee.
Yeah, I appreciate that. I think Chairman, thank you, Chairman
Ms.
Latz.
Shealy.
I appreciate that, and we would like the opportunity to continue to work with the senator, and I believe this bill is going to conference committee after it leaves here. We'd like the ability to continue to work with the senator to continue to refine the language.
All right, well, I'm going to, you haven't been here earlier this session, but I've said repeatedly that I get frustrated when people come here to a bill that's within our jurisdiction to consider, and then they promise us they're just going to keep working on it and going to keep working on it, expecting us to pass it along. It's like passing a kid out of fourth grade reading when they can't quite read yet. Well, go on, you'll figure it out in fifth grade. And I know the legislative process is going to go on for another month or a little bit longer, and there are other opportunities to deal with this stuff, but this is the stuff that should have been dealt with before it came to the second committee with jurisdiction over these issues. So I don't know what's going to happen with it after this point. I would strongly suggest, since we're not going to take any formal action on this today, but I am on the Commerce Committee, so I'm going to have another crack at this bill when we look at this again, and so is Senator Seeberger. So is Senator Howe. From my own standpoint, if these aren't worked out before we consider it in Commerce Committee, I might not support it moving on at all. On the other hand, if there's discussion and, well, I might just consider moving it on without solving these problems either. Also, without expecting any further work on it, because the time to work on it is during the legislative process, not in the last week while these things come up in Commerce Committee, just before they come to the floor. All right, so I hope everyone has heard the lecture. You're the ones who are getting it first today. But we're in the middle of the legislative process now, so now's the time to do the work on it. Is there anyone else who wishes to testify in connection with this bill right now? Any discussion? Senator Kroon.
Thank you, Mr. Chair. I'm admittedly confused. Wasn't this included in the Commerce Omnibus Bill that we passed off the Senate floor? And if so, what is happening today?
Senator Gustafson, I think there's a finance component to this, so it might be coming still, but Senator Gustafson.
Mr. Chair, Senator Latz, yes, I believe that that's why. It needed to, there was jurisdiction here, and so it needed to make a stop here before we get the fiscal note. Or, no, I'm sorry, there is no fiscal note. We have a fiscal note, there is no cost.
Okay, well, then we should ask the question, what's the expectation that we'll do with this bill? What is it that you think is going to happen from here, Senator Gustafson?
Thank you, Mr. Chair. It'll go back to Commerce and be part of their omnibus bill, or and going into conference committee.
So even though there's no fiscal note, you're anticipating it might be included in their budget bill? Is that, or you're hoping that it will?
Mr. Chair, that's correct.
Okay. What?
Mr. Chair, if I could just
Senator
say,
Gustafson.
thank you. While everyone is moving or thinking of next steps, I just want to address something too, that most of the amendments, and just to agree with you on what your comments were, most of the amendments that were taken were, and they were numerous and many, were from the stakeholders that you see here today. And so, well, actually, I've not met with I can't remember, Sheila, I'm sorry. But I have with Lifetime many times, and we have taken their amendments. The bill is what it is, and it's a good bill, and it is in a proper shape, and we have had so many meetings, a folder this thick, and have taken their suggestions. So it's been vetted, it's a good bill. We anticipate it going back to Commerce, and anticipate it being supported there. Mr. Chair, if we're waiting, is it okay for me to make another quick comment?
Yes, go ahead, Senator Gustafson.
Thank you, Mr. Chair. I just also want to point out, too, that this does not, no business is hurt by this. So whatever procedure that they used, consumer used to get into that business, we're just asking that it be that same ease of access to get out of the business. So you don't have to, like the mail, talking to somebody in person, a phone call. If a business, and most businesses do have a website, and your account is on there, if there's an area there, they can click to cancel. The idea is not to create new ways to try to find places for consumers to leave a business. We're just asking that you don't make it harder to leave and make it super easy to join. If I go out to eat and I want to go to a different restaurant afterwards for dessert, I shouldn't have to go through an escape room to do it. I just want to be able to enjoy the services that I've paid for and then be able to leave when I'm ready to leave. There is also language, too, that I think maybe was not understood by those at the table, too, that it isn't an instant. There is buffers of days put in there so that if someone says, I need to leave, and it's a Friday at 11 p.m., that the businesses have time to be able to cancel that account, and they still are being paid for the service they're providing until the next business day. I shuffled through to try to find it, and I can still do that, but I know that we're limited on time. So,
Senator Gustafson, Council has advised us that it was in the Omnibus Commerce Policy Bill that passed off the Senate floor this past week. I'm a little bit confused as to why that happened, sort of in this chronology here, or this sequence. We do have an 812 amendment that I assume you would like us to consider adopting. Honestly, I'm not sure what effect it will have if we do adopt it, because the plan here was to lay the bill over. Honestly, I'm not even sure if the bill, well, somehow the bill is both here and in the omnibus bill. So why don't we, well, the bill's here. The language is in the omnibus bill for the Commerce Committee. So why don't we consider the 812 amendment, if you want to tell us what the amendment is, and we'll see if the committee adopts it, and then we're going to lay the bill over, and that's going to be the end of this discussion. Senator Gustafson.
thank you, Mr. Chair. The amendment is technical changes. If you see page 7, line 16, it talks about, it just clears up that there may be inserting if of any, and that is just to make it easier for the businesses to be able to cut ties. And then if you go to the other section where it says describing options for maintaining an ongoing relationship with the seller, including but not limited to downgrading, pausing, or suspending. An example I would use is if you go to try to cancel your Netflix account, it will tell you that you are paid up through, May 10th or something. You're able to use that service. They will hold on to your information for 60 days or 30 days, and then you're able to join again if you choose. So something like that is offered, and they don't want to be prohibited from letting people know that they can return if necessary, if they would like to.
Any discussion on the content of the 812 amendment? Senator Umover-Bayton moves adoption of the 812 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. All right, members, we're going to lay over Senate File 3920 as amended. And whoever wants to look at it later in the process somewhere else will have this committee's input to do so. Thank you. Senator Mitchell, you ready on your bills? You can pick which one you'd like to hear first. Members, we are going to take a lunch recess at 12:30. We're going to start up with the compacts at 1 o'clock. It is my intention and my goal to finish both Senator Mitchell's bills, Senator Seeberger's bill, Senator McEwen's bill, and Senator Mohamed's bill before then. That might be a little big bite of the apple, but we're going to try because I don't plan to stay here past 4:30 today. Unless members want to stay or come back about 9 o'clock tonight. All right. Senator Mitchell, which one are we doing?
Mr. Chair, I would like to do Senate File 4499 out of respect for my testifiers who are here in person on this particular bill.
All right, members, Senate File 4499 is before us. Senator Mitchell, tell us about your bill.
Thank you, Mr. Chair, members of the committee, and at everyone's convenience, this is the first stop, and I do have an amendment. This is something that was brought from a member of my community, but we found, looking into it, it is a bigger problem across the state of Minnesota. Minnesota is in a child care crisis, which I think we heard many times with some of the different funding aspects we did last year, trying to get more workers engaged and other ways to help solve that problem. And one of our big issues is that family daycares, or what we call in-home daycares, since 1999, so in 25 years, have lost half their capacity. And when we have fewer options, it means sometimes parents have to make not wonderful choices as to how their children are cared for, not things that work in their schedule. And it particularly hurts women, especially as they try to engage in the workforce when there is not adequate childcare. Sometimes it impacts the ability to work the job or the schedule that is actually the best suited to their talents. So what this does is there is a situation that with more communities being built as HOAs, that sometimes these are being excluded by the HOAs and not even to start. So as my testifier can speak to, sometimes years after a business has even been going in an HOA as a child care center, they will restrict the rules even more or kind of change the adoption of how businesses are seen in HOAs and effectively shut down the businesses. And this is a public service to many of those communities because often the children being cared for are other members of the community in the HOA. So what this bill does is, and we have worked with, a lot of work was done in this in the House, including with the representatives from the HOAs. I've done some work with the Bar Association to make sure this is narrowly tailored so that we are talking single-family homes and so that we are talking not something where the insurance would impact other members of the HOAs, but a way for child facilities to still exist in homes in HOAs to help us solve this crisis that we have across Minnesota.
All right, Senator Mitchell, this is the first committee stop. There is an A1 amendment to be an author's amendment. Senator Seeberger moves adoption of the author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Mitchell, you have a testifier, looks like, sitting next to you.
Yes, Mr. I'm sorry.
Thomas Leonzo.
Sir, welcome to the Judiciary Committee. Go ahead and state your full name again and your affiliation and present us with your testimony.
My name is Thomas Leonzo. I live in Woodbury, Minnesota, and my Senator Mitchell here has been helping me. Back in 2011, in a development in Woodbury, my wife started a small home daycare. And eventually it kind of grew and grew, and around 2015, I also joined her in that. From 2015 until 2019, we ran a daycare in a development called Dancing Waters. We seem to have done a pretty decent job. In 2017, we won Washington County Home Daycare of the Year. Quite proud of that. Around 2019, in July, we received a letter from the lawyer of the association stating that we had to move our daycare down to 2 students. And at that time, we had 11 students. And so I called the lawyer and I said, well, you know, why are you shutting us down? And the answer was, well, we're not shutting you down. We're just saying that you can have 2 students. I said, well, okay, well, why just 2 students? And the answer was because. And that just didn't seem like a very good answer to me. And then I also asked, I said, you know, we have students here that have been here for quite some time. They've built relationships, and I also have parents that rely on us. What do I tell them? Well, that's up to you, and that was pretty much the end of the conversation. keeping the daycare, we immediately started looking for another location, and we ended up purchasing another location outside of an HOA, but we were still within Woodbury. So it was quite trying, but we did manage. But I was kind of hoping that we would look at this as something a little bit better than just because.
Thank you for your testimony, sir, and congratulations on your award.
Thank you.
Senator Mitchell, did you have any other testifiers that you anticipated for this bill?
I believe, I had thought there was someone from the HOA Association. I know, not seen.
Okay. All right. Mr. Hines, why don't you come on forward? Mr. Hines, go ahead and identify yourself.
Thank you, Mr. Chair and members. For the record, my name is Patrick Hines with Messerly and Kramer, representing the Community Associations Institute Minnesota chapter. CAI Minnesota represents the interests of homeowner associations, from residents to board members and all of the various vendors and businesses that serve associations. I want to thank Senator Mitchell for the A1 amendment. As drafted, the bill was quite broad, and we were concerned that it would have too many unintended consequences. And the A1 amendment does make some significant changes that we support. I'd bring up two issues for the committee. First, as a matter of policy, we feel that the bill as amended still misses an important concept, and that is the concept of use of common elements in an association. As many of you know, associations consist of units, limited common elements, and common elements. Common elements are owned by each individual member of the association collectively. And in a situation with daycares, for instance, if the Department of Health, as a licensure requirement, requires a daycare to have a certain amount of open outdoor space or access to, say, a playground or other equipment, if that equipment or that open space is owned as a common element, we don't believe that the Department of Health should be able to require use of that common element in order to meet the licensure requirements, because as drafted, once it was licensed, an association would not be able to restrict or prohibit the use. I don't know that that's the intention of the bill, and I don't know if the case that the testifier talked about, that would be an issue, but that is something we think should be addressed. And the second issue is more of a technical one with how the language of the A1 is drafted. I think the language on line 1.21, which defines a single-family detached dwelling, and on line 1.25, which defines a multifamily attached dwelling, that I believe is mistakenly included in the definition of private entity, which is an association, and that shouldn't be the case. I think it would be better.
Mr. Hines, I'm going to interrupt you because counsel's indicated that you're right, and she has a proposal to fix that.
Okay, thank you.
So maybe we can just jump right there. Ms. Primo.
Mr. Chair and members, I think this is how maybe it should be handled. So on the A1, page 1, line 17, delete everything after the comma. Delete lines 18, 19, and 20, and insert page 1. After line 20, insert this section only applies to, colon, and then delete line 27. I believe that's the intent of those two paragraphs, to make this section only apply to those, so the single-family dwelling and that multifamily dwelling.
Mr. Hines.
Mr. Chair, members, thank you. I believe that Senate Council's language makes sense and would put the amendment and would format it in the way in which it was intended when it was drafted.
I would
Senator
accept
Mitchell.
that change.
All right. Any discussion? Senator Uma Verbatim moves the amended, as council has described it, be added to the A1 amendment that's already been adopted into the bill. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. All right, Mr. Hines, anything further?
Mr. Chair, I would just note again that while the bill is certainly improved and that CAI will continue to work with the bill authors, Senator Mitchell, we do feel that the issue of common elements should be addressed as the bill moves forward, and that would make it more restrictive, and I think a stronger bill would prevent potential controversy between neighbors who may have differing opinions about who has access, whose children has access to the swing set and other common elements. Other than that, that's all. Thank you.
All right. Senator Mitchell, how would you like to address those issues?
Thank you, Mr. Chair. I would like to say in the licensing requirements for a home daycare, there aren't requirements that there be a certain amount of backyard space, outdoor space, that there has to be a playground that is available to them. Also, home daycares, really the max number of children that you're going to have with 2 people would be 14. And many of them, as I've heard both from the testifier and from other communities, they are actually children from within that community. So I guess to say that there would be no way for them to go play on a playground when many of the kids actually are members of the community, I think is a little bit of just a point of difference. But if that's what gets this to the finish line, we really just need people to be able to have daycare options. And this is really removing a lot of daycare options around the state.
Senator Mitchell, it's not clear to me what you would like to be done with this bill now. It's come to the judiciary. I'm not aware that it's been requested by any other committees, and I'm not aware that there's a fiscal note involved. Do you know?
Mr. Chair, there is not a fiscal note. So this originated in the House and was in Children and Family Services, and every other committee waived jurisdiction on it. But my understanding now is that Children and Family Services in the House is going to be doing only a fiscal bill. So what they have humbly requested is that if there is any way to include this in the omnibus bill for judiciary and public safety, that the House corresponding committee would accept this in conference committee if it was able to go in that way. If not, it would have to go to the floor.
Okay. Is there any discussion from members of the committee in connection with the bill? Senator Limmer.
Thank you, Mr. Chair. Senator Mitchell, there are times in multi-unit buildings that are dedicated to ownership that's 55 years and up. Does your bill recognize those type of limitations?
Senator Mitchell.
Thank you for the question, Senator Limmer. Mr. Chair, this was something that we had a broad discussion on because I completely understand where you are coming from. With the discussions with the House, we had heard of some of those communities that actually do have childcare within them because more places are having kind of these blended uses. There are more grandparents taking care of grandkids and things of that nature. So we did not end up, so I originally had it in the amendment, and then with that discussion with the House, I ended up taking it out of the amendment because you would also, the people living there at that particular age probably are not going to be doing this as a profession unless there is something within the community where they have set up that framework to do it. So that is why we made that decision.
Senator Limmer.
Thank you, Mr. Chair. I'm a little concerned about people who buy a property in a multi-unit building. Sometimes it's for flexibility as they go somewhere in the winter and there's some place for neighbors can keep an eye on it, it's more secure. many of them, especially in a 55 and older building, they are buying that type of property with the idea of getting distance away from younger people, whether it's children or whether it's just young adults that are living in those buildings. But are we changing the ownership expectation by having this type of a mandate on multi-unit buildings?
Senator Mitchell.
Again, thank you, Senator Limmer, for the question. So that was part of what I feel is actually covered in the A1 amendment, that we wanted to make sure that this wasn't being put in an apartment where you might be disturbing the neighbors or something of that. So if you look at, the lines might have changed with the oral amendment, but the original A1 as drafted, that it now really has to be a single-family detached dwelling, and it has to be run by the owner. And the only way that you get to multifamily is that if it is the owner that is running it. So to me, that would be like if you had a duplex. My grandparents did this, actually. My grandmother ran daycare for quite a while, and they also owned the duplex next door and rented it. So then the owner is the person running the daycare. So they would be responsible to any tenant next door or anything else if they were renting, to be responsible for saying, yes, you can rent this, but I have a daycare next door. So I feel like that is really why we tried to tighten this up, because I do respect that if you're in an apartment, you might not want this going next door. So it is now that the owner is going to be the operator. That's also solves an insurance problem, because if you were operating something in someone else's building, there might be an insurance liability of running that sort of a business. So that's why we very narrowly put that in, to make sure that we had addressed some of those concerns.
Senator Limmer. Senator Kroon.
Thank you, Mr. Chair. I'm looking through the amendment in the bill, and I don't see anything specifically on it, so I'll just ask you. So a lot of homeowners associations with single-family residences have like fence requirements. Maybe you can't have a fence, or maybe you can only have an ornamental fence, or certain types of fences. And I don't know what the licensing requirements are for daycares, but what if you have to put in a fence to get your license that doesn't meet the limitations of fence requirements in an HOA? Would the HOA be forced to allow the owner to put in that type of fence, or how would that situation work?
Senator Mitchell.
Thank you, Mr. Chair and Senator Kroon. This shouldn't change any other restrictions. I would analogize it to, I get licensed as a foster parent, and if I don't have a property that complies with what I need, then I'm just not going to get my license. So it's not making the HOA do anything else other than if someone is licensed by the state, or usually it's the county, by the county, then they can operate this and they meet all the other criteria. But it is not making the HOA fit the property to run the business. It is, if the county has already said this home and this property is appropriate for a license, then the business will be allowed.
Senator Kroon.
Thank you, Mr. Chair, and I should have prefaced my comments with it. One of the reasons I think childcare costs are so expensive in Minnesota is the declining number of in-home daycares. So I certainly don't want to do anything to lessen the number of in-home daycare providers. So it sounds like a lot of the big concerns have been met. There is an outstanding issue on common elements. I totally understand that side of it too. That's a hard issue, because if the kids are in that homeowners association, then nobody should be upset about that. But if there's a situation where that's not the case, and I can see some conflict coming within homeowners associations, I don't know where I stand on it because there's two important competing interests here. So I'm just throwing that out there. But I do appreciate, we do need to do things to encourage more in-home daycares to bring the cost of childcare down in Minnesota. Thanks.
Thank you.
So Senator Mitchell, it sounds like this would not apply to a situation where you got a condo building that has 50 units, because all the units or most of the units are going to be individually owned. There won't be one owner of all 50 units. Is that correct, Senator Mitchell?
Correct, Mr. Chair.
Okay. All right, any further discussion from members of the committee? Senate File 4499 will be laid over for possible inclusion in our omnibus bill later today.
Thank you. I appreciate it.
Thank you. Senator Mitchell, your other bill is Senate File 4877. Members, this comes to us from Health and Human Services Committee. There is a delete everything amendment, the A2, which is in our packets, which is not an author's amendment. So why don't we hear a description of the bill or what the author hopes the bill to look like after delete everything, and then we will consider it.
Thank you,
Senator Mitchell.
Yes, thank you, Mr. Chair and members of the committee. This basically would create a multidisciplinary child mortality review team, and they would review critical incidences. It would have DHS establish that review panel. And the need for this is basically, we have found that there are a number of cases where, unfortunately, when a child is lost in the system, which is very tragic, that there are investigations done into the why of that, but not always a follow-up as to how can we change a procedure out of that sort of an incident. So there was an article in the Star Tribune earlier this year that said when they surveyed more than 24 counties and the mortality review requirements, that it is actually being done in a very spotty manner. Some counties don't conduct the reviews, some take years to complete them, and one of the DHS deputy commissioners said they couldn't think of a single policy or procedure that had changed as a result of the mortality reviews in the past 5 years. And the fact is, when sadly a child is lost in the system, we need to look at why and if there is something that we can be doing better. So this is part of the work of many things that we were looking at with our legislative child protection task force on ways that we can make sure that Minnesota is having general better outcomes. So just to go through what some of the bill does is Section 1.
So Senator Mitchell, I'm just going to save time here. We have data and immunity provisions only that are within our jurisdiction. So I think what we're going to have Ms. Primo identify those provisions for us, and then we can concentrate, although we have a DE proposed in front of us that might go beyond those. So I guess we'll get a sense from Ms. Primo what we're dealing with here today. Ms. Primo?
Mr. Chair and members, looking at the underlying bill, those provisions are in Section 2. They begin at subdivision 5, which begins at line 6.31 and continues on to 8.14. And in the DE, I believe it's still generally similar. It's at line 6.19 through 7.30.
Senator Mitchell, are there any substantive changes in the delete everything amendment unrelated to subdivision 5?
Mr. Chair, I would say no. A lot of this is just as we've continued to talk to the agencies and make sure that everything is both in there that we need to be in there and that we're doing it in the most mindful way. These are changes that have come over basically from the House and the work that they have done to make this a better bill.
Okay, Senator Mitchell, to be honest with you, it doesn't affect me whether the House has already done it and what their input is. But the question is whether or not we're being asked in a delete everything amendment to adopt changes that would have been within the purview of the Senate's Health and Human Services Committee.
Not to my knowledge, Mr. Chair. So if I can clarify, this will go back to Health and Human Services, hopefully after we pass this, for them to include in their final bill.
Well then, members, I'm going to propose that we consider subdivision 5, the immunity and data practices provisions of the delete everything amendment only, and then Health and Human Services can look at anything else in the delete everything amendment and decide if they like it or if there are changes that they wish to incorporate in their bill. We have a testifier that is appearing on Zoom, Kelly Knudsen, I assume. If you could please, you can introduce yourself and we'll welcome your testimony, but I'm going to ask you to focus it only on the data practices and immunity provisions in the bill before us. If your testimony is relating to other aspects of the bill, well, I appreciate you waiting around. That's not within this committee's jurisdiction. We're not going to consider those elements of the bill. And so I'll leave it to you. So go ahead now.
Thank you, Mr. Chairman and committee members. And I do believe my testimony is in reference to the other parts of the bill, so I wouldn't be able to provide testimony on the immunity and data practices for which you're asking.
Thank you. And I appreciate
You're
you
welcome.
telling us that. All right. Anyone else in the room wish to testify in connection with the data practices and immunity provisions? Senator Mitchell or Ms. Primo, anything that we should know specifically about? We got a couple pages here of immunity and data practices provisions. So, Senator Mitchell.
Mr. Chair, just a lot of this has to do with the nature of the work and children that have died and making sure that when they need to, there is access to data that would not otherwise be public during the course of these reviews. Hospital records, state agency records, things of that nature, just making sure that that data is there for them to do the work when they dig into these issues.
Ms. Primo, anything you'd like to add with regard to the data or immunity provisions in the bill?
Mr. Chair and members, no, I don't have anything to add.
Any discussion from members of the committee? All right, then I think the appropriate motion, well, I'll just say I did just look through the data and immunity provisions, and it seems to basically classify the data that's gathered as not public but accessible to those who are doing the reviews. It gives the reviewers access to data so they can make informed decisions. Any testimony they receive gets the classifications as protected non-public data. And it provides some immunities for those who are presenting information as long as they're acting in good faith and assisting with the incident, gathering the incident information. So then I think the motion you'd be looking for, Senator Mitchell, would be for this, that the subdivision 5 portion of the A2 amendment be adopted into the Senate file. So, Senator Carlson, would you make that motion? So moved. Senator Carlson moves that the subdivision 5 language as identified by council. In section 2 of the A2 amendment, be amended to Senate File 4877. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. Any further discussion on Senate File 4877 as amended? Not seeing any. The members, I think the next motion would be for Senate File 4877 as amended, be recommended to pass and be re-referred to Senate Committee on Health and Human Services. Any further discussion? All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Senator Mitchell.
Thank you.
Next bill, Senator McEwen, Senate File 5257. Senator McEwen present or is she virtual? She's online.
Hello, Mr. Chair.
Senator McEwen appears digitally to the committee and the public today.
Hello, good afternoon, Mr. Chair, members. Thank you very much for rehearing our bill today. We did have some discussion on this bill earlier on, and we tabled that discussion so that we could hear back from the Department of Labor and Industry's attorneys in regard to a privacy issue. This relates to making medical records available to the doctors who are set to handle fights, to oversee fights, and so they're ringside doctors who would then medical records would be made available to them under this change. We did check with DLI General Counsel. They assured us that DLI already treats all of the medical records as private data that would only be shared with the doctor and not be allowed to just be disseminated outside of that, that there are other provisions in Minnesota law that account for that. But they are here to answer any questions that you may have in detail to that regard. So we're here to finish our discussion. Thank you.
All right, thank you, Senator McEwen. And as I recall, Senator Cruin had asked these questions about privacy. Senator Cruin, have you had an opportunity to be more fully informed on this question?
Thank you, Mr. Chair. I don't even have my recommended amendment that I brought in committee last time, but I guess that would be my question if the General Counsel had any position or Chief Author has a position on that in light of their conversations.
It sounds like, General Counsel, if you'd like to go ahead and identify yourself and tell us if you think the privacy concerns are already addressed in existing law.
Thank you, Mr. Chair. Good afternoon. Good afternoon to the committee members. My name is Ali F. Sharjavan. I am an attorney in the Office of General Counsel at the Minnesota Department of Labor and Industry, which houses the Office of Combative Sports, or OCS. The language specifying that data collected, created, or maintained under Section 341.33 as private data on individuals is not necessary to have the Office of Combative Sports to continue protecting health information. In the event of a data request, OCS's position has been and continues to be that the health records would be withheld based on the Minnesota Health Records Act. That said, if the legislature believes additional protection is needed and would like a reference to the Data Practices Act in Chapter 341, OCS would not be opposed to that, but if the amendment language is incorporated, a better approach might be to include a standalone section in Chapter 341 governing data classification of all health records received under Chapter 341 and applicable rules. To that end, OCS receives health records under Section 341.30, not only 341.33. Minnesota Rule 2201.0300 also calls for the collection of health records.
So, Counsel, is it your position that such an amendment would not be necessary under existing statute? But if it were adopted, it would be a belt and suspenders approach essentially to that question.
Thank you for the question, Mr. Chair. That is correct. It is not necessary. That's the department's position, but it would not hurt. It would be a belt and suspenders addition.
Senator Cruin, how would you like to proceed?
Mr. Chair, I don't know the best place for the amendment to be located. This is, I'm just looking at the amendment from last Monday. I mean, that's where it made sense to me, but if there's a better place to put it, I'm open to, yeah, maybe council could opine on that. I don't have a position on the best place to put it.
So Senator Cruin, I think the first question is whether you're satisfied that an amendment, whether you determine an amendment is even necessary given the testimony. If you still think an amendment is necessary, we can figure out how to draft it or place it. Senator Cruin.
Well, thank you, Mr. Chair. I would, I'm admittedly not an expert in this area. This was an issue that I thought made sense. I still don't see it would do any harm. So I would like to continue moving forward with the amendment. Where it goes, was my solution. If someone or council has a better solution to put it somewhere else, I'm certainly open to that as well.
Council F. Sharshavan, did you have any amendment actually drafted, or you just have some notes as to how you think it might, what it should do?
Thank you for the question, Mr. Chair. I don't have an amendment drafted, just some notes, but it should, if it is going to be incorporated, I do think it would be prudent to just put in a standalone section that would be applicable to health records and to any data, any health records received under Chapter 341 and applicable rules. Where that actually is in the chapter, I'm not sure that it matters.
Ms. Primo, is this something which we can do on the fly here, or would you like some time to work out an amendment with General Counsel? Ms. Primo.
Mr. Chair and members, I have some proposed language for consideration.
All right, go ahead.
It would be adding a new section to the bill as follows. Section 34.352, titled Data Privacy. All health data collected, created, or maintained under this chapter is private data on individuals as defined in Section 13.02, Subdivision 12.
Mr. F. Sharshavan, what do you think about that?
Mr. Chair, could, what section would that be?
Ms. Primo.
Mr. Chair and members, it would be 341.352. So that would be adding a new section into the combative sports chapter.
Mr. F. Sharshavan.
Thank you, Mr. Chair. Adding the new section, I think, would be appropriate. I think the health data reference is a good one. I would want to double check on the definition of health data and what that encompasses. If that's put elsewhere in the Data Practices Act, that's the only caveat. But otherwise, I think health records or health data or some reference to that would be appropriate.
Sir, would you be more comfortable if we just referred to health records?
Yes, Mr. Chair.
Ms. Primo.
Mr. Chair and members, that's fine. So it would read, the substantive portion would read, all health records collected, created, or maintained under this chapter is private data on individuals as defined in Section 13.02, Subdivision 12.
Senator McEwen, your thoughts?
Thank you, Mr. Chair, and thank you for this discussion. I appreciate very much all the work people are putting in here, and this sounds very agreeable to me as long as the council from the Department of Labor and Industry feels that there wouldn't be any unforeseen problems with adding this language. This also gives me comfort too, and I'm happy to accept it as a friendly amendment as long as DLI is okay with it.
All right, Senator Cruin.
Thank you, Mr. Chair. I'll move the amendment as described by council.
Any further discussion on the amendment? Not seeing any. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. All right, any further discussion on Senate File 5257 as amended? Senator McEwen, is it my understanding it's your intent that we lay this over and hopefully include it in the our Judiciary Omnibus Bill?
That's correct, Mr. Chair.
All right, Senate File 5257 is laid over.
Thank you, Mr.
you.
Chair, members.
Members, FYI, Senator Mohamed's file, Senate File 2026, is going to be considered part of this afternoon's agenda sometime after the compact conversation is concluded. We have then one bill left on this morning's agenda. That's Senator Seeberger's bill, Senate File 4377.
Senator Seeberger, when you're ready.
Thank you, Madam Chair. I'm here on Senate File 4377. This past year, I have met with many first responders and military servants that have served on both our nation and community who have expressed concern over their ability to access mental health resources and the challenges of serving their communities. This bill, 4377, helps address the possible and present mental health issues that our first responders and law enforcement officers face. Given their work and commitment to the community, their employment is one that is accompanying with trying and lasting challenges. Organizations such as Hometown Hero Outdoors support those members of our community that have given so much to us. Since 2017, Hometown Hero Outdoors has served over 12,000 members. It is important that they continue to facilitate outdoor adventures that help the healing process of serving our military veterans, and first responders. And there should be additional materials included in your packet that outline the program. And I have a few testifiers that can give you more information.
Thank you, Senator Seeberger. Would you like to move to your testifiers?
Yes, please.
Okay. Let's see who we have here first. Christopher Tetrault. Correct me if I'm pronouncing your name incorrectly. If you want to just start with your name and affiliation.
Yeah, Madam Chairman, thank you for having me today. Yes, my name is Chris Tetrault. I am a former military service member myself here as a Minnesota Red Bull, and I've been in law enforcement for nearly 16 years. Currently, I'm the interim president for Hometown Hero Outdoors. Our mission is to providing first responders who are emergency medical services, fire, and law enforcement, military service members, and veterans with enriching outdoor experiences, fostering healing and strengthening our community bonds. I'm here to support Senate File 4377, authored by Senator Seeberger, Housley, and Kwadzinski. In the other body, we also have additional support that is bipartisan. The bill provides an appropriation to Hometown Hero Outdoors. We're a 501c3 nonprofit that's based in Stillwater, Minnesota, and 100% volunteer organization funded through donations, fundraising, and grants. All those who volunteer are not compensated at all. Since 2017, we've helped nearly 2,000 public safety officials in the state as well as veterans in Minnesota by using outdoor experiences to improve mental health. And we do it because we know we're changing people's lives, and frankly, we're saving them as well. 1 in 3 first responders develop mental health issues. We use the outdoors as a tool to create bonds, friendships, and the hope that members will reach out to us in the time of need. Hometown Hero Outdoors has furthered its commitment through Operational Garden Sentinel. This is a program that we utilize to use our ASSIST training, which is Applied Suicide Intervention Skills training, which helps us with crisis intervention in a time of need for our first responders and military friends. Our humanitarian efforts break the stigma and discrimination against mental health issues commonly confronted by our public safety officials, military service members, and veterans. I have 2 additional testimonial testifiers that were supposed to be here today. They are unable to meet with us. They are partners that I have met with and we plan to use for mental health. But unfortunately, due to the circumstances with the first officer-involved shootings recently in Hennepin County as well as Burnsville, they're engaged with some mental health therapy with our first responders. So I have those here for you as well. But Madam Chair, Committee, thank you very much for your time.
Thank you. And just confirming, Senator Seeberger, that's all your testimony?
Correct. No additional testifiers.
Okay. Questions? Okay, and the plans to lay the bill over, Senator Seeberger?
Yeah, I'm sorry, Madam Chair, I need to correct myself. I believe Megan and Eric Mattson are here as well to testify. I was mistaken.
Okay. In person? Please come
Yes.
forward. Thank you for being here with us today. If you could just start by stating your name and affiliation and then proceed with your testimony.
Thank you for having us here. My name is Eric Mattson. I'm a retired police officer from the city of Waseca. I was shot in the line of duty in 2020 and forced to retire after that. My wife, Megan Mattson, is here with me today to testify and kind of tell us some of our story. Hometown Heroes Outdoors approached me and asked, what is a dream hunt you'd want to go on? And I said, I'd like to go hunt king eiders in Alaska. And that hunt just motivated me every day to work hard to get some of my skills back and just improve my mental health motivated me to do it more than anything else. So that their efforts in the program.
Yes, so. Thank you, and if you could just state your name as well and affiliation as you begin your testimony.
Yes, absolutely. Megan Mattson here. I am Eric Mattson's wife, now his caregiver as well. We are here to support Senate File 4377. I'm going to ask my husband a couple questions. What would your recovery had looked like without HHO?
Mr. Mattson.
Without HHO, I would never put as much effort as I put into it to get stronger.
Megan Mattson.
Why should the Senate pass this bill?
Eric Mattson.
I think the Senate should pass this bill just because it kept me motivated every day to get out of bed and to rehab.
Megan Mattson.
Talk about Jeremy, the DNR officer, and how HHO motivated you daily during your darkest times.
Eric Mattson.
Jeremy would call me and said, Eric, do you want to go hunting? And I said, yes. She's like, well, you need to get out of bed today and go to your rehab then.
Megan Mattson.
So from my perspective on the outside, now that Eric's hunt is done with, and knowing that HHO was the main reason for how hard Eric worked, and it wasn't just me and my daughters motivating him daily. Between the phone calls checking in not only on Eric but me as well, this organization was a huge part of my husband's recovery in such an impactful way. We are here today in person asking you, considering to pass this bill, to continue to help other first responders, veterans that live here in Minnesota that have sacrificed their lives to this state and the country. By passing this bill, you are helping them with their mental health. You're helping them form relationships while making memories that could forever change these individuals' lives for years to come. Please consider supporting Senate File 4377. You too can help change their lives.
Thank you for your testimony, and I know you've been here before in front of this committee. And I'm glad to see that Officer Mattson is doing, I think, better than he was last time he was here.
Yeah, he's
So
doing
welcome
good.
back, and thank you for coming here today.
Absolutely.
All right. I think we had one other person signed up to testify. That was Brian Peters. Oh, you're just here for questions. Okay, very good. Senator Seeberger. How would you like to proceed?
Thank you, Mr. Chair. It's my understanding this will be laid over for possible inclusion. Is that correct?
That's our plan, yes.
All right. All right. So grateful for the opportunity to present this to the committee and look forward to your consideration later on. Thank you.
Any discussion from members of the committee? Senator Howe, did you have your hand up?
Well, yes, Mr. Chair, thank you. I just wanted to find out, I've actually participated in some of their hometown hero outdoor events. The question I do have, though, is they've done a fantastic job from 2017 till now. And I'd just like to know where they got their funds to do their activities up till now. And then what this money here would do differently than what they've currently been doing.
Senator Seeberger, or anyone else who knows the answer. Sir, welcome to the committee. Go ahead and identify
Mr. Chair,
yourself.
yes, thank you. Senator, yes, so fundraising up until now, since 2017, it's been funded through directly with our volunteers that have been here, hosting different events, utilizing our Minnesota gambling abilities with our raffles and different events that we've held throughout our annual gala. Additionally, on average, it costs about $53 per person for us to take them to the outdoors due to that fundraising that we have here, as well as negotiating with some of the individuals that we have in the outdoor industry that help us lower those costs with gifts in kind. As far as the appropriation, what it would go to is obviously $53 a person would go a long way with what we're requesting. However, 50% would go directly towards doing our outdoor activities. And then 30% would go towards additional mental health help that we have through Abijah on the backside, who we're being a partner with, who received an appropriation last year, as well as Brittany, I can never pronounce her last name right, Dr. Brittany Mikowski, who is also a suicidologist that we'd be able to hand off our people who are having mental health issues to after they engage with us, because we do create a network of individuals that are supportive and reach out to us in a time of need. And then the other 20% would go towards additional overhead costs. Right now our admin fees are at 2.8%, so they're significantly low. That will rise a little bit since we do have a team of 6 accountants to ensure that our books are in order.
Senator Howe.
No, Mr. Chair, I've like I say, I've participated in their events in the past. I am a supporter, just wanted to have it out there where this money was going to go and the differences between past events and today, so.
Mr. Tetrault, are there other than your own fundraising efforts, is the organization receiving any other public funding or grants from other foundations or anything like that?
Mr. Chair, yes, thank you. We have engaged in doing some grants occasionally through businesses such as Cabela's, or if we have Shields or whatnot, but otherwise public funding, we have not received any. It's just been through fundraising through the efforts of our volunteers, Mr. Chair.
And what is the total budget for the organization?
This past year, so our fiscal year is a little weird. There's a booklet that you might have received, but our fiscal year starts from April 1 to the end of the following March. But for the calendar year of 2023, our operating budget was $800,000, roundabout. I have those exact numbers here if we need them.
So this request would be about a 60% increase.
Yes, sir.
Or no, over a 2-year period. So maybe a 30% increase over your existing budget, right?
Yes, sir. Yes, Mr. Chair.
Any other discussion from members of the committee or questions? All right, thank you for your testimony. Senate File 4377 will be laid over for possible inclusion, and we are now going to take a 30-minute recess for lunch.
Good job.
We are in recess. Good afternoon, the Senate Judiciary Committee will come back to order. We have Senate File 1572 in front of us. This is the first of a series of interstate compact-related bills. This is Senator Abler's bill. Senator Kupek is a co-author and is also the chief author of the last compact bill that we'll be considering. Just so everyone knows, the intent here is to just identify the main purpose of each of the compact bills. We'll take them up in series and lay them over. We do have one common element that we've been working on since Senator Abler's bill was first heard that had to do with venue and liability. There is a stakeholder agreement on that. So everyone who's the chief author of a compact bill has already indicated to the committee administration that they're accepting of that liability and venue provision going into their bills. So we'll lay everything over until we get to Senator Kupek's chief authored bill at the end. And then we're going to have a delete everything amendment, which is going to load all of the compacts into that one Senate file, which we will move out of the committee here as a mini omnibus bill on compacts. So now you know the plan. So in front of us now we have Senate File 1572. Senator Kupek is joining us remotely on the screen. Senator Kupek, good afternoon.
Good afternoon. You hear me okay?
Just fine. Thank you.
Okay. So yes, I have Senator Abler's bill here. And before we begin, Mr. Chair, Senator Abler wanted to make sure that the oral amendment he had made previously was included already in his bill.
Ms. Primo?
Mr. Chair and members, I'll have to refresh my memory on the oral amendment that was made in committee.
If you want, I can tell you it is on page 2, line 2.24. He had delete or and insert and.
I'm not sure that's the right line. Senator Kupek, can you tell us the line number on that again?
Sure, it is line 2.24.
Well, there's not an or on line 2.24, so.
Double check.
Do you have any other information, like section, article, or section?
On the bill that I have with me, there is an or on line 2.24, evidence of participation in or completion of, and he would like to say and completion of. It is in Article 2, Section E.
Looks like that's already in the bill, says and.
Okay,
Completion
very
of.
good. He just wanted me to double check on that before we begin.
Sure wasn't the other way around. He wanted or instead of and, because and is in the Grossman that came to us.
His instructions are delete or and insert and.
All right, well, if it needs a little cleanup somewhere down the road, we'll do the cleanup.
All right, then I will start. So this is the Occupational Therapy Licensure Compact.
Yes, and Senator Kupek, the whole bill is going to go to state gov from here, so if he looks at it when it goes over there and it's not the way he thinks it was supposed to be, we can get it taken care of.
Okay, great.
All right. Members, you have in front of you the A5 amendment, which gives you the language of the venue and liability language that is going to be incorporated, applying to all of the interstate compacts, just so you can review it. Senator Kupek, was there anything that you wanted to add relating to Senate File 1572 in particular? Because we did have a chance to go over it with Senator Abler.
No, there was nothing else. That is it.
All right, and members, there's also some data provisions in here, I think, which bring the bill within our jurisdiction. Ms. Primo, can you identify those for us? I assume they can be pretty common between all the bills, but we can just take a look now.
Yeah, Mr. Chair, yes, all of the provisions within our committee are generally similar, almost identical. They might be structurally laid out in different ways. In this bill, they would be at Article 9, which begins at page 15.34. That's the data sharing article.
All right, so members, if you just take a quick look at, or a not so quick, carefully evaluated look at Article 9 data system so that we all understand what we're doing here. Was there anyone in the room that wanted to testify in connection with either this data provision or the venue and liability provision? Do we have anyone online? I see Ms. Kalfas is joining us virtually as well, counsel for the interstate compacts. Maybe we can ask Ms. Kalfas if you could just tell us if you'd had an opportunity to review the venue and liability provisions, and this is what you have agreed to, so we've got a matter of record. Ms. Kalfas, well, go ahead and state your full name also, if you would.
Thank you very much, Chair. My name is Nahali Kalfas. I'm the attorney with Council of State Governments, as well as counsel for a number of these compacts before you. I have conferred with Samantha Nance, who also represents the other compacts, and I can speak to, I believe, every single compact except for PT, in saying that we have reviewed, we have approved, and I believe they're okay as well with regard to the provisions, but we are in approval of the language as it stands now. I have had an opportunity to review it, and I want to thank you and the committee for your time.
And with that, Ms. Kalfas, then we understand that the adoption of these provisions in Minnesota's interstate compact language will not be a barrier to the state becoming a participant in these compacts. Is that right?
That is correct, Chair. Thank you very much.
Thank you. And what are we to make of the fact that the physical therapy compact has not reviewed this, as you said?
Chair, I'm so sorry.
No, go ahead, please.
If I may, Chair. They may very well have reviewed it. I just didn't want to misrepresent that I am the attorney for PT or that Samantha is, but they very well may have and may be perfectly fine with it. So
Okay.
my guess is they probably have, because we tend to work in concert. I just haven't confirmed that.
All right, thank you. Anyone else want to testify in connection with any of this? All right, then we're going to lay Senate File 1572 on the table and take up the next compact provision, Senate File 1322, Senator Morrison. Senator Morrison, we have 3 of your interstate compact bills, so why don't we just take them in order. The first one is 1322, dealing with physical therapy. Have you heard, by the way, from counsel for the interstate compact relating to that bill?
Related to PT, Mr. Chair?
Yes.
Mr. Chair, it's my understanding that the physical therapy interstate compact has been around for so long, and there are, I think, almost 40 member states, so the issues may be different. I'm not certain, but I may have to ask for I may need to phone a friend.
Okay, well, I just want to verify if we have someone here from the physical therapy compact. Well, come on forward. Welcome to the committee. If you go ahead and identify yourself and your affiliation, please.
James Leahy. I am the executive director of the Minnesota chapter of the American Physical Therapy Association. We have been in contact with the PT Compact. We don't work with CSG because we predated their engagement. We have reviewed the language, and we are very comfortable with it and don't believe it will inhibit Minnesota from joining the compact.
All right. Anything specific we should know about the physical therapy compact that's before us today?
Well, Mr.
Morrison
Oh, sorry, go ahead.
or Mr. Leahy?
No, we appreciate your support.
All right, any questions from members of the committee about the physical therapy compact? I'm going to ask council a question because the packet that was distributed had an A2 amendment in it, which is somewhat different than the A5 that came out for the 1572. So is it anticipated that we should just, as a committee, look at the A2 amendment, that the applicable language is the same or for all of them, or should I just have you describe what we're doing? All right, Ms. Primo, tell us what we're doing here.
Mr. Chair and members, the A2 amendment must have been kept in there from when this bill and all the compact bills were heard in the last time we were together on this. And so since then, there's been more discussion. And so the amendment that you should look at is the A5 on 1572. Those are the changes that are being made to each bill. It's not drafted to each compact, but that is the agreement for each compact. And then when we do get to 2394, that's when all of the compacts will incorporate that language and be, I suppose, up for the committee to vote on.
Okay, so members, ignore the A2 amendment that's in your packet for this. Any specific questions or commentary around the physical therapy compact? Not seeing any. We're going to lay Senate File 1322 on the table. Senate File 1445, Senator Morrison, on the professional counselors establishment.
Mr. Chair, do we need to adopt the A5 for each compact, or?
No, we're going to
Okay.
take one big delete everything and put it on the shell of the last compact bill before us today.
Perfect. Thank you, Mr. Chair. So Senate File 1445 is the counseling compact. And the purpose of this compact is to facilitate the interstate practice of licensed professional counseling with, of course, the goal of improving public access to professional counseling services. And I can say more, but that is the gist of it. And I believe we'd also be adopting the A5 amendment on this compact like the others.
That's correct, Senator Morrison. Anyone in the room want to testify specifically in connection with the professional counselors compact proposal? Not seeing anyone. Any discussion from members of the committee? All right. So Senate File 1445 is laid on the table. Senate File 4076, Senator Morrison, Social Work Services Interstate Compact.
Thank you, Mr. Chair and members. Senate File 4076 is a social work compact. And this, like the other compacts, would allow Minnesota licensed social workers to get a multi-state license and practice in other states that have joined the compact. Unlike the other compacts we've heard today, this is a newer compact. And we hope to pass the bill this session so that Minnesota can be among the originating states to join the Social Work Compact Commission. All our neighboring states are pursuing the compact, and South Dakota has already joined.
Anyone else in the room wish to testify in connection with this bill? Not seeing any discussion from members of the committee? Again, Ms. Primo? I'm just asking if there's any discussion from members of the committee. I looked over your way and you thought I was inquiring of you directly, but I was not. All right, then Senate File 4076 is going to be laid over. Thank you, Senator Morrison.
Thank you, Mr. Chair, for a delightful visit to the Judiciary Committee.
Anytime, you are welcome here. Senator Bolden, Senate File 2656. All right, Senate File 2656 is being distributed. This is the Audiology and Speech Language Pathology Interstate Compact. Like the others, ignore the amendments that are in the packet. They will be superseded by the A5 that you already have. Senator Bolden, give us a 30-second description of what this compact will accomplish.
Thank you, Mr. Chair. Similar to the other compact bills, this would allow the practice. This one is for speech-language pathologists who provide services to remediate communication issues related to articulation, language, or voice impairment, and audiologists provide services to remediate hearing, balance, or ear problems. We would be joining 31 other states who are already currently in the compact.
Anyone in the room wish to testify in connection with this proposal? Not seeing any. Members of the committee, any questions or discussion? Not seeing any. Senate File 2656 is laid over.
Thank you very much.
Don't go anywhere yet, Senator Bolden. No, what happened to Senate File 2982? Completely different. Oh, all right. Crossing Senate File 2982 off the agenda.
Thank you.
Thank you, Senator Bolden. Senator Nelson, Senate File 2990, Dental Hygienist Compacts.
Thank you, Mr. Chair.
Senator Nelson, give us a 30-second description of this, the purpose of this compact.
Thank you, Mr. Chair. Well, this is another compact bill, as you're well aware of. You might want to know that this compact bill was developed in collaboration with Council of State Governments, National Center of Interstate Compacts, and the Department of Defense. And it is supported by the Minnesota Dental Association, the Minnesota Dental Hygienist Association, and the Association of Dental Support Organizations. This is the Dentist and Dental Hygienist Compact, which we have a severe shortage of, Mr. Chair and members. And I would be remiss if I did not thank my co-sponsors as well, Senator Bolden, Senator Utke, and Senator Morrison.
Thank you, Senator Nelson. Anyone in the room wish to testify in connection with this bill? Any members of the committee wish to comment or have any questions? All right, Senate File 2990 is laid over. Thank you, Senator Nelson.
Thank you.
Senator Kupik, you're back up. Circling back to you, Senate File 2394, Physician Assistant Licensure Compact.
Thank you, Mr. Chair. This compact, much like the other ones, the one difference is this is a brand new compact. Right now, currently, only 3 states, Wisconsin, Utah, and Delaware have joined. I think maybe one more, West Virginia or Wisconsin or Washington have joined while we've been waiting to pass this. It will need 7 states to get this going. 13 other states have additional pending legislation, but it operates much like all the other compacts.
All right, Senator Kupik. Anyone else in the room want to testify in connection with the Physician Assistant Licensure Compact Bill? Not seeing any. Any members of the committee have any specific questions or comments about this one? Senator Limmer.
Thank you, Mr. Chair. Senator Kupik, I only ask you this question because you're the last compact bill in front of us, and I can't ask anyone else the question. I see a lot of compacts here regarding health workers, but strangely missing is nurses. And I'm just wondering why nurses aren't, why there isn't a venture to include a compact for nurses. I visit a nursing home often, and we have traveling nurses that come and go at a huge expense, but they keep telling me, gee, I wish Minnesota would have a nurse compact. Do you have any, could you shed any light on that for us?
Senator Kupik.
I will tell you, Senator Limmer, if the nurses came to me and asked me to carry a compact bill for them, I would be happy to do that. That's, physician assistants came to me and asked me for this. It wasn't anything that I had a burning issue to go find physician assistants, but certainly if the nurses came to me, I'd be happy to carry that bill.
Well, I'll mark you down as a yes in the future then, Senator Kupik. I have no other questions, Mr. Chair.
Senator Kupik, you didn't leave yourself an out clause there. Maybe we
I
should
have to be
one-
the sponsor is the outlaw.
We should have one, we should have one drafted for you by council, I think. All right, so anyone else in the room? Any other questions or comments from the committee members? So here's what we're going to do. Senator Kupik is now going to be the chief author of the vehicle bill for all these compacts. That's Senate File 2394. Members, you have also been provided now with a copy of the A4 amendment, which is a delete everything. It's 156 pages. It includes all of the compacts that we've gone over here and just laid over on the table, and it includes the new liability language and venue language as well. Before we take any final steps here, I do want to thank expressly Ms. Primo and others who have been putting a lot of hours and effort into finding common ground on this liability and venue language that we had a lot of discussion on last time these bills came before this committee. I appreciate the work and the stakeholder agreement on this. So at this point, what we want to do is move the A4 delete everything amendment into Senate File 2394. Senator Umu Verbaeten makes that motion. Any further discussion? All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Now we have the Senate File 2394 as amended, and the motion would be to recommend it to pass and be re-referred to the Senate Committee on State and Local Government and Veterans. Any final discussion on that? Senator Umu Verbaeten so moves. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, everyone. We are done with our compacts here in the Senate Judiciary Committee for this year. So members, the next step here is Senate File 5337. This is the Governor's Public Safety Budget, Department of Public Safety and the Department of Corrections. Since I'm the chief author of the bill, I'm going to hand the gavel over to my vice chair, Senator Umu Verbaeten, and I can invite the commissioners who are present to join me at the testifier table to present their budgets. Why do I feel like
Senator
now
Lapp.
this is going to be a squeeze play on me?
There's a strategy.
And I'm probably the only one not armed, I don't know. Or with no access anyway to that protection. Well, members, I'm pleased to present to you Senate File 5337, which is the governor's budget. The intention is to hear the presentations, to lay it over for next week when we put our budget together. But I have with me our commissioners of those agencies, and so we'd ask if we can start with Commissioner Schnell. Can make his presentation, and then we'll go on from there.
Commissioner Schnell.
Good afternoon, Madam Chair, Chair Latz, and members of the committee. My name is Paul Schnell, Commissioner, Minnesota Department of Corrections. I want to thank you for the opportunity to provide a brief overview of the department's supplemental budget request for this session. For a quick review, we will go over this and we'll show it here, and I believe you have it in your packet as well. There are three parts to the DOC's budget request this year, and I'll speak to each one very briefly. First, the DOC has an operating adjustment request to accommodate for additional agency costs. including the essential compensation increases for our staff. Next, I'll speak to the federal 1115 Medicaid demonstration waiver, a proposal that the DOC is partnering with the Department of Human Services on to allow Medicaid to be billed for services within correctional facilities up to 90 days prior to release. And finally, the bill includes some minor language fixes in one section of the Minnesota Rehabilitation and Reinvestment Act. Members, the DOC's request for additional funding, the governor's supplemental budget proposal includes an operating increase of $7.9 million in fiscal years 25 and 26 and $14.2 million in fiscal years 27, 28. The need for this additional funding arises out of cost pressures within the department, the most significant of which are staffing costs. The DOC employs approximately 4,300 staff. Last year, labor partners in the state of Minnesota agreed to historic compensation increases. These contracts included essential increases for corrections staff, positions that were previously not competitive with like county and federal positions, and greatly contributed to staffing challenges we faced. Last year, before this committee, I testified that stabilizing our workforce was a necessity. We had conversations about staff safety stemming from understaffing, and while corrections work has associated risk, no matter the staffing levels, there is little argument that operating with a fully funded complement is the safest option. The department has used salary savings from open positions to the fullest extent possible. And while we have done all we could to only request what is absolutely necessary to accommodate for these increased costs, the cost pressures of compensation increases, workers' compensation, and healthcare needs of the incarcerated population have all collectively created a deficiency that required this requested adjustment. Members, as I previously covered with this committee, over the past 4 years, we have made enormous efforts to recruit corrections officers. Through these efforts, we have hired an unprecedented number of people to do that work, but we have retained less than half. In the past, we have had vacancy rates at some facilities like Stillwater and Oak Park Heights as high as 30%. To address these shortages and to ensure the safety of both staff and the facility and the incarcerated, we had to rely on overtime to fill security posts, and often this was forced overtime. Last summer, as mentioned, we negotiated contracts that changed the landscape for us. Pay is now competitive with county and federal pay scales for corrections officer positions. Today, a corrections officer at the Department of Corrections starts at $27.44 per hour, and that will increase to $28.67 per hour on July 1st. A year ago, the pay was $22.20 an hour. There are currently 157 officers in training, and we will be at 97% staffing level across facilities by mid-year. Members, the final portion of the DOC's budget request is included in the Department of Human Services request known as the 1115 Medicaid waiver. The 1115 waiver proposal originating from the Department of Human Services and the DOC as a central partner. We're happy to provide more information, detailed information on this later, but for now I'll provide a high-level summary as it relates to the DOC's budget. Members, as you are likely aware, when an individual becomes incarcerated, they lose health care coverage. And instead, their health care becomes the sole responsibility of the corrections institution, in this case, the state of Minnesota. The DOC has a constitutional responsibility to provide direct care to those within our custody. With the exception of some inpatient hospital care, federal law precludes Medicaid from covering health care expenses of incarcerated individuals, despite 90 to 95% of the DOC's population being Medicaid eligible. Incarcerated individuals shifting between systems of health care very often results in disconnection from treatment, which leads to worsening overall health. For people with mental health conditions and substance use disorders, this inconsistent health care coverage can have grave impacts. Recent data confirms that drug overdose is now a leading cause of death among formerly incarcerated individuals. Those recently released from prisons and jails are up to 40 times more likely to die of an opioid overdose than the general population. This 1115 waiver proposal aims to curb these numbers by facilitating a smoother transition from physical and mental health care services inside facilities to those outside. In April of 2023, the Centers for Medicare and Medicaid Services, CMS, announced a new Section 1115 demonstration that allows states to partially waive the inmate exclusion and provide Medicare coverage shortly before reentry into the community. Through this program, when state savings are realized after Medicaid reimbursement, those savings must then be reinvested in expanding the program and treatment options. The Minnesota Department of Human Services has been studying and developing a proposal to include Minnesota in this waiver. DHS is requesting legislative approval and funding through CMS for the program and support Medicaid-eligible populations in both jails and prisons 90 days prior to release. In coordination with DHS, and in order to implement the 1115 waiver program at 3 DOC facilities, the DOC will require staff and a new billing system because the DOC does not today bill insurance or Medicaid for any health care services, and this endeavor will create a new line of work and processes for the department. The governor's supplemental budget request includes $1.7 million in fiscal year 24-25 and $4.3 million in fiscal year 26-27 for corrections. During the initial phase of the process, the state will establish system infrastructure and staffing to implement the program at 3 DOC facilities, 4 county jails, 2 juvenile detention facilities in Minnesota, and 1 county jail that incarcerates a significant number of Native Americans. We are excited to partner on this interagency proposal and its potential to better serve the needs of incarcerated individuals reentering communities from both county jails and state prisons. And I should add that the Minnesota Sheriff's Association and county sheriffs across the state are excited and supportive of this proposal. Of note, the 1115 waiver DOC budget request will be picked up by the Health and Human Services budget target, and it is not included in public safety. Members, as you are aware, one of the most substantial initiatives the DOC is working to implement is the Minnesota Rehabilitation Reinvestment Act, or MRA. As you may recall, the MRA is an earned incentive, an emphasis on earned, or incentive early release program. It is focused on evidence-based interventions targeted at reducing the reduction in risk and reoffending, which means a reduction in crime. As part of the implementation, the DOC is requesting 2 technical corrections to the statute to be included in the supplemental budget bill. The first of those clarifies that incentives apply to supervised release, conditional release, ensuring that clarity that earned compliance credits and supervision abatement status extend to both supervised and conditional release term makes sense and streamlines the administration of MRA. Secondly, the language updates the reinvestment portion of the bill. While nothing changes with where the savings are reinvested, as the MRA was being debated last year, the legislature, as you will recall, also amended the statute governing how the state funds community supervision and probation. This change simply aligns reinvestment with the supervision delivery process and the supervision formula that was created by the legislature last year. I also want to note that you will see language in the budget bill that will formally separate the newly created Clemency Review Commission from the DOC, including shifting the funding appropriated to the commissioner of the DOC to the entity that was created last year. Thank you again for the opportunity to present the DOC supplemental budget request. It is the nature of the work of corrections that is often out of sight and out of mind for many in the public. I want to thank you for your leadership in helping to ensure accountability and to improve outcomes in Minnesota's corrections system. It is greatly appreciated and makes a difference. With that, I can stand for any questions you or the committee may have. Thank you.
Thank you, Commissioner. Any questions? Okay, we'll move to Commissioner Jacobson.
Madam Chair, members of the committee, thank you for the honor of being here today. My name is Bob Jacobson. I am the Commissioner of Public Safety, and it is my honor to serve in that capacity. I'm here today to give you a brief overview of the governor's supplemental budget for the Department of Public Safety. I think you have a packet in front of you that will have the slides. I'm also joined in the audience by our OJP Director, Kate Weeks, and our State Fire Marshal, Dan Cryer, who can provide any additional details or answer questions as needed. On the second page of that presentation, under the State Fire Marshal's Office budget, the governor is recommending updating the non-responsible party fund to include all state emergency response teams. This would add the Urban Search and Rescue and Minnesota Air Rescue teams. These teams are local fire departments and state patrol contracted through the State Fire Marshal's Office. Those funds have been provided from the fire safety account for incidents when a responsible party cannot be located and billed for services. This bill would also provide a definition of urban search and rescue updated to match nationally recognized language. The last page of the presentation reference Office of Justice programs. Our crime victim services funding covers advocacy and direct services for sexual assault, domestic abuse, child abuse, and other crimes such as homicide, gun violence, assault, and theft. Those crime victim services are a critical need in every community, and they're available to support survivors through crisis intervention, advocacy, applying for protective orders, safe housing, transportation, accessing financial assistance, court-related support, accompaniment to hearings and appointments, support groups, healing services for as long as the individual or the family is in need, a wide array of services. OJP, as you are aware, has heard from multiple organizations that additional funding is needed for those services throughout the state of Minnesota. The governor is recommending an additional $10 million to help support those critical services provided by crime victim services across Minnesota. Additionally, with youth intervention programs, also often referred to as YIPA, we have a grant administration amount set in statute at 2%. In order to ensure that all of our Office of Grant Administration and OLA requirements and guidance are being met, the governor proposes to raise this to match the new state standard established last session, which allows state agencies up to 10%. This proposal also ensures a successful transfer of YIP over to the new Department of Children, Youth, and Families on July 1st, 2025, by ensuring that that program administration will be properly funded. So thank you for allowing us to present today and considering our supplemental budget requests, and we will stand for any questions. Thank you.
Thank you, Commissioner. Any questions? Senator Westlin.
Thank you so much, and I appreciate that we are making an additional investment in crime victim services. As I'm sure we all know, our especially domestic abuse providers, service providers, are really struggling in the state. And are these funds that they are able to apply for in terms of grant money?
Commissioner Jacobson.
Yeah, thank you, Chair, members of the committee. I'm not sure if I understand the question, but
Senator Westlin.
I'll give it another go.
yeah.
We have a number of service providers who assist victims of domestic abuse in the state. They are so woefully underfunded right now and kind of in crisis. Are those service providers for victims of domestic abuse able to apply to receive some of this victim services grant money?
Commissioner Jacobson.
Thank you, Chair, members of the committee, and Senator, yes, I believe that is accurate. And as you have heard and have seen, there have been numerous incidents, high-profile incidents around the state of Minnesota that have caught all of our attention, much related to domestic abuse and violence. So thank you.
Okay, seeing no other questions, Senator Latz, what's the plan for the bill?
Madam Chair, members, the plan is to lay this over, and we'll put a budget bill together next week.
Okay, well, the bill's laid over, and since I'm up here, I'm going to suggest we go to Senate File 4258 next, which is Senator Mann's bill, but I'll be presenting for her.
Thank you so much. Thank you, Commissioner. Appreciate it.
Yeah, you can go on there. Senator Patty will go first, and then Councilmember Gaviria.
Thank you.
All right, Senate File 4258. Members, the packet has been distributed to you. This is the first committee that is hearing this bill. There is an A1 Authors Amendment. Senator Mover Baton moves adoption of the A1 Authors Amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment's adopted. Senator Mover Baton.
Thank you, Mr. Chair, members. I know Senator Mann's very passionate about this bill and is unable to present today, but I'm very proud to stand in her place for this bill. Senate File 4258. As amended, it provides resources and general guidance to the Commissioner of Public Safety to develop a report with preliminary research and recommendations to reduce, prevent, and end violence against Latino women and girls, including queer Latinas in Minnesota. Mr. Chair and members, we started work a few years ago to address the violence impacting Black women and Indigenous women in our state. I was very proud to support that work, to be a part of it as I came here, and I'm very honored to be a part of continuing this work that was initiated by Senator Kunish, former Senator Torres Ray, Representative Richardson, and of course members of this committee. We need this because we have a serious problem in Minnesota, and according to a recent report about the status of women and girls in Minnesota written by the Women's Foundation of Minnesota and the Center on Women, Gender, and Public Policy at the Humphrey School of Public Affairs at the University of Minnesota, women of color continue to face serious challenges related to poverty, discrimination, violence, harassment, and exploitation. I'm particularly alarmed by the growing rate of reports from young women who are experiencing violence. 12% of 11th grade girls in Minnesota report sexual abuse at some point in their life. Indigenous girls, 19%, and Latinas, 17% report the highest levels of abuse. There should be reports available in your packets and really encourage folks to look through those. This bill will provide resources to do a preliminary investigation of the problem, and it also asks for recommendations to prevent gender violence. And I'm particularly interested in the prevention component of the bill. Esperanza United, an organization that's been advocating for this bill, has 45 years of experience in the field of domestic violence, and they are now focusing their work on prevention. We know that finding ways to disrupt the pathways toward gender-based violence is key, and to change these alarming trends, we must prevent abuse and violence before it occurs. Thank you all. I hope you're able to support this bill. I'm happy to answer questions, but we also have testifiers here today who will provide more information, and I think we can start with our president and CEO of Esperanza United.
Thank you. Good afternoon. I had
Good
good morning
afternoon.
on here. Good afternoon.
Welcome to the committee.
Mr. Chair and members. My name is Patty Tototzintle, and I am the president and CEO of Esperanza United. And I want to thank you, Senator Mohamed, for presenting the bill. Esperanza United is a nonprofit organization that began serving women who experienced domestic violence formally in 1982 under our former name, Casa de Esperanza. For over 40 years, we have been offering these critical services ranging from shelter and safety for survivors to strengthening youth leadership and expanding prevention services. The senator is right. She's correct. Latinas face significant challenges in our state, and current reports show that the numbers are not getting better. Since the outbreak of COVID-19, emerging data and reports from those on the front lines have shown that all types of violence against women and girls, particularly domestic violence, has intensified. Latina women, their children, and their families have largely been ignored in public policy conversations, and we truly don't have a good system of prevention across the state capable of responding to the complexity of the problem. Latina women are enduring significant violence and harassment alone. They are ignored and isolated because they face language barriers, poverty, isolation, and immigration status barriers. Latinas are often young mothers with children who depend economically on their abusive partners and thus are unable to get away from the abuse. We are very grateful to the attention you've paid to these issues in recent years. You've moved two important initiatives to review the high incidence of violence that impact the Black and Indigenous communities and women, and thank you for that. We also support those efforts. But we are here to ask that you review the problem impacting Latina women, and we ask that you please support this bill. Prevention works, especially when we are able to work with young people and connect them to resources and provide leadership and community-related opportunities. The opportunity to learn more and provide insight on effective prevention strategies to Latinos serving, that's not just Latino organizations, but those who serve Latinas, advocates, and community members across the state is so greatly needed. Please partner with our community and invest some resources to prevent violence in our communities. Thank you, Mr. Chair and other members, and I'll be happy to answer questions. I know my colleague, the wonderful council member here, is also going to testify today.
Thank you, Ms. Tototzintle. Appreciate your testimony here today.
Thank you.
Councilmember Garrido, welcome to the Judiciary Public Safety Committee.
Thank you, Senator. Mr. Chair and members of the committee, thank you for the opportunity to testify in favor of Senate Bill 4258. I'm pleased to be here. My name is Heidi Garrido. I am a council member for the City of Hopkins and a project coordinator for the City of Minneapolis. In both of my capacities as an elected official and a government employee, I'm also a Latina woman and am fully aware of the challenges and needs facing Latina women in our state. I'm alarmed about the growing poverty and discrimination many Latinos and Latinas face in our state, but I'm also aware of the progress and contributions that we make here. Women of color in Minnesota are facing higher incidences of sexual violence and rape, and according to the most recent statistics from the CDC, about 36% of women who report sexual violence in 2022 were young Latina women. Young Latinas are reporting sexual abuse inside or outside of their homes. 11th grade Latinas report the highest level of abuse, and I'm told that Senator Mohamed gave us that statistic. One of the most serious statistics that we are reviewing now is the high incidence of abuse, harassment, and violence that Latinas are experiencing in the workplace. According to data from the National Human Trafficking Hotline, 47% of victims of trafficking and labor exploitation are Latinas. I strongly support efforts to review the needs of Latinas living in rural areas where they don't have access to systems of support or organizations to support them and their children. Nearly all Latino population growth in our state has occurred in counties outside of the metro area since 1980. Latino population growth in the last 20 years accounts for over 90% of the Latino population in 6 of 7 countries, most of them in the Southeast region. Future generations deserve an opportunity to grow free of fear and violence in their lives. Thank you, Mr. Chair and Senators, and I ask for your support of this bill.
Thank you, Councilmember Garrido. Appreciate your testimony. Is there any other testifiers in the room who wish to come forward and be heard on the bill at this time? This is a budget proposal, so we'll anticipate laying this over for possible inclusion in the budget bill next week. But one thing we'll have to do as we determine how to fund proposals when we don't have as much money as we have proposals is, and in this one in particular, because we've had a series of requests along the way here in the last several years dealing with more specific cultural communities and focusing on violence in those communities. Can you help me, and you've touched on some of it, can you help me understand how this community is unique in that it needs a specific focus of analysis and report, distinct from other more broadly based gender violence or anything like that?
Yes, the reality is that, thank you, Senator, for that question, Mr. Chair. The reality is that the Latino community is very diverse. It's diverse across the state. It can include many multiple languages depending on how many indigenous Latinos there are in the state. And of course, there's the language barrier of English and Spanish. The one thing that this bill really focuses on, it does not mean that intervention is not needed. And we all know that crises have occurred and continue to occur, and obviously we respond to crises. But this bill is also looking at prevention and the types of prevention strategies that include broad-based, community-based prevention strategies for men, for women, for youth, for families, that can really make a difference in the lives of our families and communities across the state. And we know from the work we've done, we have been focusing on prevention for so many years that we know it can make a difference. And I think that's one of the differences that we're trying to include, because that's a Latino community related strategy. It's a cultural strategy that we believe can work. And that is one of the differences that we believe is a reason for us to be putting this forward.
Mr. Chair.
Senator Umover-Baden.
Did you want to say something? Thank you, Mr. Chair. I just wanted to add to that, and I think the President spoke very well to this, but just as someone who is very supportive, so grateful for the work that we have done on, addressing the violence that Black women face and that Indigenous women face, right? As a woman of color, as a queer woman, as someone who's the daughter of an immigrant, like, our communities face similar challenges, but we also face different challenges. And, President spoke about immigration barriers, language barriers. There are some things that are going to be very specific to our Latina community that need to be addressed and that this report could surface. So I just want to share, as someone who holds similar identities but also recognizes that sort of difference and need for a unique approach, that it's important for us to show solidarity and really make sure that this community gets the support that they deserve and gets this report.
Thank you. Any other members of the committee have any questions or comments? All right, members, Senate File 4258 will be laid over for possible inclusion. Thank you so much.
Thank you so much. I heard that, my president. Thank you.
All right, next up, Senate File 2759, Senator Westlin, group of family law proposals. Senator Westlin.
Thank you, Senator Latz. We are affectionately referring to this as the family minibus, not to be confused with the family minivan. I'm here all week. So I believe, Mr. Chair, we have the A7 amendment. I believe that is.
So, members, this is the first committee stop for this bill. The A7 amendment is an author's amendment. It's to delete everything. Senator Weston moves adoption of the A7 author's amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Weston, what's in your bill?
Thank you, Mr. Chair. So you will recall at the very late night Judiciary meeting not so awfully long ago, we heard a variety of family law provisions, including some provisions by Senator May Quaid, and her provisions have been adopted into this A7 amendment, with the exception of her provision initially included references to surrogacy, and those have been removed. So her bill on assisted reproduction regarding parentage issues is what we're calling sort of the skinny version, and it only refers to in vitro fertilization in terms of the method of assisted reproduction. Everything else has been heard before. In essence, we have several family law provisions dealing with priority for temporary relief for cases where there has been denial of parenting time or where a party is being denied access to financial resources during a pending marital dissolution proceeding. There is an update to language regarding attorney's fees. This is in Section 5. This allows for an award of attorney's fees in family law proceedings. We have also made it quite clear on page 5, lines 5.21 to 23, that in custody determinations, the court should not consider gender solely in determining custody and parenting time provisions. I will tell you in practice that is what we do, but we are clarifying that language. We are also including some languages regarding spousal maintenance. The spousal maintenance continues to be one of the most litigated parts of family law. It is a little bit of the Wild West, and the purpose of this provision in Article 2, which is on page 11, provides some more concrete guidance for courts and practitioners who need to advise their clients. We also have updates to the antenuptial and postnuptial language, which is found in Article 3 on page 20. And again, we heard all of these matters in Judiciary Committee a few weeks ago. None of those items have changed, but we have now added in, again, Senator May Quaid's Article 4 regarding assisted reproduction and parentage to complete this family minibus package of bills, and I'm happy to answer questions.
All right, Senator Westlin, did you anticipate any testifiers in connection with your bill?
I did not. We took testimony previously, and so I think the intention was not to take testimony again because the bills have been previously heard, simply repackaged.
Right. So, but let me just, as a matter of courtesy, see if there's anyone here who has anything they'd like to add to the proposed testimony that's already been heard by this committee on these bills. Not seeing anyone come forward. Any discussion from members of the committee? Not seeing any discussion. Then Senator Westlin moves that Senate File 2759 as amended be recommended to pass and be sent to the Senate floor.
Correct.
All those in favor say aye.
Aye.
Aye. Opposed?
Aye.
Motion prevails. All right. Thank you, Senator Westlin. Let's do that. We're going to take up Senate File 4200, Senator Limmer.
What's that?
I planned a couple minutes, not any more than that.
Yeah, that's fine.
Hello, Judge. How are you?
Just fine. Good afternoon.
Good. Welcome to the Judiciary and Public Safety Committee. Senator Limmer, Council has an A7 amendment that they are prepared to distribute if you would like to have it distributed now. And then we can just focus on everything together. Would you like that?
Yeah, that'd be fine, Mr. Chair. But I also have an oral amendment to add to that particular amendment.
Okay, so let's, this is our first committee, Senate File 4200. There is an A6 amendment. I assume the plan is take the A6 and then, does the A7 go into it?
Mr. Chair, I believe it's an A7 amendment.
But the A7 will go into the A6. So why don't we distribute the A7? We'll consider putting that into the A6. You can amend the A7 with your oral amendment. Then we'll incorporate it all into one author's amendment. And then we'll have the bill in the shape that you'd like us to consider.
Yeah.
How's that sound?
Would you like me to introduce the oral amendment first to the A7 at this time?
Let's make sure that's distributed so we can all follow
All right.
it. Okay, very good. So Senator Limmer, we're going to put the A6 amendment before us. We're going to ask if you would like to incorporate the A7 into the A6 as the author of the amendment.
Yes, I would, Mr. Chair.
All right, so the A7 is now part of the A6 amendment by the author's incorporation. And then, Senator Limmer, you have an oral amendment that you would like to insert into the language that's contained in the A7 amendment. Why don't
That's
you tell us
correct.
what your proposed oral amendment is?
Mr. Chair, I would like to move on line 1.16 of the A7 amendment, after the apostrophe, include the words that provide data support services to law enforcement, period. I believe perhaps the apostrophe would be at the very end of that new sentence.
So, Ms. Primo, you want to repeat that for us?
Mr. Chair and members, sure. So on the A7, line 1.16, after vendors, insert that provide data support services to law enforcement agencies, just adding the word agencies there, I think that's the
That would be
intent.
fine.
Yep.
All right, Senator Limmer, as the author of the amendments, incorporates that into his A6 amendment. And so now, members, we have it all together procedurally in the A6 amendment. This is an author's amendment. Senator Limmer moves adoption of the A6 amendment as amended. All those in favor say aye.
Aye.
Aye. Opposed? Motion prevails. The amendment is adopted. All right, Senator Limmer, tell us about your bill.
Well, thank you, Mr. Chair. I don't know if everyone on the committee knows this, but you gave me an assignment.
For which you are forever grateful, I can tell.
Well, I'm thinking about it, Mr. Chair. It's been a challenge to protect the information, the personal information of our judiciary in Minnesota. And I want to thank you for this opportunity. I actually enjoyed the project. However, the safety of Minnesota judges, including referees and magistrates and members of their household, are put at risk by the dissemination and perpetual internet access of home addresses and personal information. The bill before you, dubbed the Judicial Safety and Privacy Act, I hope will alleviate these safety concerns. This legislation was worked on by a collective effort by the Minnesota Judicial Branch. It's legislative priority. It is a legislative priority adopted by the Judicial Council and the Minnesota District Judges Association. The bill does several things. It makes personal information of all judicial officials collected, created, or maintained by a government entity private data on individuals. It prohibits a person, business, association, or government from publicly posting or otherwise making available on the internet the personal information of any judicial official unless it falls into one of a number of exceptions outlined in the bill. For example, if the information is displayed as part of a news story or other speech on a matter of public concern, or if the judicial official voluntarily disseminates the information publicly. And I want to insert here, there is a real estate property exemption included in the bill. Real estate experts from the Bar Association, County Recorders Association, Land Title Association has raised serious concern with the bill that was originally introduced, that it would cause significant marketability of title issues, not just for anyone intended to be covered by the bill, but also for any Minnesotan who happens to have the same name as someone who's intended to be covered. Another area, similar concerns were identified when the Safe at Home program was first enacted. Back then, it took about 6 months of diligent work by stakeholders to modify the program to protect integrity and accessibility of real property records. Also, similar work is necessary with this proposal. So the amendment exempts real estate property records to allow time for our stakeholders to craft workable language in the future that we can then consider in sessions to come. But getting back to the overall language, the bill allows for judicial official to request the removal of information posted on the internet by filing a sworn affidavit and serving it on the entity posting the information. If not removed, the judicial official can seek a court order compelling compliance. The bill creates a misdemeanor penalty for knowingly publishing the personal information of a judicial official with the intent to threaten, intimidate, harass, or physically injure. The bill also creates a felony penalty if they would cause bodily harm. This bill is important given the uptick both across the country and here in Minnesota of attacks, harassment, threats, and in some cases harm against judges and family members of judges. And I have today Judge John Gustafson, who will provide additional background on the need for this legislation. And together we'll try and answer your questions.
Thank you, Senator Limmer. Judge, when you're ready.
Yes, thank you, Senator.
Identify yourself.
Good afternoon, and also committee members. My name is John Gustafson. I'm a district court judge serving in the 2nd Judicial District, which comprises Ramsey County. I've been on the bench since 2008. I'm the former chief judge of the 2nd Judicial District, and I served on the Minnesota Judicial Council for 4 years. And before then, I was in private practice for 27 years. It's my privilege to speak to you today in two capacities. I'm here on behalf of the Minnesota District Judges Association, which comprises over 300 judges across Minnesota at the district court, appellate court, Supreme Court level. Also many retired and senior judges. I'm also on the Judicial Council's Legislative Advisory Work Group, which identified this issue as a key issue to bring to you this year. Thank you, Chief Judge Limmer, or Chief Author Limmer. See how easy it is to get me to report to somebody? Chief Author Limmer, who went over the bill and its key components. So moving on from that, I'd like to share with you the overwhelming importance of this bill to both the judicial branch and Minnesota citizens, and help you appreciate the concerns over safety in our state. These issues place our independent judiciary at risk. It's also impacting our ability to attract the interests of lawyers for open judicial seats. Applications have fallen significantly in recent years, and safety is one of the issues that we believe is influencing that. One of the things that distinguishes the United States from many other countries around the globe is respect for and enforcement of the rule of law. The principle is a bedrock of our democracy. The rule of law exists through service of independent judges who protect our rights by performing their duties impartially, without fear or favor. Threats of violence are often directed against judges these days, so unfortunately in today's environment, judges and their staff and families have plenty to fear. Judges rank #1 for targeted attacks against government officials in the United States. The number of targeted attacks at the federal level doubled between 2021 and 2023. Our own survey of judges here in Minnesota reveals the same. We've prepared a handout that I hope was issued to you that contains some of that data. I'm not going to go over it here today in the interest of time, but death threats, posting of children's pictures on the internet. Personally, myself and a number of our staff and other judges received at their homes what purported to be a $3.5 billion lien on their home residences. Twice in the last year, I've had to be escorted out of the courtroom because of potential threats. Once a fist fight. My staff and I were all escorted to our cars after someone attempted to bring a gun back into the courthouse after I sent somebody to prison. So you can see our bench has important safety concerns. This bill is patterned after the federal Daniel Anderl Safety Act that passed overwhelmingly in Congress with bipartisan support, which I think is notable these days. The bill is named after the adult son of a federal district judge who was murdered in his own home. And shortly after that law was passed, a Maryland state court judge was murdered on his driveway. You may have all heard of that. New Jersey has passed a law patterned after the Anderl Act, which the statute before you now is patterned after the federal act as well. So we're all on notice that this is happening, that it's significant, that it's a growing threat. And I'm hoping that you will approve this bill, move it on, pass it when it gets to the Senate floor, voting yes for judicial safety and to preserve our independent judiciary. And of course, I'm open to questions.
Thank you, Judge Guthman. Appreciate your testimony today. I'll also note that I was contacted several months ago by a federal judge here requesting this as well. So there's been lots of communication and concern on the bench about these issues. Is there anyone else in the room that wishes to testify in connection with this bill? Council has a technical amendment to bring up for us. Ms. Primo.
Mr. Chair and members, it would be to the A6, page 1, line 25, after section insert and section 480.45. And this would clarify that the definitions in this section apply to the next section in the statute in section 3.
Mr. Chair,
Senator Limmer.
Council, would you consider that a technical amendment?
Ms. Primo.
Mr. Chair and members, yeah, it's a technical clarifying amendment.
Senator Limmer.
I would move the amendment as described by council.
Any discussion? All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment's adopted. Any further discussion? And Senator Kroon.
Thank you, Mr. Chair. Support the bill as amended. Very important topic. I just wanted to note for the record and that when I knew that the real estate part of this was going to be challenging, but until diving into it, I didn't realize how challenging the real estate part of this is going to be. And immediately I thought, well, the Safe at Home is a model that we can use, but I didn't realize the numbers of people that this is going to be cover is way more than the enrollees in the Safe at Home. So as we move forward with the real estate part of this, there's going to be a lot of heavy lifting and work that title lawyers, the Bar Association, Land Title Association, recorders are going to have to do. So I want to thank them publicly in advance because it's going to be a lot of work to try to incorporate real estate into this.
Mr. Chair.
Senator Limmer.
Mr. Chair, Senator Kroon, you're absolutely correct in characterizing the difficulty that will be in the future. The Bar Association has been a tremendous partner in trying to define and modify this existing bill. We can't go as far as some would want us to go in the short time period of this legislative session. I remember going back, and I think I made comments earlier that the Safe at Home program, which is a prospective program, you have to move somewhere and then lock in the location of where you're at. That took at least 6 months just to get the program started, let alone placing participants in it. And so my hat's off to the Bar Association, Brian Lake in particular, and those that were involved in the title associations and the other real estate entities. They've really been a tremendous help and helped us understand how big a task it is.
Any further discussion?
Mr. Chair, one last thing that I wanted to leave on the record if there's any question. I was asked, what's the government's interest in wanting to move forward in this? And I think it's quite simple when you think about it. It's to protect and preserve the impartiality of the bench. That's vitally important for our society, vitally important for our judges to be clear-minded and focused and not having to worry about threats at home. Their jobs are difficult enough, and we hope that this will move in the direction of preserving the independence and the impartiality of the judiciary.
And Senator Limmer, I know this assignment, as you put it, turned out to be a lot more work than you expected, and I appreciate your taking it on and the good work that you've done with it.
Thank you.
Any further discussion? There's no fiscal note on this, is there? Here's Mr. Turner.
There was a fiscal note, no cost.
Fiscal note shows no cost. So we have a choice, Senator Limmer. We can send this independently to the floor, or we could roll it into our omnibus bill.
Mr. Chair, I think
Chief author, your choice.
I think your omnibus bill is getting too big anyway, so I would prefer it going independently.
All right. I will work with you and leadership then to find time on the floor
I appreciate that.
to take this up independently.
Right.
Senator Limmer moves that Senate Bill 4200 as amended be recommended to pass and be re-referred to the Senate floor. All those in favor say aye.
Aye.
Opposed? Motion prevails. Thank you, Senator Limmer. Judge Gustafson.
I was waiting for the tough questions.
too. That works too, right? Timing's everything. I agree. Thank you very much. Yeah. All right, members, we're going to take up Senate File 4271. That's the Omnibus Judiciary and Public Safety Policy Bill. Members, we're going to assemble our committee's policy bill at this time. You will have in front of you the chair's recommendations, and then we will have an opportunity to discuss the contents of that particular bill, as well as a variety of additional amendments that we will consider, that will be considered separately. So at this time, I'm going to give the gavel over to Vice Chair Mohamed Baden.
Senator Latz.
Yes. All right, Madam Chair and members. Senate File 4271. The original introduction is a very small shell of a bill. What you have with you in the form of the A9 Delete Everything Amendment is the assembled proposed chair's recommendations at the time the A9 amendment was prepared for the omnibus policy bill from this committee. It contains a whole lot of bills that this committee has heard throughout this legislative session, which I thought reflected general support within the committee, and that I felt, in my personal opinion, ought to become law. That's all, of course. That's how I make my recommendations. It's up to this committee how you'd like to address those questions. So for starters, I'd like to move as an author's amendment, the A9 Delete Everything.
Senator Latz moves the A9 Delete Everything amendment. All those in favor say aye. Aye.
Aye.
Opposed? Okay, the motion prevails. Amendment's adopted. Senator Latz.
Members, the staff summary, which was also distributed, to you lists all of the content of the bill. I guess I'll give you a sort of a higher level overview. I'd ask you please to read through the staff summary as well. And then I look forward to our conversation. Members, the bill, and I'm not sure if this is in the same order that's contained in the A9 or not, so I'm just going to kind of run through it in the order that I have it here. Well, maybe I'll use the staff summary for my order. I think that'll be easier for everyone to follow. Members, the first section contains law enforcement provisions. The sections 1 and 2 change the name of, oh, this is even easier. I got a spreadsheet in the same order. Article 1 changes the name of the Police Excellence and Improving Community Relations Advisory Council to the Public Safety Advisory Council. That was my bill. Next portion is Senator Abler's bill relating to Anoka County, authorizing the county, if they choose to do so, to build a jail and criminal justice center outside of the county seat. The next article on corrections contains my file on the State Correctional Facilities Security Audit Group membership. The next portion of that is my bill relating more generally to corrections. Contains quite a number of provisions in there, including some data sharing for sentencing adjustments, correctional officer use of force, electronic filing of detainers, disclosures to the victim of offenders' city and zip code of residency, or relocation after release from incarceration, discontinuing a report relating to medical conditions for the challenge incarceration program, membership relating to health care peer review committee, use of jail inspection data, medical director designee information, supervised release board private victim input for their consideration, changing some dates on a probation report, a local advisory board for community supervision and probation services. The next bill addresses a release of certain inmates modification terms. Next bill is Senator Uma Verbaten's bill relating to some technical corrections to the felony murder aiding and abetting statute we passed last year. Article 3, criminal provisions, contains Senator Uma Verbaten's bill on controlled substance laws, modifications, Senator Westlin's bill prohibiting the sale of human remains for commercial purposes, Senator Pappas's bill conforming age range for hiring a minor to engage in prostitution. That's more of a technical related bill. Senator Morrison's bill relating to immunity for individuals who seek medical help for a drug-related overdose, expanding that beyond just one individual, but others also that are participating in trying to protect a person they fear is overdosing. Next section has my bill relating to first-degree witness tampering in violent crimes cases. Article 3 continues with Senator Howe's bill requiring a report regarding the sentencing of certain military veterans. This has to do with the Veterans Restorative Justice Act, so we can gather more information on how it's working and how effective it's been. Senator Uma Verbaten has a bill in there limiting probation length for certain attempted crimes. Senator Housechild in Article 4 has a provision relating to the purposes for which a grant to the Grand Portage Band of Lake Superior Chippewa may be used. Senator Cruin's bill relating to the revocation of stay provision for certain stays of adjudication and deferred prosecutions. Senator Uma Verbaten's bill relating to victim notice and input at the end of confinement review process conducted by the Department of Corrections. Senator Gustafson's bill relating to sexual assault prevention grants. Senator Rarick's bill relating to predatory offender system data collection. Senator Marty's bill with technical amendments for the scrap metal dealer and catalytic converter bills that we passed last year. Senator Carlson's bill establishing uniformity for impaired drivers' revocation of licenses. Next, Article 5 contains my bill relating to standards for petition for post-conviction relief based on newly discovered evidence, expanding the time limit to respond to those petitions as well. Senator Umover Baton's bill relating to admissions and judicial proceedings of certain custodial statements. Those are the statements that were obtained during inquiries that relied on falsehoods stated by the inquiring or investigating officers. Senator Champion's bill relating to criminal record expungements, some minor modifications there. Senator Kroon's bill clarifying in rem jurisdiction for judicial proceedings. My bill relating to the name of the Competency Attainment Board, changing that from the Competency Restoration Board. Senator Pappas's bill relating to definition of child in need of protection or services. Article 6, a judicial branch policy, contains, I think, just the general, oh, that's the shell. That's the shell bill, Senate File 4271, that's in front of you. Article 7, Senator Dibble's bill relating to guardians. It contains Senator Kroon's bill, looks like again we've got relating to in rem jurisdiction. Not sure if that's a duplicate provision or if that's related provisions. Also Senator Limmer's bill relating to property insurance for grantee beneficiaries on transfer on death deeds. Other civil law provisions include Senator Mitchell's bill relating to the open meeting law. I'll refer you to that. It is a portion only of the bill that she presented to us in committee. Senator Lang has a bill in there relating to orders for protection. And that was the one that deals with notifying custodians of a petitioner's minor children of any changes in the order for protection. Senator Westlin's bill relating to the Uniform Public Expression Protection Act is there. Senator Pappas's bill permitting clients of civil legal services and volunteer attorneys to proceed without payment of court fees without additional findings relating to informa pauperis. Senator Kroon's bill increasing the conciliation court claims monetary jurisdictional limit up to $20,000. My bill relating to collateral source calculations and contributory fault modifications, only Section 1 of that bill. Senator Mohamed has a bill in Article 9 relating to contract for deed requirements between investors, sellers, and purchasers of real property, a modification that was designed to address situations where investors, sellers are getting unsophisticated buyers into contracts for deed and then finding opportunities for declaring them to be in default and foreclosing on the contract for deed and capturing the equity there. So that is what is in the A9 amendment, members. And Madam Chair, when you are ready, I'm happy to get into more detail on any of those provisions for members. And also, we have a series of amendments I'm prepared to entertain as well.
Thank you, Senator Latz. I think it might be helpful to see if there's some questions based on what's in here. And then I know we'll have a number of amendments to walk through, and some we're going to have a little bit of testimony on as well. But I'll go to members first and see what questions they have on the A9DE. Okay, seeing none, I think we can move to amendments. Did you have any that you wanted to begin with? I know I have a number and may need to ask Senator Pappas to chair to get through those, and there's some other amendments that other members are bringing forward as well.
I'm ready to take on whatever amendments you're ready to take on.
Okay, Senator Umuver-Baton.
Thank you, Madam Chair. If we could begin with the A6 amendment. This, I'm happy to explain while it's being passed out. The
Senator Umuver-Baton, I'm sorry, what's the bill number, the amendment number?
A6, Madam Chair.
The A6, okay, thank you.
Okay.
We have the A6 amendment.
Thank you, Madam Chair. The policy omnibus does include the, what was my underlying bill, 2495, around banning the use of deception and interrogations. There's been ongoing conversations with Great North Innocence Project, law enforcement, and the changes in here do reflect some of those conversations. We are striking the juvenile court official because we weren't aware of any situations where a juvenile court official would be conducting an interrogation, so that language just wasn't necessary. That's sort of the first change, and then those two additional paragraphs that you'll see are just providing further clarification that inadmissibility doesn't apply to statements if they occurred prior to that first instance of the deception, and then it doesn't impact admissibility of statements discovered through independent lawful means. So I think this is helpful, provides more clarification on that bill.
Is there any discussion on the A6 amendment? Any comments from Senator Latz?
I consider that to be a friendly amendment.
All right, all those in favor of the A6 amendment, say aye.
Aye.
All those opposed, nay. Motion prevails. The A6 amendment is adopted. Senator Umuver-Baton, you have more? You have this whole pile?
No, that's just everything.
Okay, got it. Are there any other amendments?
Yes, Madam Chair. I have
Senator Umuver-Baton.
Thank you, Madam Chair. I'd like to offer the A12 amendment, and I do have some testimony on this. So again, the bill does include some pieces on post-conviction relief. Senator Latz had a bill, I had one. This is sort of combining the components of both of those bills, making sure they're in our policy omnibus. There's a technical clarification here in the A12 amendment that the court can hear a petition regardless of when it's filed if it's not frivolous and is in the interest of justice. And I think our testifiers can speak to that as well.
We have a testifier in the audience to speak to this amendment.
Should we sit here?
Yes, that's fine.
How are you?
And please just identify yourself for the tape and proceed with your testimony.
Good afternoon, everyone. My name is Linus Chan, and I'm here representing the Decriminalizing Communities Coalition. Our coalition is made up of several different organizations, including the Jewish Community Action, Minnesota 8, Coalition of Asian American Leaders, the ACLU of Minnesota, Legal Rights Center, Immigrant Law Center of Minnesota, the Minnesota Wrongfully Convicted Forum, as well as Minnesota Freedom Fund, with support from the Great Northern. I'm here today to talk about the A12 amendment, which has just been discussed by Senator Ver-Beaton, which is an amendment to the post-conviction statute. The post-conviction statute, for those who may not be aware, is the primary mechanism in which someone can get an unconstitutional or illegal conviction heard by a court and have relief, which would then get rid of that conviction. The current way that the statute is written in 2005 had provided what's called an interest of justice exception to the normal 2-year bar. Unfortunately, that exception has been almost read out of the statute given different ways, and that has been interpreted. What this amendment would do was make a more robust ability for courts to help decide when petitions, even when they are filed after the 2-year limitation, should nonetheless be allowed to be heard by the court and be given a chance to be adjudicated by the court. This type of exception, this sort of catch-all provision, would allow Minnesota to join several other states that have similar types of language that does involve allowing exceptions to time bar limitations that are, in fact, related to interests of justice or manifest injustice. Those states include Maryland, Kentucky, and Oregon. Simply, this provision would allow people to have their case heard. It simply does not provide any additional avenues to get convictions overturned, but it simply allows more courts to hear those claims, adjudicate them, and decide when possible and when necessary, in, quote, the interests of justice, that those convictions should be overturned even though they were filed after a 2-year time limitation. Thank you very much for allowing me to testify. I also have Marvina Haynes, who has a few comments that she would like to share as well with the committee.
Welcome, Ms. Haynes, and please state your name for the record.
Hello, everyone. My name is Marvina Haynes. Thank you so much for allowing me to speak today. I am the director of Minnesota Wrongfully Convicted Judiciary Reform, and I am speaking to encourage you to support Senate File 3939 to expand post-conviction release in Minnesota. On May 19, 2004, my 16-year-old brother Marvin Haynes was arrested without a guardian and later found guilty of first-degree murder. He was sentenced to life in prison, even though no fingerprints, DNA, or weapon or physical evidence was found indicating him he had any involvement in the crime. For nearly 2 decades, my brother was incarcerated while my family tried to prove his innocence. Unfortunately, because we had passed the 2-year time bar, we could not file for post-conviction relief. However, thankful with great community pressure and public support, we were able to work with the Innocent Project to convince prosecutors to waive the time bar so Marvin could prove his innocence in court. Last year, he did just that, and in December, he was finally released. My brother was fortunate enough to have the Innocent Project, Minnesota Wrongfully Convicted Judiciary Reform, and community support to convince prosecutors to waive the time bar, to waive the 2-year post-conviction relief time bar. But most who are wrongfully convicted are not as lucky as my brother and will never have the opportunity to prove their innocence. That's why I'm here asking you guys all to support SF 393. This bill will expand post-conviction release for more Minnesotans, and so people who are wrongfully convicted like my brother Marvin won't have to sit in prison for 20 years innocent, and will have a fair opportunity to challenge their conviction in court. This will ensure we are working to do the right thing so no one in Minnesota is sitting innocent in our prisons, and will create a more fair justice system for all of us. I strongly encourage each and every one of you guys to do the right thing. Thank you.
Thank you so much, Ms. Haynes, and I'm so sorry about the injustice done to your brother. Thank you for coming here today.
Thank you for that.
Is there any other discussion or any discussion? And Senator Latz, any comments on the amendment?
I would consider this to be a friendly amendment.
All right, then all those in favor say aye.
Aye.
Opposed, nay. Motion prevails. The A12 amendment is adopted. Did you move it?
Yeah.
Oh, good. Senator Umo-Verbatim.
Thank you, Madam Chair. I'll move to the A22 amendment. We also have one testifier, I believe, on this. And we'll just explain.
Please explain the amendment. Senator Latz.
I'm sorry to interrupt. I was just approached by Mr. Small, who had desired to be heard on the last amendment.
Oh, I'm sorry. On the last amendment.
Yes, please.
Please go ahead with your testimony.
Thank you very much, Madam Chair, members of the committee, Senator Latz. So we met
our association met with Mr. Chan and others.
Excuse me, say who you represent.
Oh, I am so sorry. My name is Robert Small, and I represent the Minnesota County Attorneys Association. Thank you. We met with Mr. Chan and others about this particular amendment, and our conversations were that our association was concerned that this would essentially eliminate the 2-year statute of limitations. Now, we had previously met with the Innocence Project to address the specific concerns about Mr. Haynes. And we agreed upon language that eventually became Senator Latz's bill that would address situations like Mr. Haynes. The approach this amendment takes is to derive a wide-open time period to ask the court to review a conviction that has already been proven beyond a reasonable doubt, has already had appeal opportunities and opportunities for post-conviction relief. We've had productive conversations with the advocates of this language to try to narrow the scope and find a specific solution to a specific problem. However, adding this complex issue by an amendment is of great concern to our association, and thank you for hearing me out.
Thank you. Is there any desire on the part of the author of the bill or the author of the amendment to reconsider the amendment? All right. Thank you, Mr. Small.
Thank you.
The next amendment is the A22 amendment. Senator Umu Verbatim.
Thank you, Madam Chair. The A22 amendment would require the BCA to conduct investigations when law enforcement use of force results in death. It does clarify the process that's in statute. If the incident involves a BCA officer, it instructs them to prepare a report for the prosecutor for the county where the incident occurred. If no one's charged, the reports have to be released to the public within 6 months. I've consulted with BCA, taken a lot of their feedback, all of it actually, that's incorporated into this amendment, and have confirmed that they can absorb the cost with the changes that are made.
Okay, is there brief testimony on this one? Then please, can we come forward? Try to come forward quickly when you have an amendment before. Oh, it's on the Zoom. Oh, great. I thought you were coming up to testify. All right. Can you please identify yourself on the individual on the Zoom?
Yes, I'm Josh Parker, Senior Counsel at the Policing Project.
Thank you, Mr. Parker. Please proceed with your testimony.
Good afternoon, Chair Latz and committee members. I'm pleased to be testifying today in support of A22 to SF 4271. The amendment strengthens Minnesota's existing accountability systems by ensuring that officer-involved use of force deaths are universally and diligently investigated. In 2020, the legislature created an independent use of force investigations unit within the Bureau of Criminal Apprehension, and allowed law enforcement agencies to request that the Bureau investigate officer uses of deadly force. But it is not currently mandatory for agencies to request Bureau investigations, meaning that these crucial investigations may be conducted by conflicted parties or not at all. The amendment would close that loophole. It clearly mandates that every use of deadly force be independently investigated, and to ensure that these investigations happen every time, the bill also empowers the Attorney General to enforce agency compliance. Strengthening Minnesota's existing law will bring the state in line with a diverse array of states that have already addressed this issue. Many states, including Wisconsin and Delaware, require mandatory independent investigation of all police uses of deadly force, and it would be a really beneficial bill. Thank you for the opportunity to speak today, and I'm happy to answer any questions.
Thank you, Mr. Parker. Is there anyone else in the room that wishes to make brief comments? Sorry, I didn't say that earlier. Anyone on the committee? Then Senator Umu Verbatim moves the A22 amendment. All those in favor say aye.
Aye.
Opposed, nay. Motion prevails. Because I think I did forget to ask Senator Latz if he approved the amendment. It's getting late.
Madam Chair, I consider that a friendly amendment. I think
Thank you.
independent investigation is important.
Other amendments? Senator Umo Verbatim.
Thank you, Madam Chair. Got a few more to get through. I'd like to offer the A21 amendment.
The A21 amendment. Proceed.
And happy to explain. This is just a copy of Senate File 3999, which was the Office of Justice Programs agency bill. I think just in the timeline of getting our policy bill together, it was easier to get this placed in as an amendment. So we did hear that bill. It's all of the same language, just making sure it's included in our policy bill.
Okay, we did hear it already. All right, so no testimony. Senator Latz?
I consider this to be a friendly amendment.
Any discussion on the A21 amendment? Senator Limmer.
I'm having a little difficulty in finding it in my stack. Could someone maybe describe the amendment?
Yeah, the
What it
stack
does?
that was handed out was the A5 through the I believe through the A21 amendment. And so it should be at the end, bottom, back of your stack, but Senator Umo Verbatim could certainly go over it. Or staff, if you'd like staff to.
Madam Chair, again, this was the Senate File 3999 Office of Justice Programs agency bill. So we're just making sure that that is included in our policy bill here. It was easier to get that drafted as an amendment to the DE.
Senator Limmer.
I'm sure I understand what it is. I'd like to know what's in the amendment. What does it do?
Senator Umo Verbatim.
Thank you, Madam Chair. Thank you, Senator Limmer. If we could bring forward Director Kate Weeks, she'd give a brief explanation of what's in their agency bill.
Okay, Ms. Weeks, if you'd come forward then and just go over briefly the provisions.
Good afternoon. My name is Kate Weeks. I'm the Executive Director of the Office of Justice Programs. The amendment does three things. The first is to make sure that the information that we receive for sexual assault exam payments that we are now responsible for remain protected, similar to our crime victim reimbursement program. The second piece is making sure there's consistent definitions of crime victims throughout our statutes, so they're all treated fairly and similarly. And the third piece is to make sure that in our crime victim reimbursement program, that individual private gifts or fundraising efforts are not considered collateral as we make determinations on claims, because oftentimes it's difficult to figure out if that funding actually went to the intended victims. And that is it.
Any more discussion? Any more questions? Right. Then Senator Umo Verbatim moves the A21 amendment. Senator Latz, do you already
Friendly
agree?
amendment.
All right. All those in favor say aye.
Aye.
Opposed, nay. Motion prevails. The amendment is adopted. Any more amendments? Senator Umo Verbatim.
Thank you, Madam Chair. I would also like to move the A19 amendment.
That's now at the bottom of our packets.
Thank you, Madam Chair. This was the safe at home changes that we heard in committee. It again needed to be drafted as an amendment for ease to then be placed into our policy amendment. So that is the same bill that we heard. It was Senate File 4737.
And are there anyone in the audience that wants to make a brief comment on this amendment? Anyone on the committee have any questions? Senator Latz?
It's a friendly amendment.
Thank you. Senator Umo Verbatim moves the A19 amendment. All those in favor say aye.
Aye.
Opposed, nay. Motion prevails. The amendment is adopted. Any more amendments? Senator Umo Verbatim.
Yes, Madam Chair, thank you. Let's go with the A13 amendment next. And this is a just small change clarifying that the post board may order law enforcement agencies to conduct inquiries into compliance allegations. And those complaint allegations, that language was in there, but we needed to just clarify the way that was written, as you'll see in the amendment, and it does have the post board's full support.
Anyone in the audience want to comment briefly? Anybody on the committee have any questions? Senator Latz?
It's a friendly amendment.
All right, Senator Verbatim moves the A13 amendment. All those in favor say aye.
Aye.
Opposed, nay. Motion prevails. The amendment is adopted. Senator Verbatim.
Thank you, Madam Chair. I think this is my last one. I have the A14 amendment. This amendment codifies a recent Supreme Court decision ruling that police cannot solely cite cannabis odor as a reason to search a vehicle. I did have similar language in another bill, Senate File 3928, but I do want to clarify that this is different and is really about codifying that case. It does clarify that it has to be the sole basis.
Any comments from the audience on this amendment, if you're keeping up? Anybody on the committee have any questions? Senator Limmer.
Thank you, Madam Chair. Perhaps I have a question maybe for council. What would be if a peace officer had a perception of the odor of alcohol, would that be a sole basis to search a motor vehicle? How does this compare with cannabis versus alcohol?
Mr. Bacchus.
Mr. Chair and members, I don't believe that the odor of alcohol would authorize a search of the vehicle. I mean, it might authorize certain, steps to be taken in terms of the DWI law, field sobriety test, and then potentially an implied consent. But I don't believe it would be, you'd be able to search the vehicle this solely on an alcohol smell.
Madam Chair.
Senator Limmer.
Mr. Bacchus, the language on this amendment says on 1.5, cannabis odor shall not serve as a sole basis to search a motor vehicle. What would be other contributing bases to, in fact, search a vehicle?
Mr. Bacchus.
Madam Chair and Senator Limmer, I would assume it'd be other indications that, other crimes have occurred, like perhaps a weapon or something, a firearm or something like that, some indication that, again, some other crime has occurred.
Madam Chair.
Senator Limmer.
Mr. Bacchus, would the behavior of the driver be a basis combined with the odor of cannabis to search a vehicle?
Mr. Bacchus.
Madam Chair and Senator Limmer, again, I guess it would depend on what the officer is suspecting in that situation. I mean, if the officer is suspecting that the person is driving impaired, maybe under the influence of cannabis or another drug, I don't think the officer would be able to search the vehicle at that point because the officer would be suspecting a DWI offense. But if the officer, suspected another type of offense, then under that, perhaps the officer could search the vehicle. It would be very fact-specific, I would think.
Senator Limmer, anything else? No. Okay. Any other? Senator Latz.
So, Madam Chair, Senator Limmer has hit on the core concern that I identified as well with the original drafting, which left it open to a prohibition based on a variety of things if marijuana odor was found. So there's a reason why this is narrowed down to the sole basis. So marijuana is now legal to consume in Minnesota, not while you're driving, but theoretically you consume before you drive. May not necessarily be impaired by it, but you'd still have the odor about you if you get into your vehicle and drive. So if you're stopped for speeding and the officer approaches the window, you roll down the window and the officer smells the odor of marijuana. Under past law, before it was legal, there might have been a basis not only to investigate further, but even to potentially anyway to search a vehicle. And in fact, it was used in many cases as a basis for ordering the driver to exit the vehicle and to search the vehicle. For example, to see if they were in possession of a criminal amount of marijuana. The Supreme Court, especially since we passed the law, but even before that, actually narrowed it down and said that the odor alone is not enough to search the whole vehicle. However, if there are other factors, the odor still, even under this amendment, could be considered as a part of a totality of circumstances determination as to whether or not a search would be appropriate. Now, there are different standards as to, can you investigate further to see if it's a DWI, for example. If the officer suspects impairment, as Mr. Backus said, that's not enough to search a vehicle. But if that combined with a variety of other factors would be enough for a court to determine that maybe there's something that a search is necessary for, then that totality of circumstances would be evaluated on a case-by-case basis. So this amendment is very narrowly tailored to prevent abuses of an odor kind of situation, but leaves wide open all the other types of determinations subject to judicial review as in the ordinary course of the proceedings.
Senator Limmer.
Madam Chair, Senator Latz, I'm assuming that perhaps case law hasn't really been developed yet around the circumstances of legal recreational marijuana post legislative decision to make it legal in unique circumstances. I'm thinking a driver is odor of marijuana, dilated eyes, failure to focus on the conversation. Those would all be contributing factors, I'm sure, for a police officer to make a judgment, but I don't know if we really have gotten to the clear line of what actually absolutely would allow a police officer to further a search of the vehicle. So,
Mr. Chairman and Senator Limmer, I don't know if a driver stopped for a DWI, if the officer would necessarily search the vehicle. I think they might arrest the driver for driving illegally. But,
no, Madam Chair,
yeah.
I'm putting it in the context of an officer coming up to a car, window goes down, and there's a smell of marijuana, not alcohol.
Yeah, well, the same thing. I'm using the two as a comparison. It's impaired driving, I think, is the issue. But if you're being stopped for impaired driving, erratic driving, that doesn't, I'm asking, if anyone knows, I don't think that necessarily leads to searching the vehicle.
Madam Chair?
Senator Latz.
You're correct. That's enough to investigate whether or not the driver is impaired, and then they can ask the driver to exit, maybe run a field sobriety test and so on. That alone would not be enough to search a vehicle. There would have to be some other particularized reason to believe that the vehicle contains contraband in violation of criminal laws to justify a search of the vehicle. Or if you get to the point of a post-arrest and you're about to impound the vehicle, you can search a vehicle just as a part of the impound process.
All right.
Any more discussion on the A14 amendment? Then Senator Umu verbatim moves the A14 amendment. All those in favor say aye. Opposed, nay. Motion prevails. The amendment is adopted. Are there any other amendments? Senator Westlin.
I don't have nearly as many. I'd like to move the A5 amendment.
Please proceed.
Thank you, Madam Chair. So basically, these are primarily some technical corrections to what we are affectionately calling the Bones Bill. It is clarifying that we are referring to the sale of calcified human remains. The term has been updated throughout wherever it's discussing human remains. We've also removed for commercial purposes. There is some clarification language also around donation and the circumstances for donation of human remains. This is on pages 31 and 32, but they are primarily in the nature of technical or clarifying corrections.
Madam Chair, your mic.
Thank you. Senator Latz, any comments? Anyone on the committee?
I consider it to be friendly.
Friendly amendment. Anyone in the audience? No one is looking interested? In our bones, we got bones. Senator Westlin moves the A5 amendment. All those in favor say aye.
Aye.
Opposed, nay. Motion prevails. The amendment is adopted. And Senator Westlin.
I have one more. And this is similar to a couple of Senator Umu Verbaten's amendments. We did hear this in committee, and the amendment is just A17, adding this to the omnibus bill. And it has to do, you'll recall that this had to do with verification that or attempts to verify a person's address who's required to register after they have moved to another state. And again, it was heard in committee and passed out of committee. We just need it in the omnibus.
Is there any discussion on the A17 amendment? Senator Latz.
Consider it friendly.
All right. Seeing none, all those in favor of the A17 amendments, say aye.
Aye.
All those opposed, motion prevails. The amendment is adopted. Senator Seeberger.
Thank you, Madam Chair. I have the A18 amendment.
The A18 amendment. A delete everything amendment. All right. No, amend the delete everything amendment. Senator Seeberger.
Thank you. This amendment speaks to the collateral source bill that we heard earlier in the session and simply moves to delete the reference to including amounts paid by the plaintiff's employer to an offset to collateral source deductions.
Are there any comments? Please come forward and state your name for the record.
Good afternoon, Madam Chair and members. Joel Carlson here for the Minnesota Association for Justice, and this is an amendment that was actually added to the bill when it was heard on February 19th, and when it was added to the delete everything amendment, that amendment just wasn't picked up. The bill, as you remember, had some other sections that were controversial that Senator Latz did not put in the omnibus bill. This corrects the language that's in there, so we'd appreciate your support for this amendment.
Are there any other comments from the audience? Are there any questions from members of the committee? Then Senator Seeberger moves that the A18 amendment be adopted. All those in favor say aye.
Aye.
Opposed, nay. Motion prevails. The amendment is adopted.
Thank you.
Any other amendments? Somebody do it. All right, the A10 amendment is before us. Senator Latz.
Madam Chair and members, there was a bill that was proposed.
This is the amended language.
The A10?
Yes, so this is so people can work if they want to.
Yeah.
This one, I know this.
So members, we did have a bill before us that related to jurors that when they provide their jury service, they could not be forced by an employer to work an alternative shift if they took their regular shift off during the daytime to do their jury duty. There's some additional language in here that would also not prevent an employee from being able to work an additional shift if they wanted to. They could make up the time, they just have to ask for it as long as they're not under any kind of pressure or request to do so by the employer. So basically, it becomes a juror's decision whether they would like to ask for a make-up shift. And that's what this language does. I ask for your support for the A10.
Is there any discussion on the A10 amendment? Anyone in the audience want to comment? Then Senator Latz moves the A10 amendment be adopted into Senate File 4271. All those in favor say aye.
Aye.
Opposed, nay. Motion prevails. The amendment is adopted. Are there any other amendments? Are there any other amendments? All
Madam
right.
Chair?
Senator Latz.
Let me inquire whether we've covered the bills that were heard today and whether some of them were laid over with the possibility that we would consider them to be added into this omnibus bill.
These are the ones that have to be added. I don't have bill numbers for them. Senator Latz, we think there are two bills, and we're looking for bill numbers. There were two Gustafson bills. One says the A1 amendment. Oh, okay. All right. They are restraining order provisions modifications, and the other one is venue for certain criminal sexual conduct cases may be proper in multiple counties' establishments. Those were two that we heard today. Senator, Mr. Backus.
Madam Chair and members, I could just give you the Senate file numbers for those, and then I think Ms. Primo has another one or two. But so the first bill is Senate File 4413. That's the OFP HRO bill, and the second would be 4952. That's the venue for the criminal sexual conduct changes, and those are the two that I'm tracking on the criminal side.
Okay, so why don't we just take this one at a time? So Senator Latz, you'd like to add the Gustafson restraining order provisions modification, Senate File 4413?
So moved, Madam Chair.
Okay. The motion is to add Senate File 4413 to the omnibus bill, Senate File 4271. Are there any questions, discussion? It's the bill we heard earlier today. All those in favor say aye.
Aye.
Opposed, nay. Motion prevails. That bill is added to the omnibus bill. Then the other Gustafson bill was 4952, which was heard in committee today. It was the venue for certain criminal sexual conduct cases. Any questions or discussions about that bill from anyone? All right, Senator Latz moves that Senate File 4952 be added to the omnibus bill. All those in favor say aye.
Aye.
Opposed, nay. Motion prevails. As amended, sorry, be added to the omnibus bill as amended. Thank you. All right. Take a pause.
So are you going to pass this out now then?
Senator Latz, is it your intention to pass this bill today to the floor?
That was my intent, Madam Chair. But I believe there may be a number of civil bills that we heard today also.
Yes. Yes, I will. Okay. Are there any other, Ms. Prio, are there any other bills that need to be added at this point that the chair is recommending?
Madam Chair and members, I'm not aware of any other bills that would be up to the members of the committee.
Madam Chair,
All right.
may I inquire?
Senator Latz.
May I inquire of staff? We had a list going of bills that we heard today that we also laid over that we were thinking about offering as amendments to the omnibus bill. Have they all been covered in the amendments that we already went through with individual amendments, or do we need to consider those as Senate files?
Senator Ladd, staff has informed me that Senate File 4499 was heard by the committee. Unfortunately, I was not here. It's a daycare bill that Senator Mitchell had before the committee. And is there an interest in yourself or the committee members in adding that bill? Or would you like to take a recess and review other bills for possible inclusion?
Madam Chair, perhaps if we could take 5 minutes, I can take a look at the list and I can decide
That's what I was thinking too.
what I would recommend to the committee to consider.
All right, the Senate committee is in recess.
Thank you.
To the call of the chair.
Madam Chair, I'd move adoption of move the amendment, Senate File 4499 into the omnibus bill. This is Senator Mitchell's bill earlier today relating to homeowners associations and daycare. We laid it over at that time for possible inclusion. It's policy only.
Thank you, Senator Ladd. So you're moving that Senate File 4499 as amended be incorporated into our policy omnibus. Okay. All those in favor, say aye.
Aye.
Opposed? All right, motion prevails. Amendment is adopted. Are there any other Senator Latz? Okay. I think for this final motion, we're sending this to the floor, but we also need to give our staff some broad authority. Do you have that?
I'll make it up here, Madam Chair. I move that Senate File 4271 as amended be recommended to pass, be sent to the Senate floor, and that staff be directed to make any technical corrections that are necessary for the bill.
Senator Crew?
Thank you, Madam Chair. Senator Latz, I just wanted you to know that Uniform Public Expression Protection Act is part in this omnibus bill. There's still some ongoing discussions with stakeholders. I didn't want you to be caught off guard. I'm not sure if there will be any changes. That's all to be determined. But just so you know, the parties are engaged. It's just logistically, the meetings haven't happened. So I just wanted you to be aware of that.
Thank you.
Senator Latz.
Madam Chair, Senator Kroon, I've been copied on some of the communications. I appreciate that, and I encourage the continued work.
Okay. On your motion, Senator Latz, to move Senate File 4271 as amended to the floor and to give broad authority to our staff to incorporate any of those technical changes. All those in favor say aye. Aye. Opposed? Okay. Motion prevails. And that bill, Senate File 4271, is sent to the floor.
Members, next item on the agenda is Senate File 4950, Senator Westlin, relating to ignition, interlock, and controlled substances.
Thank you, Mr. Chair and
Senator
members. There is an A1 amendment to this, which I don't have a copy of.
Members, this is the first committee for this bill. There's an A1 author's amendment. Senator Westlin moves adoption of the A1 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. Amendment's adopted. Senator Westlin.
Thank you, Mr. Chair. Under current law, individuals convicted of certain DWI offenses must comply with the Ignition Interlock program to recover full driving privileges. This existing program requires an individual to have an ignition interlock device that they use to test for the consumption of alcohol before starting the vehicle. Senate File 4950, the bill before you at this time as amended, is an alternative program for those convicted of certain DWI offenses involving controlled substances. Instead of the interlock program, which does not detect other controlled substance use, they would participate in an intensive testing program involving weekly urine testing to ensure abstinence. We have worked with stakeholders, including the Department of Public Safety, who provided valuable feedback that was incorporated into the author's amendment. This bill and program is an important update to our ignition interlock system, which ensures public safety while also reasonably restoring driving rights.
Senator Westlin, do you have any testifiers that you're anticipating for this bill?
I don't believe so, and my understanding, Mr. Chair, is with the amendment, my understanding is this actually has created a fiscal note. There's some other things. I believe this has to travel to transportation and ultimately state and local government, but I believe that the fiscal note is being absorbed by the Transportation Committee.
All right, so I know that we have at least, I believe that there's someone in the audience who wants to testify in connection with the bill. Yes, sir, come on forward.
Mr. Chair, Senator Westlin, members of the committee, my name is Ed Cohen. I'm one of the owners of Smart Start Minnesota, Minnesota's original ignition interlock provider. I'm testifying today to express some concerns with Senate File 4950. Minnesota's ignition interlock program has been in place as a statewide program since 2011 and has graduated approximately 50,000 people from this program. Minnesota's program is one of the best programs in the country, and each year there are tens of thousands of incidents in which drivers are prevented from driving because they have attempted to start their vehicle with a blood alcohol concentration that exceeds the state limit. And there are significant numbers of individuals who are prevented from driving who have blood alcohol concentrations that exceed the legal limit. Ignition Interlock is a program that works. This bill will affect a significant change in the Ignition Interlock program, and I'm concerned that the bill in its current form will actually provide less public safety for the people of Minnesota than there is today. As a starting point, this bill will strip out of the interlock program many individuals who otherwise would be subject to it. For 17 years, Ignition Interlock has prevented thousands of individuals from starting their vehicle after consuming alcohol. And while I realize that controlled substance users are not stopped by the Ignition Interlock, polysubstance use and abuse is real. And frequently, those who use drugs will also use alcohol. By creating this parallel program to the Ignition Interlock program, this bill will prevent away from stopping the use of these polysubstance users and abusers. And while I don't have specific numbers, the Office of Traffic Safety has previously indicated that there are many drug users who are also using alcohol. Drinking is frequently a trigger for using controlled substances, and drugs are frequently a trigger for drinking alcohol. I'm not clear that any of this data has been considered in the promulgation of this bill. Additionally, many controlled substance DUIs include alcohol, but frequently not at illegal levels. Ignition Interlock tests the individual every time they get behind the wheel to drive. The intensive testing program will rarely test the individual. By taking the controlled substance DUI out of the Interlock program, you are removing a tool that has been proven to prevent the use of a vehicle by individuals who've been drinking. The fact that a person who was charged with a controlled substance DUI does not mean that they do not drink. Additionally, there are some specific issues with the bill that could be problematic. As constituted, this bill would prevent an individual who would otherwise be eligible for the exception to vehicle forfeiture from exercising that exception. The exception requires acceptance into the Ignition Interlock program, and there is no exception for the driver of a forfeited vehicle to enter through the intensive drug testing program. The testing presumed by this bill is also quite vague as to how the testing would occur, who would be conducting the testing, where the testing would take place, and what they would be tested for. I'm a member of the Minnesota DUI Task Force, and probation officers today in our meeting were expressing their belief that they could not handle additional testing requirements with current staffing and budgets. The bill also imposes a requirement for following a treatment plan, but does not address how that requirement will impact the individual, who will be paying for this treatment, and what if there are not beds or placements available. How individuals comply with the requirements of this bill will, if they do not have the means to do so. I believe this bill, as constituted today, has many unintended consequences that have yet to be explored. I would ask that you consider these concerns.
Thank you.
Senator Westlin.
You reached out to me about this.
I just sent you an email. I just learned about this.
Okay. Thank you, Mr. Chair. Well, this bill has been out for a while. I believe it was dropped in January. I have not heard, you can go back to your seat. I have not heard any of these concerns raised to me previously as the author of this particular bill. I will simply say, first of all, that the fact if somebody is pulled over under current law, I guess I will ask you, Mr. Chair, as a criminal defense attorney, if someone is pulled over for a controlled substance for a DUI, driving under the influence of a controlled substance, are they required to participate in the interlock program?
Senator Westlin, being pulled over does not trigger the interlock program. Being convicted of certain offenses, second offenses basically, or alcohol test 0.16 or higher, includes mandatory interlock. There are also incentives. Before you can get your license back, or in some circumstances, you can wait out a revocation period rather than reinstating with interlock. But there are also some circumstances under which you can avoid the mandatory minimum sentences set in statute if you enter the interlock program. There are also ways to avoid vehicle forfeiture if you enter the interlock program.
So my understanding, Mr. Chair, well, first of all, if someone is engaging in controlled substance use, the Ignition Interlock is not going to pick that up. And I would assume, and I don't know this because I don't practice criminal law, but I would assume that someone could certainly voluntarily participate in Ignition Interlock, but if someone's preferred drug of choice is cocaine or something else, that is not going to be picked up by Ignition Interlock. I will note that according to the amendment here, the commissioner is going to be adopting rules to implement this section. It does talk about the program participant has to engage in random urine analysis and other testing at least weekly. I don't practice criminal law, I do practice family law, and I know that we frequently require people to undergo drug testing, and certainly a weekly drug test would pick up use of a variety of substances. Again, it would have been nice to have heard some of these concerns before hearing about them today for a bill that was dropped in January. But I am going to ask that this committee pass this bill to the next stop. And if anyone has concerns about this bill or any other bill that I author, I would encourage them to reach out to me and talk to me about it before the day of the hearing.
Is there anyone from the Department of Public Safety or Office of Traffic Safety here to, that can testify in connection with the bill? Come on forward if you will. Go ahead and state your name and
Thank you,
if you
Mr.
have anything
Chair.
you'd like to say, go ahead.
My name is Megan Gallagher. I'm the Director of Legislative Affairs for the Department of Public Safety.
All right, thank you. Do you happen to have any data on the polysubstance use, how frequently people who are regular users of controlled substances also consume alcohol?
Mr. Chair, I do not have data on that. I don't know if the Office of Traffic Safety has any recent data on that, and the Ignition Interlock program only tracks alcohol use, so I don't have data. We could see if we have some and certainly provide it to the committee.
All right, and has your office done an analysis of this proposal to determine whether the agency has a position on it?
Mr. Chair, we've reviewed the proposal and worked on it with Representative Cagle, who's the author in the House as well, and completed a fiscal note on that side as well. So there is an understanding of how it would be administered, yes. The agency is neutral on the bill itself.
So the agency is not taking a position on whether you think this would advance public safety or detract from public safety?
Not at this time. We've only provided technical assistance on how the program would be administered.
I'm a little bit surprised that the agency on a bill of this nature is not weighing in on the wisdom of this policy proposal.
I can tell you, Mr. Chair, that we had discussions with Representative Cagle about the fact that there is a difference between a drug test and an ignition interlock device in terms of the vehicle not being able to be driven, and that's something that she's continuing to research to see if there are ways that they could have that there would be something similar with the intensive testing program. So we've certainly asked that question. We haven't taken a formal position on whether this is the best way to advance public safety or not. We want to help and make sure that the program itself could be administered in the way that it's envisioned by the author and by Senator Westlin.
All right, thank you.
Mm-hmm.
Any questions from members of the committee on this? Thank you, Ms. Gallagher. Is there anyone here from the DWI task force, by any chance? I mean, these are the DWI bills that typically get evaluated by the DWI task force before they're brought to the legislature. Senator Westlin, do you know if the DWI task force has considered this and if they have an opinion?
I have not heard from any other stakeholders about this bill, Mr. Chair.
Mr. Cohen, you have something to add to that?
Yes, briefly. Mr. Chair, members of the committee, David Bernstein, Chair of the DUI Task Force, learned about this yesterday as well. He has sent you an email not objecting, but expressing some concerns that was sent midday today. So he asked me to let you know that that was sent to you.
Okay, I haven't seen the email yet. Thank you for sharing that.
Mr. Chair, I guess
Senator
the only
Westlin.
thing that I would offer at this time is that if we are requiring people to use ignition interlock to detect alcohol, but we are not necessarily currently doing anything to have ongoing intensive monitoring of people who are charged with and using other substances, it seems to me that adopting a program that's going to require them to test weekly, and yes, that doesn't mean there's going to be that same instantaneous interruption of their ability to drive, but if they are found to have substances in their system, there are going to be consequences for it. I don't know that there is any effective way right now to monitor folks to keep them off of our roads who are using substances other than alcohol. Obviously, if someone's ordered to use ignition interlock for whatever reason, they're being required to do that. But what are we doing with all of the other people who may be using additional substances?
So Senator Westlin, if someone's convicted of the level of a driving while impaired offense that would require the use of ignition interlock for purposes of getting reinstated driving privileges, in my experience, and I've been practicing in this field for about 30 years, predating the ignition interlock, and I was one of the original authors of the ignition interlock bills in the first place. They would be required either as a direct condition of probation or as a recommendation following a chemical use assessment, which would be incorporated into a condition of probation on the sentence, to abstain from the use of controlled substances that are not prescribed. And almost always that includes a random testing requirement or some kind of a testing monitoring component, independent of the driving privileges, which is what the interlock, which brings the interlock into play. So I guess I would say that these folks are already subject, in most cases, to some kind of controlled substance testing and abstinence requirements. Can you clarify for me whether if this were to become law, would there still be a path for the individuals to avoid the statutory minimum sentences by installing ignition interlock for the duration of probation, as there is now?
That's a good question, Mr. Chair. I would like to phone a friend and see if Mr. Backus can help.
Mr. Chair, I'm sorry, I don't know that I can answer that off the top of my head. I'd have to look it up, but I don't think that's provided in the bill.
All right, and the related question, the next question in that also would be what impact, if any, it has on the current statute that allows for the avoidance of the motor vehicle forfeiture when the requisite conditions are met by entering ignition interlock and having an agreement to return the vehicle. Is that affected at all by this proposal? That's not mentioned here either. So so Senator Westlin, is the bill, I read through the original bill, I haven't cross-referenced the amendment yet. It still provides for weekly urinalysis, is that it?
For weekly, yes.
Okay. So the challenge there is that there isn't any mechanism for preventing the operation of a motor vehicle from someone who is using controlled substances.
I don't know that there is currently either.
Well, unless there's polysubstance use. And you're right, there isn't a good way to do that right now, although I understand technology being as it is, they're working on it, but not quite caught up to that yet. Do you have something to add, Mr. Backus?
Mr. Chair, members, just your original question regarding the mandatory penalties and the ignition interlock exception, that appears in 169A.275, and that's not amended in this bill. So that there would not be a similar exception for these people if they're not in the ignition interlock program.
Okay, so then if under this bill, if a person were to go the route provided for in this bill, they could get their driving privileges reinstated without ignition interlock, but subject to the weekly urine testing. But that would not be an avenue for a reduced in custody or house arrest sentencing. It would not be an avenue for getting their vehicles back. For those, they would still need to go into the interlock program. Is that the way this is set up? Yeah, Mr. Backus, so if someone were to go into this intensive testing program to get the driving privileges reinstated and did not go into the ignition interlock, they could, under those circumstances, they would not be able to avoid the mandatory minimum sentences for jail and house arrest, and they would not be able to get the vehicle, avoid forfeiture for the vehicle through this intensive testing program. Is that right?
Mr. Chair, members, yes, that's my understanding, yes.
Okay, so they would still have to get the interlock if they wanted to take advantage of those opportunities. Is that right? Mr. Backus?
Mr. Chair, yes.
I'll be candid, Senator Westlin, I'm a bit hesitant about this. This is a pretty substantial change. I don't know that it advances public safety, since these folks, I think, almost all will still be subject to testing as a condition of probation. And they'd be able, at least in the circumstances, if there's any co-use of drugs and alcohol, they'd be able to drive and drink and get behind the wheel. They could drink alcohol and get behind the wheel with valid driving privileges. Because it sounds like the way this is put together is they could get valid driving privileges if they agree to submit to urine testing for controlled substances. But that wouldn't stop them from drinking and driving, which they could do legally, because they're getting their license back. Am I misunderstanding this?
Well,
Senator Westlin?
let's go look at the bill, because so the program, the intensive program requirements are that the commissioner is going to establish guidelines for participation. Now we're on page 8. The program guidelines must include provisions clearly identifying and prohibiting masking agents. Program must include provisions requiring disclosure of any prescription medications. The commissioner must enter a notation on a person's driving record to indicate the person is a program participant. A person under the age of 18 is not eligible. A program participant must pay the costs associated with the required urine analysis. A participant must participate in any treatment recommended. A program participant must submit to regular and random urine analysis and other testing that take place at least weekly. The results ordered by the court or required by probation satisfy the requirement. Then, if you go to issuance of restricted license, the commissioner must issue a Class D driver's license subject to applicable limitations and restrictions of this section to a program participant who meets the requirements of the section and the program guidelines. The commissioner must not issue a license unless the program participant has provided satisfactory proof that they have submitted to a minimum number of preliminary urine analysis as required by the commissioner that tested negative for the presence of a controlled substance or its metabolite and for the presence of specific intoxicating substances, and the participant has coverage of insurance, et cetera. So one has to participate in the program for a period of time. Again, I assume that that's part of the rulemaking to be established by the agency before one gets one's license back, and then there's a notation on your driving record that you are a program participant. I am happy to continue working on this. I'm happy to continue to have conversations with anyone about this. Certainly, Chair Latz, you have far more experience in this area than I do. I know that we get bills on the fly, and I also know, we don't always have time to review them in detail before they come before a hearing. Again, I am happy to have ongoing conversations, and this has at least 2 additional committees to go to. My position, I guess, Mr. Chair, is that I think there is a population of people who are not subject to ignition interlock and who are not being tested for anything, have no restriction on their license. This would provide a new means of testing and programming that is going to require them to do certain things that under current law they may not be required to do because of the nature of their offense. So from my perspective, yes, I do think that that actually is better than not having anything. And again, you have far more expertise in this area than I do. I am happy to have ongoing conversations to see if there are things that we can do to make this bill better. I would ask the committee to pass it along to, I think, again, transportation next and state and local government, or it's the other way around. I don't know what more to say than that, Mr. Chair.
So, Senator Westlin, I agree with about half of what you're saying.
Well, that's pretty good.
I mean, I agree that more needs to be done with regard to controlled substance DWIs to make sure if they get behind the wheel that they're not using controlled substances. I'm not convinced that eliminating the ignition interlock requirement gets us there. Honestly, I'd be much happier layering the urine testing protocols on top of the interlock program. Rather than eliminating the interlock and substituting it with the urine testing protocols. I guess I disagree with one factual assumption you made, which is there are a lot of people out there who would be driving without testing because anyone who gets to the point of the ignition interlock being required is in almost every circumstance is going to be subject to testing and abstinence conditions as part of their criminal sentence and probation requirements. So they're getting tested, or they ought to be tested. Certainly there's an incentive to be more compliant, if you will, but if the urine test is taken a week later, I mean, that's not going to stop the people who are huffing, because the chemical evidence of huffing is out of the system in 15 minutes. There are other controlled substances that have, various periods of degradation or elimination of the metabolites from their system and out of the urine testing as well. So
I would submit, Mr. Chair, if someone
Senator
is
Westlin.
huffing and it's out of their system in 15 minutes, that may be less of a danger than someone who is on fentanyl or some other substance. I guess I don't want to continue to belabor the point. I understand your concerns with this. I don't know that this prevents ignition interlock from being ordered in appropriate situations, but in situations where it's not being ordered because of the nature of the substance for which one has been arrested, this would at least provide some testing. And there's a consequence if you have a failed test and you don't get your license back before you test. You have to do a minimum number of tests before you can get your license back, and you have to show that you are participating in some sort of a treatment program. So, again, we can move on.
well, yeah. I mean, I'll be candid with you. I'm just not comfortable at this point with the proposal. Part of it is that, almost all the usual stakeholders that get involved in these conversations aren't here testifying one way or the other about it. A little surprised the DWI task force hasn't weighed in on it. The bill was introduced March 13th. So however long it's been around, the bill introduction was March 13th, and this is the first conversation you and I have had about this bill as well. So
My copy of the bill says January 19th, but I guess I don't know if this was, maybe that's when it was dropped by the House author?
you may have.
Or maybe I have a very old copy of this, yeah. I'm sorry, that's in my file. I don't have the.
So, I mean, I think it's certainly worth exploring further, but, you know, and it's valuable to, I think, have had the hearing, but I'm sorry, I'm just not comfortable moving it forward from here. And even though it has other steps, this is the primary committee of jurisdiction on it. I think it needs some more work.
Well, I guess
So
we'll
it's
take a
your
vote on
motion,
it.
we can-
Yeah,
and, you know,
I
see what
move
the
it,
committee wishes to do,
and
so.
if it fails, it fails, but I would encourage people to vote for the bill.
All right, is there any further discussion on Senate File 4950? So Senator Westlin is moving that Senate File 4950 as amended be recommended to pass and be re-referred to the Committee on State and Local Government and Veterans. All those in favor say aye.
Aye.
Opposed? No. Motion does not prevail.
Division.
Division called. All those in favor of the motion, raise your hand.
Where's Sandy?
1, 2, 3, 4. Got them all. 4 in favor. Sandy. Okay. We're counting online as well. Those opposed, raise your hand. Senator Pappas, there's a division on Senator Westland's motion here. Okay, so the motion is Senator Westland's motion on Senate
I'm voting with Senator Westlin.
The motion is on Senator Westland's motion, Senate File 4950. That'll be recommended to pass and be re-referred to the Senate Committee on State Government. There was a voice vote, which the chair called that it failed, and there was a request for division, and we're now raising hands for the division. So those in favor of the motion, Senator Pappas, is you online? Okay, she's raising her hand. Okay. And those, and we have those opposed? Yes. Okay. Okay. All right, so we have 5 in favor, 4 opposed. The motion does prevail. All right. Let's do that. Okay, we're going to take Senate File 2026. Senator Mohamed, Senator Mover-Baton is going to present the bill on speed safety camera enforcement pilot program.
We're here. This isn't the first stop, is it? Oh, no. Okay.
Senator Mover-Baton, please tell us about the bill.
Thank you, Mr. Chair. I am a co-author on this bill and happy to present on behalf of Senator Mohamed, Senate File 2026. This is not the first stop, but there is a DE for this bill. I can give sort of a high-level summary and also have a testifier here that can speak to this in more detail, but it's going to provide for a 4-year pilot program for traffic safety cameras for speeding and running red lights. The pilot is limited to MnDOT for work zones and up to 4 local communities nearby schools. The amendment responds to feedback that the author has heard throughout the process from the ACLU, MinCOGI, our judiciary regular, Rich Neumeister, and the bill will now allow for a pilot of those traffic safety cameras, which are really a tool to make our roadways safer. So I would like to move the A6 amendment, and happy to answer any other questions about that bill or have our testifier speak to that if folks want those questions answered in more detail.
All right, members, this bill comes to us from the Transportation Committee, so the A6 amendment is not an author's amendment. Why don't we hear testimony and determine exactly what's in it? We'll take it from there. Who do you have with you, Senator Umer Verbed?
Sure, Chair Latz and members of the committee. My name is Ethan Foley. I'm the Vision Zero Program Coordinator for the City of Minneapolis. I focus on our traffic safety initiative. So we're one of the 4 cities who would be authorized to do a pilot of traffic safety cameras in this bill. We're supporting this because we have a real challenge with traffic safety, and this is something we see across the state. And in particular, in Minneapolis, we've seen since 2020 an increase in speeding and red light running, leading to more people being killed on our streets. And so in the last 2 years alone, we've had 31 people killed in crashes that clearly involve someone speeding or running a red light just in the city of Minneapolis. 18 of those people were not the driver. They were an innocent, totally innocent person. One case was a mother walking with her 3 children trying to cross a street when a speeding driver ran through and ran them all over. She was killed. Her children were severely injured. She was not doing anything at fault. And so we need new tools to be able to address these traffic safety challenges. Traffic safety cameras are used either for speeding or red light running in 29 other states around the country. And so what we've done with this bill is really take a lot of the best practices we see around the country and the results that have been proven around the country to improve safety. And we've incorporated those into the bills because it's what we see. MnDOT did a study of speed safety cameras, and what they found is that every single study of speed safety cameras in the country reduced speeding, crashes, injuries, and deaths. Every single study. And so this is very proven, but we know that there are questions around fairness, privacy, equity, and we've taken all those best practices from around the country, the feedback that we've heard locally, and incorporated that into the bill, and then this amendment that is before you right now. And I'm happy to walk through details related to the amendment, but that's just a little bit about the overview of why we're doing this. I think a few details I'll point out for the amendment, and just to clarify jurisdiction here, should I be focusing on the data privacy pieces or other pieces as well?
We have pretty broad jurisdiction here beyond just the data, so why don't you just fill us in on the whole bill?
Okay, great. And I think we're maybe going to send it back to transportation as well, is my understanding, is just so folks know, so that because there are some changes from when it was heard in transportation.
I think there are also some fiscal costs.
Yes. Overall, the program is set up to treat this a little like a parking ticket, or like the program we have with school bus arms. And if someone violates a school bus arm and that's caught on camera, then the owner of the vehicle can be sent a ticket. And so this is set up similarly to that. In order to manage to make sure we can deliver things effectively, but we're also not being overly punitive, the tickets the citations in this bill are set at $40 to start. The first violation is set up as a warning. And then the second violation, the offender would have an opportunity for diversion with taking a traffic safety class, a free traffic safety class in lieu of one citation, and then the citations would kick in. What we want to have is every opportunity for folks to change the unsafe behavior, so we're improving safety on our streets without being overly punitive. Every location must be signed ahead of time. There's a traffic safety camera coming. And then, again, we want folks to change the behavior. We don't want to punish folks. And then we also are required in the bill to have all locations on a website that's maintained so that it's really clear where are these locations around the cities that are piloting this. I'll also note that the cities, it was mentioned that this pilot would be limited to 4 local jurisdictions plus MnDOT. And then it's further limited that those communities would be limited to no more than 1 camera per 10,000 residents. So for the city of Minneapolis, that would mean through the pilot period, we could have a maximum of 42 traffic safety cameras at a maximum, just to give you a sense. One of the other cities mentioned in here is Mendota Heights. They'd be able to have 1 traffic safety camera. So just to give you a sense of some of the limits in place, there's also a lot of reporting requirements included in the bill. And those are really because we recognize that this is a pilot and we want to have good information to help to inform the potential of a long-term program. And so we've added a lot of reporting requirements based on feedback that we've heard through the process to make sure that we get a good evaluation that can serve the legislature well in future decisions around this topic. So I think those are some of the key points in the bill. I will note also that, Chair, we talked about an affirmative defense for, some cases where maybe the citation shouldn't apply. So one of the additions that was made in the amendment is that if a owner of a vehicle receives a citation, but they provide a sworn statement that, hey, I wasn't operating the vehicle at the time of the violation, then that would be an affirmative defense as well. So that's another addition through the amendment.
All right, thank you, Mr. Foley. Anyone else wish to come forward and testify in connection with this proposal? Let's open it up for committee discussion. Senator Kroon.
Thank you, Mr. Chair. On the A6, page 17, lines 9 through 12, trying to figure out if that, it says it's not rulemaking. Is the intention of this that, I guess I'm just to see if it's authorizing rulemaking or if it's exempting it from rulemaking. This seems to be not clear to me.
Mr. Foley.
Chair, members of the committee. So this is there, you'll see in the previous section, it's actually a couple sections ago, there are requirements that MnDOT and DPS create standards and guidelines around various aspects of having a traffic safety camera program. That is to assure things like we have standards for calibration of the cameras, maintenance, other things like that. This is just clarifying that those things won't be in rule per se, but any implementing authority is required to meet those guidelines and standards that are set by the agencies.
Senator Kroon.
Thank you, Mr. Chair. I'm not sure how common this provision is. And I know that rulemaking is within the purview of state and local government, I think, but it seems like this is, to me, it's like charting out a middle ground of some sort. It's not authorizing the agency to do rulemaking, or it's not exempting them. I appreciate your explanation, but I'm not sure what this means from that standpoint. If we were going to exempt them from rulemaking, then it seems we should use that word, which is commonly understood in exempting the agency from rulemaking.
Mr. Foley.
Yeah, Chair and Senator, I think we're trying to be clear here that this is not rulemaking, and so that, and I think that there's further clarity needed and with an exemption, we wouldn't have any concern with that. I think the intent of this was to do what you're saying, which is this is not rulemaking. It doesn't have to go through the rulemaking process. And I'll say particularly all this is a pilot program as well.
Mr. Chair,
Senator Cronin.
I'd like to offer the A7 to amend the A6.
Staff will distribute the A7 amendment. Senator Cronin, tell us about your amendment.
Mr. Chair, thanks. The A7 just simply makes it clear that it's exempting the agency from rulemaking, which is what I heard the testifier say was the intent.
Senator Umaver-Benton, this amendment, Senator Cronin, council has informed me that adopting this amendment would cause it to go to the state government committee because of the impact on rulemaking. FYI.
Mr. Chair, could I get a copy of the amendment?
Oh, yes, of course.
Mr. Chair. I think we have similar goals. I would say that because this is a pilot and we're being very clear what those actions are for the commissioners, that this wouldn't be necessary. I'm nervous about adding this in and then the bill needing to go to the state and local government committee. Perhaps council can also weigh in on just the existing language and whether or not that's clear enough that this is not rulemaking.
Mr. Backus.
I'm sorry, Senator Umaver-Benton, could you just repeat that question? I didn't hear it exactly.
Mr. Chair, Council, just the existing language on line 17.9. The intention here is just to clarify what is already listed in earlier sections of the bill would not be considered rulemaking.
Mr. Chair,
Mr. Backus.
Senator Umaver-Benton, that's something kind of outside of my scope and my jurisdiction, really. My understanding is, adopting standards and requirements, and that could be considered rules under current law. So arguably, based on the current language, it's possible it could need to go to state government either way, but my understanding is that state government hasn't requested it. So maybe it's you are correct, it's a pilot project, and it has limited geographical coverage, so I really can't answer that, but my understanding is from State Gov Council is if we adopt this amendment, then it would have to go there for sure, and maybe it's arguable whether it needs to go there currently.
Okay. Mr. Chair, just knowing that the taking on the amendment would require us to do so, I'd ask members to vote no. But I do understand that council will have to weigh in. We'll see what happens after we're done with this bill. But my intention is to send this back to the Transportation Committee. So I'd ask members to vote no on this amendment.
Senator Cronin.
Thank you, Mr. Chair. I'd just add that whether or not something is a rule is a matter of constitutional import. It's for the courts, and I think the legislature should be very clear about what its intention is here. To me, we're either authorizing them to make rules, or we should exempt them. And to have this middle path, I don't think is a healthy way to make law and set a precedent, even if it's just a pilot program. If the intention is to not make rules, I don't see any harm in specifically saying that through the standard language of exemption.
Council, I've never actually seen language in a bill that I can remember that says not rulemaking and declaring that these kind of things are not rules. If I just never had it come before me, or is my memory faulty, or have you seen this before?
Mr. Chair,
Mr. Backus?
members, this is coming kind of second hand, but my understanding is the way subdivision 17 is currently worded, it would be considered quite unusual. That's my understanding. Unusual.
All right, well, we probably, also because the A7 was drafted to the original Senate file 2026 and not to the A6 amendment, we probably need to clarify the page and subdivision references in the A7 amendment as well. So I assume the motion will be to make any necessary modifications to the amendment. Any further discussion on the A7 amendment?
Mr. Chair? Mr. Chair?
Senator Howe, hold on. I think Senator Carlson, oh no, he wasn't raising his hand. Oh, Senator Howe.
Well, thank you, Mr. Chair. And I'd kind of like to ask council if we don't lay the provisions out here in this bill and we don't have rulemaking, exactly where do the details get worked out? And if they work those details out at the Department of Public Safety, are they policy? Do they have the effect of law? Or how does that work? I've never done it where it's not in the bill and it's not rulemaking. I wonder where that falls.
Senator Howe, you asking counsel? Mr. Backus?
Yes.
Mr. Chair and Senator Howe, I mean, my understanding is that the commissioners would adopt these standards, curriculum, and requirements according to the section. Unless the section requires it, I don't believe there's any kind of public process and comments like you would have for normal rulemaking. And then theoretically, if they were challenged and they were considered rules or had the effect of rules by the court, then they would be unenforceable because they didn't follow the proper procedures under Chapter 14. So there is potentially there's potentially a downside by not calling them rules if a court eventually finds that they're functionally equivalent to rules.
Mr. Chair.
Senator Umer Verbatim, I think my recommendation would be that we adopt the amendment, that we send this on to rulemaking, and transportation can dual track it if they wish to. And then and maybe someone can sort this language out later, but I wouldn't want to be in a position of having the program founder because the guidelines were not properly adopted.
Mr. Chair,
Senator Umer Verbatim.
I just wanted to share for the record that after subdivision 4 that does list out those standards, there is requirements for public engagement and notice. That's all.
Okay. Senator Umer Verbatim, just to let you know, staff has indicated to me that one of the staff persons from State Government Committee says they're leaning away from feeling they need to see the bill because this really isn't their statute of jurisdiction. So for whatever it's worth, there's no definitive answer. I guess they do an evaluation at some point down the road and decide whether they request a re-referral. We're dealing in a very gray area here, apparently. Senator Umer Verbatim, what is your position on the proposed A7 amendment?
Thank you, Mr. Chair. If we need to, I think my concern is just around the state and local government piece, but hopefully we can figure that out. I don't have issues with the language in the amendment, just want to make sure we're working through that process. So if that's your recommendation as well, we can move forward with adopting it.
Any further discussion on the A7 amendment? Senator Kroon moves adoption of the A7 amendment with the language to be clarified by council to fit into the bill. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Any further discussion on Senate File 2026? Senator Carlson.
Thank you, Mr. Chair. I've talked with the advocates on this a couple of times, and there's some things I really like about it, but some things I'm a little uncomfortable. And I guess there's a couple of questions I'd like to ask you. You mentioned and I think it's only 2 instances that you can charge a vehicle for a violation, and that's going through the stop arm on a school bus and also parking. And that's where the tag goes to the owner of the vehicle. And I think you've said that here a couple of times too, but it seems like there are times when you make it a bit confusing where you say a person, and that the person has to go through first of all, there's issues there where it says that the person gets so many tickets. You get the first ticket freebie, and then after that, there's rising penalties. And then also, and you don't say the vehicle, but then also, I'm wondering, where does it say how you get the violation attached to the person? Because you say you don't use license plate readers, which I didn't know that you didn't have that in the beginning, because now you're just taking a picture, and evidently you have to have the license plate in the view, so at least you can find out who it is, because if you have a blue Chevy, you've got a lot of people that may have blue Chevys that you're going to have to identify one person from it. So I'm a little confused on how you get to that. How do you get to the person? And how do you keep the person out of the violation if we're going to say that that the person gets a freebie, the person actually increases the penalty after more than one violation?
Senator Uma Verbate.
Thank you, Mr. Chair. Senator Carlson, I just want to back up a moment, and then I'll allow our testifier to go into answering your questions in more detail. But the framework of having a warning and then education and then the citation is really following best practice, is addressing some of the concerns from folks about sort of continuing that fines and fees model that would have a really disparate impact on, I would say, low-income communities and communities of color. So the framework there is very intentional and is the result of engaging with a number of advocates. But to your specific questions, I'll let my testifier speak to those.
Chair, Senator, members of the committee. So the way that automated traffic enforcement would work is we have a camera. There's specifics in the bill about what that camera can collect. And it cannot collect any images that make someone personally identifiable. And that's to protect privacy based on concerns we've heard through the process. But it can collect, and it must collect, the back license plate. And so what happens with the system is it collects it senses a violation. The camera's not recording all the time, but it senses a violation, then it records the images, and then including the back license plate. Then an agent, a trained traffic enforcement agent, has to review that, confirm that there's a violation, and then the violation, they're looking up the owner of that vehicle based on the license plate, and then the citation or the warning, warning initially, or the citation is sent to the owner of the vehicle. And so that's how the system is set up. And so there are, we do have the pieces in here clarifying that getting the information necessary to make that, send out that citation fairly.
Thank you, Mr.
Senator
Chair.
Carlson.
But it sounds like you just have a human doing the license plate reader.
Mr. Foley.
Chair, Senator, the difference with an automatic license plate reader is that automatic license plate reader is a camera that's always running through license plates, and that is prohibited. It's prohibited to have a traffic safety camera that is doing that, which is an automatic license plate reader, that's fundamentally different than camera senses a violation, it records the images, it sends those images on to review by a trained agent who has to confirm the violation. And part of what we have in the reporting requirements is you have to report on how often does an agent say, hey, the camera sent a violation forward, but for whatever reason, we deemed that there wasn't a violation. And maybe that was one of the affirmative defenses we have. It was emergency vehicle or whatever. But that'll help us as part of this pilot in understanding how is the technology interrelating with the human, because it is important to have that human verifying that violation. And that's a critical part of due process related to this.
Senator Carlson.
Yep. I guess what I don't see, Mr. Chair, is there's the difference between a human reading the plate and a camera reading the plate. And also there's, it really doesn't take much to imagine that you just take that clip of the image when the person violates. You're talking about capturing the rear license plate, so the person has already violated the law, and now turning on the license plate reader is not a big shake. But also, I have another question too, and that's related to that. This is the third time I think I've been here where we've gone through this kind of issue, and the second time was first time was when Minneapolis did it and had to, and they violated the Constitution and they had to refund all of that money. The second time was when there was a dispute between the people who were qualified to issue a tag because of the image, and that it was, that we had to have a licensed officer do that. And I think when we talked, that you said that this has been overcome. So has it been overcome that a licensed police officer does not have to issue that tag, even though it does have fines and penalties and records involved in it?
Mr. Foley.
Chair, Senator, so there are specific provisions in this bill that govern the requirements for that trained traffic enforcement agent. And so that agent either has to be a licensed peace officer or they have to be a trained local enforcement agent. And so this bill is outlining the details and procedures around that, and that provides the structure and the legality for the program. And I'll also just clarify, yes, Minneapolis had a program that was overturned by the Supreme Court, but that was not due to constitutionality. It was due to the fact that there wasn't specific statutory authority to allow us to implement the program in the way it was then. This bill is providing statutory authority to do a pilot for local communities so we can see how this works and learn from it locally and see how it compares to the 29 other states that have similar type programs to this.
Senator Howell.
Thank you, Mr. Chair. And I just want to bring up something that we brought up in transportation. We're charging a $40 fine, and from my experience, the fines don't change behavior, especially with those people, that have means. I mean, the folks that can't afford it, it might affect some of their behavior, but for those people that have the money, it's not going to change any behavior. And in the Transportation Committee, we had Chief McCarthy from the chief from Mendota Heights tell us how they run their camera program, and they have a camera program that actually captures the speeders or the people that run the red lights, and they send them a letter saying, hey, we caught you doing this. And after a few times of that, they actually, if it's busy enough, they set an officer out there and then they pinch him. And it goes on their record. It hits their insurance program. and it actually changes behavior. And I would like to see a pilot program going down that road much more than this. I like her approach, because I tell you what, I know what changed my behavior. Sitting 5 days in jail changed my behavior, and I actually started my military career. So if we're going to change behavior, let's catch these folks and actually do something that makes a difference. Let them set a day in jail instead of just being able to pay their fine. It doesn't raise their insurance, doesn't affect their ability to drive. They're not going to pull their license. If you're going to do this, let's do this in a method that's going to change behavior, such as Chief McCarthy from Mendota Heights. I think they've got the right answer, and I'm surprised that after the discussion in transportation, we didn't make an attempt to maybe go down that road.
Senator Westlin.
Thank you, Mr. Chair. And just to Senator Carlson's point, and I'm sure that this has been addressed, but first of all, just to clarify, it is my understanding that the Minneapolis rubric was found unconstitutional, and it was found unconstitutional because it presumed someone was guilty without due process. I think the other issue with the Minneapolis provision was it was a city ordinance that was in conflict with state law, because state law governs traffic violations and so on. So I guess, first of all, I want to say I probably will be supporting the bill. I think the number of people running red lights in particular right now is just shocking and dangerous. I want to make sure, though, that whatever the concerns were with the Minneapolis ordinance, that those are being addressed here, and we won't run into the same constitutional issues and questions. And I do believe that there is a difference between what you're doing here and what happened there. But if you could just briefly, because I know we got other bills to get to here, I could briefly touch on that.
Mr. Foley, 30 seconds,
Sure.
please.
Chair and Senator, I'll just say that, yes, we've worked with our lawyers, some of whom were involved in that case, and with Senate and House counsel to make sure that we have a bill that will be constitutional. And I will also note that the other states that have these, the only one that was ever found unconstitutional had a provision that we don't have in this bill. And so we're learning from those experiences as well.
Any further discussion on this bill right now? Senator Carlson, real briefly, please, unless you want to stay until 7 o'clock tonight.
Oh, I'm okay with that.
I'm not.
No, I'm not.
I'm going to be
No,
in services in about 1 hour,
Yeah,
so whether we're done or not.
A couple of things. I'm going to support this because I think it's a good thing. I'm a little concerned about a test being 4 years, but I don't think you're going to have enough cameras out there, because my view on this is that we need much more enforcement on the construction zones, because one camera in a construction zone isn't going to change much behavior, and we have people that are driving 100 miles an hour through a 60 zone in a construction zone, and we need to get them off the street. So,
Senator
thank you, Mr. Chair.
Verbatim moves that Senate File 2026 as amended be recommended to pass and be referred to the Transportation Committee. And members, I'm just going to suggest if state government wants to see it, they'll let someone know and they'll try to capture it or ask for a re-referral. But the preliminary information we have is that they're not sure that they even need it. Is that okay, Senator Verbatim? Any further discussion? All those in favor say aye.
Aye.
Opposed? Motion prevails. All right, last bill of the evening, members, Senate File 4411. Giving us about 40 minutes, members. So we're going to focus our testimony, please. This is my bill. I'm going to give the chair over to Senator Verbatim.
More work.
have a seat.
Senator Latz, when you're ready.
Thank you, Madam Chair and members. Senate Bill 4411 is a bill that would assist county attorneys in meeting their constitutional duties to disclose impeachable, credibility-related evidence of proposed witnesses in criminal cases to the defense or defendant in those cases. The United States Supreme Court in Brady stated that defendants are entitled to have information that is in the possession of the state that might give them grounds for challenging the credibility of a testifier based upon that individual, in most cases police officers, histories of conduct or improper conduct. There's been a substantial amount of discussion about investigations of alleged misconduct, what happens with the records, how are they characterized, is there discipline that follows, is discipline characterized as coaching instead of discipline, so it becomes private under the Data Practices Act instead of public and disclosable, and does that information get to the prosecuting attorneys who have the duties to make that disclosure under the United States Constitution. The Hennepin County Attorney's Office, which has the highest volume of criminal cases in the state of Minnesota as a prosecuting agency, has found that they have had to bring almost 200 motions in front of judges to try to get the information that they think they need to disclose to the defense. It's created an administrative and procedural bottleneck and tied up resources and has become a substantial procedural burden. So they have made the request that we present the bill that is before you to facilitate the disclosure of this information. With regard to the bill itself, it's pretty straightforward in that regard. It provides for responsible authorities to release personnel data to the prosecuting authority under certain circumstances. It then provides for the prosecuting attorney or the prosecuting attorney to make the judgment calls as to whether or not that information must be disclosed under Brady. So in some regards, this is a simple data bill, but obviously has much broader implications than that. And then it provides immunities from those who are making those disclosures as long as they do so in accordance with Chapter 13 and this proposal. So I know that this has generated a lot of input and concern on the part of a variety of parties. So we wanted to have this hearing so that the issues could be aired in a public proceeding. I do have the A2 amendment, which is delete everything amendment. This is an author's amendment, and I move its adoption.
Senator Latz moves the A2 amendment. It's an author's amendment. All those in favor say aye. Aye.
Aye.
Opposed? Okay. Motion prevails. Amendment's adopted.
Madam Chair, there are some testifiers here I'd like the committee to hear from.
Thank you, Senator Latz. This is our last bill, but we would like to get out of here at a reasonable time. So if you can all try to keep it within 2 minutes, that would be very helpful. I'm sure there might be questions for our testifiers as well, so if we can get through that and then see what questions we have, I think that would work best. And let's start with Claire Deagle. Or whoever wants to start. I just had you look first.
Thank you, Madam Chair. If I could ask that Mr. Berger proceed first.
Sure, Mr. Berger.
Thank you. Madam Chair, members of the committee, my name is Mike Berger. I'm the Chief Public Defender for the 4th Judicial District, which is Hennepin County. I'm here today to put in our support for this bill. In the interest of time and being the end of the day, I think that Senator Latz did an excellent wave-tops view of Brady Giglio and the constitutional obligations. So what I would point out is that in my experience as a public defender, a career public defender, the problem here is the trial delays. And the trial delays for our clients that occur and hold many of our clients in custody and hold individuals with speedy trial demands, an additional constitutional obligation that gets violated as these challenges occur. One thing that I think is worth highlighting, and as the chief public defender in Hennepin County, I think that this can often get framed as a Hennepin-only issue. I will tell you, I've spent 16 years as a public defender, and those were in the 10th Judicial District, the 8 counties across the north part of the metro. This is equally a problem there as well. The delays in trials that come from these challenges are delaying constitutional rights and delaying outcomes for our clients. Practically speaking, this change would allow us to no longer have unknown unknowns. We would be able to see what's before us in these cases. The delays would leave. We would see less continuances. We would see less in-camera reviews on these cases, and justice can be had in these cases.
Thank you. And that was under 2 minutes. Hopefully everyone follows your lead.
You know, I try to be fast.
Next, Hannah Martin.
Thank you, Chair, members. My name is Hannah Martin, and I'm a criminal defense attorney and the legislative chair for the Minnesota Association of Criminal Defense Lawyers, also known as MACDL. I'm here today supporting Senate File 4411. This bill does not alter or change the constitutional right to Brady in any way. It does not place a higher burden on the state, nor does it change what is considered Brady evidence. Instead, this bill expedites the process for prosecutors to get Brady material and in turn gets it to defense attorneys faster. Right now, in order for the state to get non-public, potentially exculpatory material, many agencies are requiring a court order. This can cause significant delays in criminal cases, which is a hardship for the state as well as for our clients. Under this bill, prosecutors would no longer need a court order. They would review the Brady material, or the potentially Brady material, and if it is exculpatory, defense attorneys will sign a protective order which prohibits them from disclosing this material. This is a common practice with other confidential data within the court system. The data will maintain its non-public classification, and defense attorneys are going to be bound by a protective order which provides safeguards for this material. Ultimately, what this bill does is cut down the time it takes for a defendant to get exculpatory material in which they have a constitutional right. Thank you.
You're doing great on time so far. Claire Deagle.
Thank you, Chair. My name is Claire Deagle. I'm the Director of the Division of Professional Standards at the Hennepin County Attorney's Office. In April of 2022, the Minnesota Department of Human Rights issued its investigation into the City of Minneapolis and the Minneapolis Police Department. The Hennepin County Attorney's Office is mentioned in this report in quite an unflattering way. The Minnesota Department of Human Rights stated that Hennepin County and the Minneapolis Police Department had engaged in a systematic failure to produce comprehensive impeachment information. And specifically, this was about police misconduct information. And the department recognized that Hennepin County did not have access to the information that they would be required to disclose under Brady Giglio, under this constitutional requirement that we have. We also had multiple judges across the state, not just in Hennepin County, issuing orders saying that prosecutors needed to be looking at non-public data to ensure compliance with Brady Giglio for police misconduct. And I just want to very briefly say the reason why non-public data may lead to Brady Giglio information is for 2 reasons. First, an agency may find that there was a policy violation based on a complaint. This would be referred to as, in most but not all agencies, as a sustained complaint. But the agency may decide that it doesn't warrant discipline, that instead it should be dealt with by coaching or counseling. And in those circumstances, the information would be non-public, even though there was a policy violation found that could implicate Brady Giglio. The second circumstance is when a chief has decided to impose discipline, but the grievance process hasn't yet lapsed. That information then is still not public, even though, again, the department has knowledge that a policy violation has been found that could implicate Brady Giglio. This happened most recently in another county in 2019, or I shouldn't say most recently, but ended up almost tanking a really important criminal case because of that exact issue. So I just want to emphasize why our prosecutorial obligation to disclose Brady information applies to non-public data. So trial delays have been mentioned.
If you can wrap up quickly.
Yes, absolutely. I want to just quickly talk about trial delays. So we, of course, have massive caseloads in Hennepin County. There's 74 cases set for trial next week, 74 criminal cases. There are 494 officers that have been subpoenaed. We do not need to see court orders for every single one of those officers at this time, but in the last 6 weeks, we have filed, as Chair Latz said, almost 200 motions. This has led to at least 18 delays, which directly impact public safety. And it's also really unfair to our victims who are coming to court to testify about one of the most horrific events in their life. They're showing up and being told that they will not have a resolution and that they have to come back. The trial delays are also very difficult for our prosecutors and for our law enforcement partners who are subpoenaed as well to testify in trial. I also want to recognize that, and I'm sorry I didn't recognize that before. We have a number of police chiefs here today. I understand there might be some disagreements with the bill, but I want to emphasize how much we value their partnership in prosecuting the cases and how this issue is not because of any decision by the agencies or any lax action by the courts or any problems with our office's process. This is a problem with a state law, the Minnesota Government Data Practices Act, and this body can fix that. Thank you.
Thank you, Ms. Deagle. We have 3 other folks that are signed up to testify, so if you all want to come forward, Chief Jay Henthorn, Mark Schneider, and Devin Bruce.
What bill are we on?
Thanks, Cliff. Yeah, it's
We just finished it.
Chief Henthorn?
I'm Chief Eric Warner.
Okay. I had some other folks signed up to testify, but if you're taking their place, if you want to just state your name and affiliation and begin your testimony.
If I could just ask for a little grace ahead of time, I'm actually here representing a couple of those testifiers, so if I could have about 4 or 5 minutes, that would be great, but I will try and make it brief. My name is Eric Warner. I'm the Chief of Police for the City of Maple Grove, and I'm the current past president of the Minnesota Chiefs of Police Association. I also represent the state of Minnesota at the International Association of Chiefs of Police. The information presented today is informed by input and discussion with chiefs and attorneys from across the country and discussion with Minnesota County attorneys outside of Hennepin County. The members of the Minnesota Chiefs of Police Association, the Sheriff's Association, and the MPPOA want to make it clear that we are committed to fulfilling the affirmative duty to notify their prosecutors of any exculpatory material. On behalf of the 300 police chiefs, the Sheriff's Association, and the MPPOA, I'm here to state that we do not support the bill before committee today. The language proposes to alter the Minnesota Government Data Practices Act in a number of concerning ways. It provides no limitation on the type of complaint data that may be relevant to disclosure. The bill provides no requirement to establish and maintain any type of security protocols or limitations on who would have access to the data or how the data would be managed. There needs to be uniformity and clarity of protective orders issued by the courts, and we believe that the court shall issue, not may issue, these orders. There's no uniform standard across the state on Brady material, and there's no due process for officers being placed on a Brady list. In our conversation with the Post Board, they have concerns about the data that they would be required to disclose. Overall, the bill does not cover the broader issues of a well-developed and transparent Brady Giglio process that provides confidence and legitimacy for all participants in the criminal justice process and the public, as other states have. The states of Colorado and Iowa have passed bills that cover many of these broader issues, and we would like to look at those laws. Lastly, this bill is also supported by the Hennepin County Attorney's Office, as you heard, but as a solution to the problems with their flawed Brady Giglio policy that was originally focused on the Minneapolis Police Department and now being thrust upon county attorneys statewide through this bill. In a recent in-camera review of a police officer's discipline file, a Hennepin County judge ruled, the review reveals nothing that is either or could reasonably lead to admissible evidence in that case. Or as I heard the judge say, this is not even close. We would be interested in what an in-camera opinion of these 200 orders that the Hennepin County Attorney's Office chose to secure, and see what judicial review of those files would look like. Most importantly, the judge continued, the process by the Hennepin County Attorney is time-consuming and poses logistical challenges, and from an outsider's view, the process appears to be in shambles. We believe that we're aware of the Human Rights Report that was focused on the actions primarily of the Minneapolis Police Department. The Minnesota Chiefs, along with our partners in the criminal justice system across the state, support defendants in criminal cases receiving constitutionally required disclosure of information when witnesses against them have demonstrated records of untruthfulness, bias, or a lack of credibility. The Chiefs of Police Association, the Sheriff's Association, the MPPOA, and all the chiefs in Hennepin County respectfully request a no vote on Senate File 4411, and for the committee to support the other legislative proposals to create a task force to develop a uniform statewide Brady procedure as other states have. We know many county attorneys, the Minnesota County Attorneys Association, other criminal justice partners also support that approach. And I want to thank you for giving me time to speak today, and I hope I didn't take too much of your time.
You made good time. Thank you, Chief. Devin Bruce.
Thank you, Madam Chair and members. For the record, my name is Devin Bruce. I'm the Legislative Director for the Minnesota Association of Professional Employees, a union representing over 17,000 state professionals and all boards, agencies, and commissions. Just to be very brief, because we are very, very short on time, we've raised a number of concerns about the scope of the underlying bill, and even a little bit with some of the scope of how law enforcement agencies are determined under the statutes. We're currently working with our partners at Hennepin County Attorney's Office to try and address some of those concerns, as well as some in the immunity from civil or criminal liability for public employers for disclosing data that are currently not, that was done intentionally or to damage the reputation of said employee. If there's any disclosure that was not intentional by the employer, the employee would have no recourse under this law. So we are currently working on language with them, and we appreciate your time.
Thank you so much. Members, questions? Senator Kroon.
Thank you, Madam Chair. My question would be for, sorry, Ms. Deagle,
Like legal, Deagle.
almost at it.
That's good.
So I wrote down, and if I got it wrong, please correct me, but you said Hennepin County and Minneapolis police were found to have engaged in a pattern of discrimination, race-based policing in the Department of Human Rights investigation report. And I'm pulling it up here, and I went through it, put in keywords, and I'm not finding anywhere where it says county. It's all direct. Everything I'm looking at says Minneapolis Police Department or the city of Minneapolis. And in the conclusion, so can you help me find where Hennepin County, where that finding was made against Hennepin County?
Ms. Deagle.
Thank you, Chairwoman Verbatim. Yes, it's on page 65 of the report. And Senator, I also have an excerpt for you printed out, if you would like to just look at it more directly. So the critique specifically that I was referring to was the failure to produce comprehensive impeachment information. And so even though Hennepin County and the Minneapolis Police Department are named here, the problem that county attorneys do not have access to specific police misconduct data that might be non-public is an issue that exists across the state. So our obligation would not be different than an obligation of another county attorney. It's possible that in some counties, It's possible that in some counties, the way the agencies handle complaints or process complaints does not mean that there are sustained findings of misconduct that are non-public. That's the choice of the agency. So it is specific there to Hennepin County and Minneapolis, but the issue that it is noting that county attorneys don't have access to possible Brady Giglio police misconduct information that is in the hands of the department is not specific to either Hennepin County or Minneapolis.
Senator Kroon.
Thank you, Madam Chair. I've been looking at page 65, and it says the city and the county are aware that individuals charged with the most serious crimes may have been denied access to this information. There's a few other places, but the specific, I'm not seeing the specific finding of engaging. And maybe this isn't worth going down the road. I still don't see where it says that on page 65, but.
So on page 65, I think it's the.
Ms. Deagle.
Pardon me, Madam Chair. Pardon me.
Senator Kroon, would you like Ms. Deagle to weigh in, or
Yeah, sure.
Ms. Deagle?
Thank you, my apologies, Chair. So the part I was referring to is the language about a systematic failure, which I think is the beginning of the third or fourth paragraph on page 65. So it says the systematic failure to produce comprehensive impeachment information may exist for several reasons. And so
Senator
that's.
Kroon.
Thank you, Madam Chair. Okay, I see what it says. I still don't think that that's what you originally said, where Hennepin County was found to have engaged in a pattern of discrimination, race-based policing. I don't want to mince words here, but my next question is, so the Hennepin County Attorney's Office obviously supports this bill, but what about the rest of the counties? I don't know if Mr. Smalls wants to chime in. What about the County Attorneys Association? Where do the rest of the county attorneys stand on this?
Thanks for the question, Senator Kroon. While Mr. Smalls is coming forward, if you had any response to some of other Senator Kroon's questions, Senator Latz or Ms. Deagle, feel free.
Just very briefly.
Ms. Deagle.
Thank you. Just very briefly, if my point was specifically meant to be made about the systematic failure to disclose impeachment information, not that the county was found to be complicit in discriminatory policing.
Mr. Smalls.
Thank you very much, Madam Chair. Senator Latz, my name is Robert Small. I'm the Executive Director for the Minnesota County Attorneys Association. Senator, I'd like to answer your question as best I can. When this matter came before our association, it came along with a number of other bills. The responsibilities of prosecutors to meet their constitutional obligations is of significant concern to every prosecutor in Minnesota and throughout the United States. It is an utmost importance, and it's a high priority. So when these three bills, or a number of bills, came before our association did not take a position on the bill, but saw these various proposals and said, you know, at its core, Brady Giglio constitutional obligations are prosecution obligations. They're prosecution obligations. And prosecutors, we ought to get together and determine a statewide policy and a statewide process to make sure that all county attorneys are doing it the same way. And so, to briefly answer your question, we have not taken a position on the bill. We do have information privacy subcommittee of our organization. They looked at this particular bill, made some technical suggestions. I just received, I didn't know this amendment wasn't posted. I just saw it. So I don't know if they took the technical advice that we gave them on this particular bill. I hope that answers your question, Senator.
Senator Kroon.
Thank you, Madam Chair. So if I'm understanding your response, the County Attorneys Association agrees there should be some uniform policy on how this is handled. But what about this specific bill. There's just no position on whether this achieves that.
Well, we incorporated this bill, Senator.
Mr. Small, sorry.
I am so sorry.
I didn't catch it myself.
Madam Chair, Senator, we took that bill, that's one of the many bills, and our work group is looking at it. We just had our second meeting today. And so we don't have a position on the bill. We're looking at it, trying to incorporate that into the statewide process and procedure.
Senator Kroon.
Thank you, Madam Chair. Well, I mean, this is, Hennepin County is obviously for this, but this is going to have statewide impact. To me, I would certainly feel better about this if the County Attorneys Association was involved and supported it, and rather than just one particular office. And it sounds like that process is underway to come up with something, and maybe there could be more broad agreement. I don't know how that process is going to play out, but I would be concerned about moving forward on something of this magnitude simply with only one county supporting it.
Senator Latz.
Madam Chair, county attorneys are the prosecuting authority, but they can't do their job if they can't see the information they're supposed to evaluate to determine if it is constitutionally disclosable or not. So to me, it's a pretty simple question. It's the county attorneys that should be making the constitutional decision about what is disclosed, not the law enforcement agencies, the police departments, the sheriff's departments making that decision. If the county attorneys have to go through motions every time they've got a criminal case to get a judge to order a law enforcement agency to give the county attorney the information they need to make those decisions, that's a burden on the constitutional obligations, in addition to creating the burdens about potentially delays of trial and the additional resource expenditures that should be unnecessary. So to me, our law enforcement testifiers said they supported disclosure of witness demonstrated records of untruthfulness. But who's making that decision? County attorneys won't even be able to see what records there are unless they can see the data that is now listed as not public. And right now, they have to get a court order to see it. So to me, it's a pretty straightforward question. Now, what standards a county attorney applies, different county attorneys apply different standards in what cases they're going to prosecute, what cases they're going to think meet certain constitutional obligations or don't. That'll play out within individual counties and within the courts in those counties. Some different judges take different approaches to those things too. But for right now, we've got a pretty substantial burden in the highest volume county attorney's office in the state. We have it in our power, as was already said, to relieve that burden. Ultimately, does the county attorney decide they got to disclose something under Brady? I guess they'll make the decision, and each case will take its own path as it does.
Thank you, Senator Latz. I think Ms. Deagle wanted to comment as well.
Thank you, Chair. Just briefly, to answer Mr. Small's question, we did incorporate the MCA feedback in the A2 amendment, and we did circulate a memo with that modified language to the MCA. So I understand that Mr. Smalls hadn't been able to take a look at it yet, so just wanted to emphasize that. And specifically, one of the changes that they'd advocated that we had incorporated, and that is incorporated in the A2 amendment authored by Chair Latz, is that the language personnel data in subdivision 20 There is now narrowing language as personnel data related to a complaint or charge against an individual. So then it's more specific to potential misconduct information, which hopefully then would alleviate, I know not all of the concerns that chiefs had, but at least the concerns about what personnel data would fall under this amendment.
Madam Chair,
Senator Latz.
I would add one other limiting factor to that here. If you look at lines 1.31 and 3.2, it's not every employee of a law enforcement agency. It's only the individuals employed by a law enforcement agency who are or may be a witness in a criminal prosecution. So it's pretty narrowly focused only on the evidence that might be involved in a criminal prosecution, not every employee.
Senator Wilmer.
Thank you, Madam Chair. I'm still trying to determine how law enforcement is complying with this now. Are they refusing to comply? Are they doing something that, well, what's the problem we're trying to cure, I guess? And I'd like to ask one of our police chiefs to come up to the table and ask that question and hear from them.
Go ahead, Chief.
Madam Chair, Senator Limmer, I think some historic context here would help with your question. First of all, the Hennepin County Chiefs of Police Association, all of its members, had a what we believe was a robust process in the suburbs, where we went back and reviewed all of our historic data, sat down with what we called a Brady committee. So you would have your local prosecutor, the Hennepin County Attorney's Office, the police chief, and we would sit down and go through all the data, and they would know what we had and didn't have. So essentially we got caught up, and then every year someone from the Hennepin County Attorney's Office would come out, and we would do that same process. In between that, there was a requirement by the police chief with those standards that if we felt we had something of urgency, we were to call the Hennepin County Attorney's Office. So the process was in place where there isn't a lag. So this data stacking up and no one has access to it. And we thought that was a very good process because we had the attorneys in our office with our attorneys, and we were at the table together. There was a change, obviously, with the election and a change in policy. And we proactively, many of us chiefs asked to give information, and no one came out to our PDs. And then we got this policy, and then all of a sudden we start getting these orders. And then there's a disagreement of what is Brady, and that's what's concerning of why we would like to get it in front of a judge. Also, in reaching out to other county attorneys, we wanted to get their perspective on this. I sit on the Anoka Hennepin Drug and Violent Crime Task Force. The Anoka County Attorney is on that task force that understands this issue, and we communicate between Hennepin and Anoka because of our relationship. Anoka County Attorney is not in support of this, and he said I could say that today. I just asked the committee again. I have page 64 and 65 that was presented here. This is the Human Rights Report. This is very clearly focusing on the city of Minneapolis and the problems that are here. And that's why my second testimony is here. We are doing a good job. Minneapolis has its issues, and I believe those issues need to be worked on. But if we're going to make a monumental change that we're asking this body today, I believe that we need to have some type of task force together like Denver or Colorado did, where you had representation from the chiefs, from the judiciary, I'm sorry, from the county attorneys, from the defense. What are the issues? And let's get a process that we can all wrap our minds around. And I think the public would expect that as well. So thank you.
Ms. Deagle.
Thank you, Chair. And I know, Senator, you directed the question, Chief Werner, but I do have some additional information to provide. So the prior process that Chief Werner described was specific to public information. So the Hennepin County Attorney's Office policy with respect to Brady Giglio was only about public information, which means public disciplinary files. It did not apply to that non-public information. And in fact, the agencies, by their city attorney's advice, have been told that you cannot just provide non-public information to the Hennepin County Attorney's Office, that they need to get a court order. So that's why we've instituted this process. But the shift from public information to having to review non-public information, again, came from the Minnesota Department of Human Rights, which identified an access issue. It wasn't specific to Minneapolis and Hennepin, but this access issue, and then multiple court orders from judges saying, you prosecutors need to be reviewing non-public data. So there was impetus from the courts, from the Minnesota Department of Human Rights, and from courts across the state that we need to be reviewing this information. So that was the reason for the change. I also want to emphasize, in response to your question, Senator Limmer, that it is not that the agencies are not complying. The agencies cannot provide us the information. In Hennepin County, the agencies cannot provide us the information without a court order. So we are getting court orders, and for the most part, with the exception of 2 judges, the other 15 judges are allowing that information to be produced to us for disclosure. So it is the prosecutors that are reviewing the information. It is not the courts. So with respect to Chief Werner's request that the court should be reviewing this, they are not reviewing it. In fact, when we did ask one judge for in-camera review, the response was that's the prosecutor's job, that's not the court's job. So this really, and I will also note that Ramsey County, which is supportive of this bill, their law enforcement agencies will accept subpoenas for this non-public data. So they do not have this court order issue that we do because their agency's view of the law, and Brady, it's my understanding after looking at their policy, that they would accept a subpoena for that information. So this really isn't a monumental change because we are getting access to the data that we need to get access to comply with Brady Giglio. All this is doing is taking out that step of seeking a court order. So we are not removing in-camera review on a massive scale from the courts, and we are not also changing any policy that other county attorneys may have to do. We're just making it easier. And we also are supportive of working with law enforcement on efforts to create some sort of statewide standard for Brady. That does not affect this bill, because that's not what this bill is trying to do. Thank you.
Senator Kroon.
Thank you, Madam Chair. I mean, I'm trying to piece all this together. I'm not a criminal law attorney. I'm not an expert in this area, but it just seems like there's a real lack of trust and a lack of cooperation in Hennepin County. That's what I'm hearing, specifically with the problem stemmed from the Minneapolis Police Department. And I know there are constitutional obligations, and I certainly would want to make sure that those are being fulfilled. It's, from what I'm hearing, it sounds like there are multiple processes that could fulfill those constitutional obligations. If the Anoka County Attorney's Office is against this bill, I know him, and he's very capable. I'm sure he's very committed to constitutional principles. And so it seems like that there could be other ways to do it, which is why I would be more comfortable, again, to have a broader support from the County Attorneys Association, even if you believe that the ultimate decision on whether they turn something over is their constitutional obligation. That could be true. It's just, I would feel comfortable if there was broader support. And, there was, what happens to this non-public data that gets turned over to the county attorney's office that ultimately isn't produced as part of the court? I might not be saying the terminology right, but what are the processes and procedures on that? There was some concerns about due process. I don't know if you have any thoughts on that, but I'm just throwing it out there because I'm not sure I quite have that concern wrapped around my head. And maybe one of the police officers can elaborate on the due process concern that was mentioned earlier, but I want to understand that part better.
I see Chief Werner coming forward. Go ahead. And then I also saw that Mr. Berger came back as well, so I'll go to you next, but go ahead, Chief.
You're all over the map. I'm consistent here.
Madam Chair, Senator, well, in the example that was given, and as other states have in law, when there's material that a county attorney thinks should be designated as Brady material that could be used or introduced in a court, there's an opportunity or due process for that officer to challenge that in front of a judge, versus a county attorney just to say, this is what the standard is, and then it gets released. So the information's out. And we have to be clear where that information goes. And I don't want to get too deep into it, but in one of my cases, the order said the defense only had to destroy paper copies. They didn't have to destroy electronic copies. So now all this information and data is out and it's flowing around, and here's an officer with no due process. And in this particular case that I gave an example, the Hennepin County Attorney said, with no notice to the police department until 3 days before a court, that there's potential Brady in this, but then a new order on that same file came out and said that I have to, as the chief, notify the officer. So the process is changing and it's in flux. And what we're debating here is we're saying just give more information and we'll just figure out the rest of the process. And the officer, what he did is he went to court with his representation, and that's when the judge made the determination to say it's not even close to being Brady material. And so when we're talking about due process, let's have due process for everybody that this issue affects. Of course it affects defendants. Of course it affects victims. It also affects officers. And to leave that sole discretion, if there's up to a prosecutor, yes, it is their discretion. But when we've seen the Brady designation in this county be expanded to virtually every policy violation, and that's what we're hearing from our membership at the Hennepin County Chiefs of Police Association. It's a policy violation, it's Brady, and we would like to see some due process for someone else to decide that before that material gets put out into the I guess, interested parties.
Mr. Berger?
Thank you, Madam Chair. I think there's some things worth putting in context here, and some of it's related to the due process thing. And I will point out, Chief Warner and I are on the CCJC in Hennepin County together. I've had the opportunity to work with him. I have immense amount of respect for what he does, but we have some fundamental disagreements. And what I can say is that I took over as the Chief Public Defender in Hennepin County in June. Prior to that, I was the managing attorney for the felony team in Anoka County. Anoka County's process is, in my opinion, immensely flawed. They are not dealing with the non-public data, which is directly what this relates to. This is a practice that exists throughout the 10th district, which is why I stated in my previous testimony, this is a statewide issue. The non-public data is what is the things that defense attorneys need to put forth a viable defense. It's what they need to use for impeachment purposes. It's what we need to use that is relevant to credibility of witnesses. And I want to be clear, Brady is not just law enforcement. It's all professional witnesses. It's all lay witnesses. This is not exclusive to law enforcement. This applies to witnesses that exist in the case. Now, I understand how this is working with the Data Privacy Act with law enforcement, and that was what needs to be zeroed in on here, because there's other protections that exist for other groups, and that's not what we're addressing here today. But what I can say is that we are asking for information that is constitutionally pertinent. And when defense stands up and is told, you have presenting a case, presenting your bill, arguing something for you, someone else is telling you what's relevant and not relevant to your case. This is a gatekeeper that does not allow defense counsel to see and make determinations for their clients what is pertinent. Now, that doesn't mean everything we receive goes before the court, that everything we receive goes into the public record. That due process is not about that officer. That due process is about the individual, where the full force of the state is trying to imprison them. That is the person that is the focus of these cases. I understand law enforcement sacrifices. I understand what they are doing. But the conduct and the approach that they have to these cases is relevant to the defendant's case that goes forward, needs to be known by defense counsel, needs to be argued before the court, and the judge can make the determination then. But what I referenced earlier is the operational environment that our office has right now is unknown unknowns. We don't even know what we're missing because we have intervening factors up to us receiving information about what's relevant in our case. I can't even tell you what I'm missing because I don't know what it is. And what I can tell you is the Great Northern Innocence Project put forth a letter of support in this. And that statistic in there is 77% of cases that are overturned for failure to disclose information is related to Brady. And that is because defense counsel had unknown unknowns. I couldn't even tell you what I'm missing.
Senator Sieber.
Thank you, Madam Chair. And thank you, Senator Latz, for the conversations that you and I have had over this bill. And as I've indicated before, I can't support this bill for a number of reasons. I've heard on a high level here, I see there's not agreement. There's a dispute. There's a significant dispute between parties with regard to what this bill does, what's necessary for this bill, how it impacts counties, what counties are affected. I spoke with my own county attorney about this bill, and I can tell you that in my district and where I live, I have a vastly different relationship, and my residents have a vastly different relationship with law enforcement than they do in Hennepin County and the city of Minneapolis. And I am very reluctant to vote on state legislation to solve a problem that exists only in Hennepin County, and I won't do it. If there's problems with regard to how Brady material is accessed in Hennepin County, then that's a problem for Hennepin County to solve. It's not our job as state legislators to change the entire law of the whole state just to fix one county's problem. There's been a suggestion for the counties to get together and develop some uniform standards with regard to what Brady is. Perhaps that's a good starting point, but given the level of dispute here, given the inability and failure of all the parties to be in agreement with regard to the proper procedure here, and because I don't think it's my job to enact state law to solve one city's problem, one county's problem, I can't support this bill.
Okay, I'm not seeing any further questions or comments, so Senator Latz, how would you like to proceed?
Madam Chair, I'd like to move that Senate File 4411 be recommended to pass, and that I'm not sure if it has to be seen by another committee or not, wherever it needs to go from here.
Senator Latz, it would go to the floor.
We refer to the Senate floor.
Okay.
Roll call,
As amended.
Madam Chair.
Roll call requested, roll call granted. Okay, Senator Latz, we have just learned that there is a fiscal implication. So the correct motion would be to send this to finance. So Senator Latz moves that Senate File 4411 as amended be recommended to pass and referred to the Senate Finance Committee.
I renew the roll call, Madam Chair.
Yes, and there's a roll call. Clerk will take the roll.
Chair Latz?
Yes.
Senator Umu Verbaeten?
Yes.
Senator Limmer?
No.
Senator Carlson?
Yes.
Senator Eichhorn?
Eichhorn votes no.
Senator Howe? Senator Kroon?
No.
Senator Pappas,
Yes.
Senator Seeberger,
No.
Senator Westlin,
No.
Senator Howe,
All right, there being 5 in support, 3 against, the motion prevails and it is adopted. Oh, sorry. There being 5 against, 3 for the bill, the motion does not prevail and is not adopted.
How do you get 3?
There's 2 of him now.
Okay.
I didn't count that. So 1, 2, 3, 4.
Thank you, Senator.
Thank you. Thank you. I counted it different. I thought there were 4 in favor, but still. I thought it was 4-4.
Okay.
Can I get a clarification, Madam
We're getting
Chair?
the numbers correct.
Okay.
All right, there are 4 in favor, 5 against. Therefore, the motion is not adopted.
Thank you, members. You bet. Sure.
How did it go? Bill passed?
Okay. Okay, that concludes our agenda, and the committee is adjourned.
Sent a message.